We'll call to order the City Commission meeting of the City of St. Pete Beach. Today is Tuesday, December 25th, 2023 at 5 p.m.
December 5th, not 25th.
December 5th.
Merry Christmas.
All right, it is Tuesday, December 5th, 2023 at 5 p.m.
See how long they stay laughing. See if we can keep them laughing all night.
We're good to go. All right, let's stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. City Clerk, if you'll please do a roll call.
Vice Mayor Grill.
Here.
Commissioner Frislowski.
Here.
Commissioner Marone.
Here.
Commissioner Grouse.
Here.
Mayor Petrilla.
Here.
We have a quorum.
Thank you. Okay, do we have any amendments to the agenda as presented?
None from me.
No. There has been, I would ask that we add a discussion item prior to the audience comments. There's a question that's come up in the last week or so, whether we should even be here tonight, whether the applicant has a completed application. And so I think it's important that we cover that item and then move forward one way or the other.
Can we do that in the form of an attorney report on the procedural aspects of the app? How do you, I just wondered how you want to.
I think we just add as a discussion item, we present the information and then we.
Or we're going to have audience comments on the discussion item. That's wondering if we want to do it as a report from the city on the procedural aspects of the application and whether or not it meets the requirements to even be here tonight. And then we can discuss. I'm just thinking out loud about audience comments and how we want to handle that.
Any other?
I'm not sure I follow who would be presenting from, on the procedural aspects. We did receive correspondence from.
Yeah, you know, I mean, you can, the commissioner's right, if you put it on the agenda as a separate discussion item, you may have to take public comments on it, and then you have public comments on your quasi-judicial item. So if you wanted, the other way could be to open the main item, which is the conditional use permit, and immediately address procedural issues.
So here's my thought.
Yep.
And again, I'm just thinking out loud.
Sure.
If obviously procedural comes before substantive, and we have a concern about the procedural issues, can we have Brandon Berry or someone from the staff who can answer the commission questions about procedural issues, and then we can have a discussion about whether or not we think it meets the threshold to move forward?
I mean, we can certainly do that.
I mean, what's everyone else's comfort level with that following that procedure? I just think it's the only way we can get there without having, if we can open up audience comments, but we're going to be doing double duty here tonight.
Right.
And forgive me if I'm being slow, who from the city is presenting procedural issues? Because if the city thought we had procedural issues, we wouldn't be sitting here.
I can address procedural issues, and if we need staff to comment on any of those and participate on it, I can lead the discussion, and if we need staff to help, we can do that.
Okay, so we can add that as the first item,
Agenda item.
and then any audience comments, and then item 3 and so on.
So I would recommend you not take agenda, like audience comments on that particular issue.
No, I'm saying it's in the agenda.
Okay.
Regular audience comments.
Sorry. I got it.
we can do it as an agenda item, then we'll have a discussion, because I think it's only appropriate that we discuss and make a decision about whether this is something that should be going forward.
Yep. Okay. We have a motion to,
So that would be a one, or a,
it would be 1B.
You're no power?
okay. Then audience comments, then the resolution. Okay. And Jay, did you ask for a motion?
Yes.
So moved.
Do we have a second?
I second.
City Clerk, if you'll please do a roll call.
Commissioner Frislowski,
Yes.
Commissioner Marone,
Yes.
Commissioner Grouse,
Yes.
Vice Mayor Grill,
Yes.
Mayor Petrilla,
Yes.
motion carries.
So there is, I guess the question before us is whether the procedures and all the steps were taken in the process of getting to tonight with the application. There were some procedural questions stemming from the community meeting, and then there was some procedural questions stemming from the addition to the pool amenity, to the amendment to the conditional use application for that feature.
So I got an email that I think was shared with the rest of the commission from a planning board member who sat on the planning board for the presentation and the planning board's recommendation, who in part of that email referenced a April 13th meeting that he claims was not properly noticed. So is that something that we can have addressed?
So I think there were a couple different procedural items. So there was the original April 13th meeting, which was improperly noticed, which the city clerk notified the applicant, so that they could, and that's why there was a second community meeting a week later. Let me go back to my, that was one thing. Then there was a question of, one of the requirements is for a completed application at the community meeting, that the applicant collect and present within 3 days comment cards from participants to the city clerk. The initial letter from the applicant stated they did not have any comment cards. That's all part of today's package. And then there's a second letter from the applicant dated July 16th, I believe, where they presented 64 audience comments cards about 3 months after when they were originally required to present those to the city clerk. So that would have been a requirement of the application. And then the next part is there's a change, there's an amendment to their original conditional use application to add a pool amenity. The pool amenity, according to the applicant's attorney, based on her testimony at the planning board, that feature would have required a conditional use application in and on its own. And so then the Land Development Code has procedures in place that would say, well, if you are amending your application, then it has to go back to the review process. Since that pool feature was not presented at any of the community meetings, never mind the one that actually counted, so it would actually have to go through the entire process from the beginning, including a community meeting, at which point the residents would be able to provide comments, which then could go to the city clerk, which then would go to the staff, so the staff can use those comments in consideration for the conditional use application for the conditions of that application. And it seems that none of those steps were followed. In my conversation with the city manager, he indicated that he requested of the applicant on at least 2 occasions that they provide some kind of documentation that was done. So far, we haven't received anything. So because of, I think that's the short of it, but it seems that all the steps were not followed in order for us to be here for the application. So not just with the audience comments cards, but also with the conditional use application amendment with the pool feature.
So my question would be, with regard to the audience comments cards, and I'll ask the city, I'll ask the city attorney, is that fatal to the application?
I believe that I've already opined in an email to you all, because this came up as an issue. I didn't see that as a fatal flaw in the process. So I've opined on that already. It was brought to my attention several weeks ago, and you all got my email on that.
Okay. And and one of the reasons I got your email, I just want,
I know.
yeah, I'd like the residents to know.
I get it.
Would you consider that a due process issue?
You know, I think, let me try to, this is a conversation that the city manager and I have had. I've had it with the assistant city attorney, and also with with Brandon Barry, the planner for the city, about the community, about the requirements for a community meeting. And I think we need to understand this a little bit better. You know, there's two places where the community meeting is referenced. One is in the comprehensive plan, and one is in the land development code. And in the comprehensive plan, under the community redevelopment area, the language is practically the same. It says a minimum of one community meeting shall be held at least 30 days prior to submitting an application for administrative approval of a development or redevelopment site plan proposed, et cetera, et cetera. And then it goes on in the LDC to say the same thing. And so my question to Brandon staff, you know, is like, okay, well, this is a CUP, it's not an administrative site plan approval. You know, how did this come about that we're having two community meetings? And then, so understand that if all that an applicant is getting is a site plan, an administrative site plan approval, it's almost void to the community. So when the comp plan was changed, and I believe it was when you and I were together and we had that lawsuit in 2015, that was added in to give some public participation into development that may be occurring in the community redevelopment district that the community wouldn't know about because it would be administrative. And so then I was like, okay, well, how did this get attached to a conditional use? Well, okay, logically, after you have a conditional use hearing, the next step is to go to site plan approval, okay? So in talking with Brandon, and Brandon, maybe you should come up and just confirm some of this. So we talked about this, and I said, why would we be having a community meeting for a conditional use permit? Because it's not required in the conditional use process. It's not in that section of the conditional use process. It's required in a different section, Division 39. And it seems like a moot issue to, after the CUP process is done, which is very public, it's, you know, 2 hearings or more, and then assuming something is approved, it then goes to the administrative site plan approval process, and it would really be a moot issue almost to have the community meeting at that time. So from what I'm understanding is that as a policy decision several years ago, the city decided that let's go ahead, and since we know that eventually this is going to be a site plan approval after it goes through the CUP process, let's get the community meetings done, because they can have it as long as it's 30 days. It's not 30 days before it's got to be 30 days or more before they apply for their site plan approval. So I want everyone to understand that they're actually different issues. One is for site plan approval, but they're just doing the community meetings ahead of time, which makes sense because then there's more public input that can happen, and the code even contemplates simultaneous applications. I mean, Brandon, can you just confirm that I'm on track here?
I agree with all that.
Yeah. So my review of what's being said is that essentially, like, if if you're deemed to have a complete application, so you come in, let's talk about CUPs now, and you say you want a conditional use. Those are not as of right. Those are, you have to meet conditions, and you file your application, and eventually, if you file everything that's required, the planning department or the city issues some kind of written statement that says you have a complete application. Is that correct?
Yes.
Yeah. And so at that point, then it goes through the review process, okay? And it's very standard, especially for larger projects, not, you know, maybe a parking lot or something like that, but a larger project like this, for things to change and staff to request additional information. And it eventually goes to TRC, but then they may even ask for additional information. So I think for me anyway, my estimate of it is that the review process is, you know, once they filed that application and they've been deemed to have a complete application, as long as they're responding to staff and they're supplying information to staff upon request, which is normal, you know, like as staff starts looking through, you know, the various documents, they're going to say, okay, this, you know, can you give us more information about that? And they have a right to ask for more information. So that's a very normal process. I don't see, so for example, the updated traffic study, right, was at the request of the city. Am I correct about that?
Correct.
And I think what was asked was to add Saturday traffic counts in, right? Is that
Yes.
correct, Brendan?
Yes.
Okay, so that was something that the staff had asked, that we want more information. I don't see that as triggering the need to go all the way back to a community meeting. I don't see how that does that. Okay. Now, the issue about the pool, let's talk about the pool. So the pool itself, and correct me if I'm wrong, it's not the pool that's triggering the conditional use, it's the dining and drinking outdoors that's triggering the conditional use. Am I right?
The activity.
The activity, the use of that pool area. Am I right?
Correct, particularly it being on the rooftop is what triggers the dining and drinking to require this.
Right, okay. So I think that is a change. That's an additional request. That's adding on to your request for conditional use. So I think that they did go, I mean, it's not a question of whether they disclose the pool necessarily, because they're, as of right, they can have that pool there. Am I right?
Correct.
Okay, all right, you will
No,
say.
I think the issue is this. You go through the process, then you add another conditional use application and marry it to the original app. Can you marry it to the original app and piggyback on all of the procedural aspects of the cup all the way up to marrying it with this new cup? Because it is a separate cup number, right?
It's under the same request
It's under
number.
the same request number.
Yes.
But it's a separate cup application that was
It's
integrated into this.
it's an amended application of the one that was originally submitted for the hotel
Because if
development.
the hotel was finished, they could come back and make an application for the dining, drinking
They could, correct.
on the
Right.
roof as a separate conditional use.
So
Correct.
they did amend that application, and it went back through the review process, correct?
It did.
So they said, okay, we're amending it, we're adding this, we're going back through the review process. Now, mind you, I don't believe that the community, that triggers going back to a community meeting, because we're talking about a conditional use application, okay? Now, they also went to TRC, correct? On
Correct.
that issue?
Yes.
Okay, so that's the review process.
Is there a difference in general, not specifically on this, on other CUPs, we will sometimes negotiate in this room with an applicant on a condition. and we'll come to agreement, and we'll ask the applicant, do you agree, do you not agree? Is there something different here with this one that raises the point, or?
I think the question is whether they followed all the steps as outlined in the Land Development Code, if there's an amendment to the conditional use application.
Yeah.
And I think this is going to sound like a ridiculous proposition, right? But if they had come in with a CUP for a pool with drinking and food, and then 6 months later they said, we also want to have a building. If they amended that original conditional use application because they also wanted to have a building in reverse of what they're doing now, would it be the same answer? Because that's what's happening here, is we have something that on itself would have triggered a conditional use application.
Mm-hmm.
And so if we're going to be consistent, I think one of the things that we do here is, we administer, the city's ordinances, and we try to be impartial, we try to be fair, we try to be consistent. And if we're consistent every time that we have a conditional use application, that the first thing that we require the applicant to do is hold a community meeting, then why would we change the procedure in this case? So if you have an amendment that in itself would have required a conditional use, my concern is, are we then disenfranchising the residents? Because the purpose of the community meeting, according to what the Land Development Code says, is for the applicant to take those comments, right, to bring those to the city clerk, for the city clerk to be able to bring those to the staff, and for the staff to be able to consider those comments as part of any conditions that they may want to request, right? So at TRC, at the planning board, at the city commission meeting. And in this situation, my concern is, and you did a really good job last commission meeting explaining the importance of due process. And my question is, are we depriving the residents of due process because the only opportunity they have to present comments to be considered for conditions is at that community meeting? There's no opportunity for them to present any comments at TRC. They can present comments at the planning board, but that's already 2-3 steps in. And I think...
So, so here's the thing, is that, so a conditional use by itself does not trigger a community meeting. It's just in practice, they started doing that because they knew that eventually they have to go for an administrative site plan review, which is oblivious, nobody gets to see, so it was added in. So my point being, I do think a conditional use application does require a lot of due process. It requires TRC, it requires planning board, requires this public hearing. That's a lot of due process to me. That's a lot of due process.
Because I'm thinking back to the cup for the red, white, and booze.
In addition to the advertisements and everything.
I'm thinking back to the cup for the red, white, and booze was kind of like, I looked at as the second part of this. And I don't remember a community meeting for that.
That's outside of the community redevelopment district, so they're not required to. Mm-hmm.
But you're saying as long as it's not site planning, it's not required.
So what it's all about is the community redevelopment district is such an important area, the areas, because there's a couple of them, that we built in. It's basically a safety that if someone comes in and says, I want to build X, and it's as of right, and it requires a administrative site plan approval, but it's still going to be a development, the community wouldn't know about it until they start breaking ground. So then what was added in 2015 was this idea of let's make them have a community meeting so that it's known to the community that this is going to happen, that there's some due process in that. And so that's what I'm saying with that. It's the community redevelopment district that really triggers that. That's where it's required.
So I'm understanding what the mayor's saying, and I understand your explanation, but and I'm looking for a practical application that doesn't get us back here where we're doing this again. I want to do this the right way the first time, all the way through. it, if we extracted the cup
The pool.
with regards to the dining, could they submit
Yeah.
it later?
I think they
Would
can,
that still
yeah.
be a fatal flaw to the app because it was amended if that gets extracted?
I mean,
I'm just saying this hypothetically.
They could, yes, they could theoretically bifurcate it and just say, we're dropping the outdoor dining and drinking on the pool area. We're not gonna have that. We'll discard that and go forward with just the CUP without that. Because of the arguments that it wasn't sufficiently discussed at a community meeting. They could do that and come back to you all with just, hey, now we want to do this activity on the pool for dining and drinking, which has been described to me as a more of like venue for events and not necessarily a restaurant per se. And they could come back and amend the CUP. They'd have to go back through the process, as you said, Mayor, through the process of application and, you know, TRC, things like that.
I think we already did that once, right? Remember was it July, when they tried to simultaneously run a permit and a conditional use application?
Yeah, you'll recall that there were administrative things happening, like basically administrative site plan. There was some Florida building code permit stuff that the former city manager was like, okay, you can go forward with those. And I read the code, and it was really my opinion, because it talks about simultaneous applications, that if you have a larger CUP, they really ought to travel together. The commission should be able to, because in some of those instances, they may have been talking about elements, features that you all might want to have a say on with regard to during the CUP. So I had to opine that if there is a project with a CUP, they can't get these permits administratively at the same time, simultaneously. And I think I believe that was the right decision, because there's things like facades and view corridors and things like that you all want to look at.
So they wouldn't be able to reapply for conditional use until this one, if it were to be approved, was completely done with, because it's simultaneous. So just like we told them simultaneous last time, this one should be simultaneous as well.
Yeah, I mean, theoretically, I guess you would
Could be a
get,
couple of years before they could reapply for that.
I don't know how long it would take. I really don't. I mean, I'm just theorizing. I personally, I think, that's one answer to it. I mean, I think that the choice of having the community meetings at the front end of a CUP in the CRD, because it's ultimately going to be an administrative site plan, I think is a logical one, because the public is involved on the front end, rather than, let's say after this meeting, having a community meeting. Lots of people might say, well, that's, it's sort of superfluous, because the commission's already decided on it.
So if we sent it back, the pool portion, what I'm struggling with, trying to understand, is how will the process be better? How will this project and our evaluation of the project be better? Because what I believe Mr. Berry has said is that the information has been through TRC, it's been through staff, so the piece potentially missing was, well, that didn't happen, it wasn't discussed at the community meeting. So are we depriving residents of their ability to provide input on this portion of that process? Speaking for myself, I've received a number of emails, and it's very clear where from those emails that those people there are some concerns that we need to work through conditions, as we would set with any CUP. And they're very similar to other CUPs when it comes to timing and noise and decibel levels, et cetera. We have, as a commission, worked through those and come to a win-win resolution. So in this situation, and would the situation be better? Are we curing a problem? Residents will have the ability to speak here. Residents will have the ability to tell us their views in a public forum, in this public hearing. We have many, there are many, there's a lot of, a lot of correspondence from residents that's been entered into the record. We have a link to 1,000 over pages of comments from residents, non-residents, and others expressing that. So if we did that, what would be different when it comes back through?
I mean, I read this, and to me, I was looking for, the review process, because it does say, like, okay, let's go back to the review process, and I was looking for, it has to go back, something that says, go back to community meeting, and it doesn't say that.
What's the first step in the review process? It's checking whether there's a completed application, correct? I mean, it says review the application. So that, to me, says
There's not much of a process. It's really just review the application, determine when it's complete.
And does it have on there community meeting and comment cards?
Not on it doesn't say it in the code if you want to look.
Checklist that we've given applicants in the past?
But that's not in the code. You know that, right?
I'm asking what we've done in the past so that we can be consistent across the board. And again, to Commissioner Girl's point, what are we trying to fix, or what's the point here is, if we've had a procedure in place, right, if we've had a community meeting at every conditional use application, but in this case, we're going to change it for this particular applicant, what are we?
So
my concern is, are we being inconsistent here?
So you believe, okay, so I'm telling you I could tell you what the code says, because if I'm a lawyer and I'm challenging this, I'm looking at the law, okay? And the law doesn't say go back to a community meeting. In Division 4 conditional use permits, it just talks about it talks about changes of information. This is under 4.2 E, changes of information. If an applicant submits new data or information at any time after a determination of completeness has been made, the revised application will be subject to the same stages of review, which is basically going back like through the TRC, being distributed to the different departments. And that's how I looked at, for example, the issue of, new information about the Saturday traffic. Now, if they amended their application, it doesn't say go back to a community meeting. I can't tell you that it's a departure from the essential requirements of law by not going back to the community meeting. Now, what you're talking about is the procedures and practice that the city has implemented as policy, saying that we're going to have in the CRD for an administrative site plan approval that is associated with CUP, we're going to have a community meeting first, because it makes sense. And we probably should amend our code so that it says that. But I think they made the right choice, because that's where you want to have your community meeting.
So I see this as two different issues. One is, and the one I'm mostly concerned about is, do we have any procedural defects departing from the essential requirements of the law that are fatal to the application? And I'm hearing from our city attorney, the answer is no.
I don't see, no.
Okay.
I'm not going to say it needs to go back to a community meeting, simply because from a plain reading of Division 4 conditional use permits, it doesn't say go back to community meeting as part of the review process.
And I'm hearing from the mayor, as a practical matter, when we exercise a policy on a routine basis, that he would like to see some consistency in the application of that policy. and it
That
didn't
is part
happen,
of it.
and it didn't happen here.
Yeah, so that's the first part, is that, and then the second part is if the first step in the review is having a complete application, and the application asks if those,
So I don't have the application in front of me, so does the application
we
ask?
have Brandon here.
Oh, yeah, okay, well, that's what I mean. I'm reading the law, I'm not reading the application.
Yeah.
So the question is like, on the application itself, like your determination of completeness, is that part of it? Is it asking whether or not you had a community meeting?
Not specifically. That's something we typically discuss with the applicant in advance of application. I can't think of one where it was turned in and caught retroactively, but it might happen at some point. It's not part of the actual application package itself, no.
And the other issue that is playing into my thought process is the due process, because there has been a substantial public meeting at the local planning agency, the planning board, on this application. There has been a lot of information disseminated and distributed on file with the clerk. I get emails multiple times a day. I'm sure you all do too. So I'm thinking to myself that there is, obviously we have a full room. We also have the parking lot, we have upstairs, we have out there with people in it, which tells me that people are aware that this is going on. In other words, people aren't going to be shocked that, oh, there's going to be this potential music or food and drinking on the pool area. So that's the only, as I have to put this together, so when something isn't clear, it doesn't say go back to a community meeting in the conditional use permit review process. I have to think about, like you said, due process, and the room is packed, the building's packed, the parking lot's got people in it. And we've already had one meeting on it, and in between those meetings, we've talked about the procedure a couple times. So I have to factor that in, and I know a judge will as well.
Have we, if I may, Brandon, CUPs and the CRD, we haven't had that many in the past few years. I mean, for consistency, have we had this type of situation before?
Not that I can think of. The two projects that stick out that have held them since I've been here have been the Miramar and the Quarry Landings project. Those both did hold a community meeting prior to conditional use permit application.
As did the Tradewinds.
Now, I will tell you one second. I will tell you that I was going to mention that if you wanted to ask the applicant, would they like to withdraw part of their application or something like that, or what their feeling is on it, because they're also thinking about, is this going to get appealed because of something, et cetera, et cetera. So the people that are going to be named on the appeal will be the city and the applicant. So at least that's kind of your cue.
Hi, Elise Batzel, Stearns Weaver Miller. So a couple of things that I think are important with respect to the mayor's comments. 39.17, that's the provision that Andrew's reading that requires a community meeting before your site plan approval. A really easy solution to this, by the way, we did the community meeting early. We did a transportation analysis that is not required under your CUP criteria, but we worked with staff and thought it would be helpful for this commission. That's required at site plan approval. If you feel like we need to have another community meeting within 30 days before our site plan approval, we'd be happy to do that. That clears up any issues that you have procedurally. And in fact, we think that would probably be a great idea. We could have another community meeting. If there's additional input from the community that we haven't already had through all of these procedures, that buttons it up for if there's any, in the abundance of caution. But the CUP does not require a transportation analysis. We did that voluntarily. The CUP application does not require a community meeting before the CUP. It requires it before site plan approval. None of those things have happened yet. We're not at site plan approval yet, but we have voluntarily done those things and provided information to get as much input as we can from the community. And with respect to you talking about practices and procedures, I understand and respect that. You are limited to the criteria in your respective land development code, right? You don't get to go out and make the rules from the dais. So if you want to be consistent with how you're treating the community meetings, the thing to do would be to modify the code rather than to implement something that you may have been doing but isn't written in the code. Florida law is really clear about that, that you have to follow your own guidelines and that you can't interpret your own regulations when it's contrary to what the statute says, which Andrew just provided. So if, we're offering that as a solution that I think addresses the concerns that you raised. If there are procedural defects in what we've done in the past, we can absolutely cure those by having another community meeting 30 days before site plan approval, and we'd be happy to do that on the rooftop dining.
And also, it's my understanding that, and we looked into this today, that there is a separate application for administrative site plan approval. So it's not the same one as your CUP application. They literally will have to be filling out a new application for site plan approval. That's something I wanted to check to make sure that they weren't all one application, that they, so if you wanted to go by the code itself, it does say for administrative approval of a development or redevelopment site plan proposed, it's addressing that issue. So, I mean, if we wanted to go, I get it. It's not the way that I think it's only probably a handful of times that this has happened where they've had, because it's in the CRD, CUP, things like that, that triggers this kind of process, this larger process. So, I mean, she's correct technically by the code. She can, as long as she does the community meeting no sooner than 30 days before they file their application for site plan approval. And a lot happens during that administrative site plan approval. A lot of data, a lot of information is supplied to the city that isn't required as part of the CUP process.
Thank you.
I'm just telling you what the law says.
That's what we're asking for.
Thank you.
All right. Any further discussion on this item? Are we good to proceed?
I'm comfortable proceeding.
Okay. All right, City Clerk, item 2. Do we have any general audience comments?
Okay, so I do have a non-agenda public comment card, just one. But then I also received a video submission, and like we discussed at the last meeting, they can't be sworn in. So,
Yeah, and I'm on that issue, and I think Elise is going to say the same thing, is that I think there's only one, right? So,
That's an order.
I'm sorry.
That was an order.
I don't know what he's saying.
he wanted to speak on the procedural item, and I repeatedly said no.
Yeah,
Right, yeah. So I do think it would be prejudicial to hear something that's pre-recorded and played here that we don't know whether it's under, oath, sworn oath, nor can the applicant question any of that. So I don't know if, Lisa, if you want to state that any better. I mean,
No, it's just that Florida law requires that if there's testimony during a quasi-judicial proceeding, it has to be sworn testimony. And if you play the video and let's say that this person says something, we don't know if it's sworn in, and we're also provided the right to cross-examine those witnesses. And when they're on video rather than being live, we don't have the opportunity to do that, and that's a deprivation of due process for the applicant.
and I wouldn't want to have to play it and then tell you, just ignore everything that was said, because it's really, it's outside of court, and it's just better not to play it. It's only one.
Okay.
We're not talking about you, Mr. Kurzman.
Yeah. We're taking general public comments right now. And so you have one.
Yeah, other than the video. So we've all decided video, no, skipping that, right? Okay.
Yes, ma'am.
So, John Kurzman, I am not talking about you at this second, okay? I'm calling your name now. I was talking about a video. Please stop yelling and interrupting me. You can come to the podium, state your name. You have 3 minutes on non-agenda public comment. I was not talking about you. Stop. Please stop.
Two things.
Please stop.
One is
Okay, wait, excuse me. This is a big meeting, this is important. I think we've already had a very long discussion, quite, uneventfully. I think we can continue in that same spirit. I appreciate what you're saying. Mr. Kurzman, you will have 3 minutes. If you please state your name and address for the record, and then we'll be happy to listen to what you have to say. Thank you.
I was only prepared right now to talk about the procedural item that we just discussed, which is...
I think we said we weren't going to take public comment on that. We're not going to take public comment on that.
So I'm prepared right now to talk about that, though. That process is the key to ensure community.
Mr. Mayor.
Mr. Kurzman, we agreed that we will not be taking public comments on that item.
Well,
And
We're not
so,
voting on it. It was a discussion item. They're not taking public comment on it, John. Please, sit down.
so if you have something else that wasn't related to the previous and it's not related to the conditional use application,
no, give me a second then to switch.
is the clock running?
No, I haven't started it.
I moved the slides from my other comments to that to focus on it, though. Okay. It speaks to the same, all right, John Kurzman, Be 100 Way. Can you zoom in a little more?
He's talking about, he's going to talk about the community meetings.
So it does say in our land development code.
Mayor.
Mr. Kurzman, are you going to be talking about the previous item we just discussed?
What?
About,
No, I'm talking in general about our comprehensive plan, nothing to do with what the applicant has done. This is in general about the land development code and the comprehensive plan. And my issue has been that I think it's been that the plan is, and the question is, when the public is really supposed to be able to provide their input to the commission and the other layers of
Mayor,
government.
Mr. Kurzman's wrong about this. He's not a lawyer.
I'm asking, this is not the sworn portion of the hearing. This is the portion where the public can talk in the agenda about general things, which we're running the clock, and to understand and to ask a question about when the public is supposed to be able to understand to provide input to the public input into this process. There's a technical review committee. The staff tries to work on issues. They try to get input. When do they get that input? The planning board gets the documents. They've already stated that they can't look at information outside of the zone. The planning board publishes, the documents are published 7 days before the planning board meets. The technical review committee gets things 7 days before, and it's published 7 days before. The city commission document is published 7 days before. The public has to only get these documents 7 days before, read them, 600 pages, or whoever knows how many pages each document is. They have to read them, comment on them, send them in, and then whatever agency, TRC or whatever group, has to read them, comment on them, understand them, and then go to meetings and then deal with them. So, and then when you have these meetings, city commissioners, and when you get to the quasi-judicial hearings, are impartial judges. The question is, at what point do people really get to provide the input to these processes? This is a general question. And then also, what do you do about handling limited resources? Water mains are only a certain diameter. Sewer mains are only a certain diameter. Gulf Boulevard is a single street with no parallel streets, literally in the large resort district, unlike the rest of most of our city. So, and right now we have a water shortage. So there's limitations. So how is the city going to figure out what to do if you start approving the first permit you get, when then the second permit you get needs the same resources, because everybody will baseline traffic or water or whatever they need based on the current city, and then whatever projected growth is. But they won't necessarily base it on the next application, and applications you haven't even received yet within the same zone or other zones. So how are you going to do that? Is it going to be first come, first served? Are you going to be stuck in the middle, having to then get sued by the second applicant or the second permit, which might have even been the first applicant? How are you going to deal with that? How are you going to estimate all those things? What's going to happen when there's a drought? So, and is it going to be a precedent? So are you setting precedents now? Because this, if you're going to have a first applicant, are you setting precedents for all the future applicants you're going to have? So I just want to make sure you have time for all this. That's all my general question is.
Thank you.
Thank you.
Any other public comments?
No other comments.
Okay. Next item we have is item 3, resolutions. Resolution 2023-21, conditional use permit 23053.
A resolution of the City Commission of the City of St. Pete Beach, Florida, approving a conditional use permit pursuant to sections 35.3, parent B, parent 1, and 35.4, parent B of the Land Development Code to allow the construction of a 290 temporary lodging unit, 10-story, 100 feet 6 inches tall hotel with rooftop features not to exceed 127 feet 6 inches in total height from base flood elevation on the northern portion of the site, and a 130 temporary lodging unit, 8-story, 88 feet 6 inch tall hotel with rooftop features not to exceed 100 feet 6 inches from base flood elevation, hotel on the southern portion of the site, along with ancillary and accessory structures, and permit a rooftop dining and drinking amenity that includes the playing of outdoor music to parcel number 063216801720000010 with addresses of 5300, 5350, 5380, and 5390 Gulf Boulevard, incorporating the conditions outlined herein and providing for correction of scrivener's error and an effective date. And I'll need to swear you in, Brendan. Do you swear or affirm that the information is actual representation that you're about to give tonight?
Mayor, before we get started, before Brandon starts his presentation for the city, the commission does need to disclose any ex-parte communications, and that would include emails, text messages, letters, social media, conversations with the applicant, other groups, organizations, any meetings with city staff, individual research that you did, or any site visits are types of things that would be ex parte. So.
Okay, I'm going to start. I met with some of the folks from the Serrata, the ownership group and council. I disclosed that on my lobbying report. I think it was like, I want to say it was like the third week that I was a commissioner. Yeah. I was told that they were to come over here and meet with them. I did. They made a presentation, and that's the only time I met with them. I'm familiar with the property for over 40 years. I have read all the emails that were sent to me, but I did not reread emails that were boilerplate. I have read the entire packet. I have been provided by Lisa Robinson with many different traffic studies that I have reviewed. The traffic study for the Miramar, the traffic study for East Quarry, the traffic study for the Tradewinds, the traffic study for the Serrata, the recent Kimley-Horn traffic study that was in our packet. I talked to Brandon, I don't know, a week ago, to ask him if we're going to have presentation by our Public Works Director, if we're going to have presentations by our Fire Chief, and if we're going to have any presentations from law enforcement with regards to resource issues associated with this project.
I read many emails, all the emails I received. I met with many residents, talked with many residents. Met with the applicant back, I believe it was May 23rd. Again, that was on my lobbyist report. Met with city staff, mainly city manager and city attorneys. I think that pretty much covers it.
Let's see, I attended the applicant's community meeting, I attended the planning board hearing meeting, I reviewed the documents from the application, and those made part of the record from the TRC, the planning board hearing, even rewatched the planning board hearing meeting. I reviewed the land development code comprehensive plan and documents submitted for the record for this hearing. I've had several conversations with city staff and current and former FDOT staff. I have received and reviewed hundreds of emails, calls, and messages from residents. I've met with members of the public, individual and in groups at community and association meetings. I met with one advocacy group, and I met with the applicant and their representatives. I received and reviewed several emails from the applicant's attorney, their lobbyists, and staff.
So from an ex parte disclosure, in addition to the many emails that I received, many of them being the same form email, many of which were unsigned. I've read all of them. I've had discussions with many residents, city staff, the property owner, as Ms. Betzel had coordinated for us to meet with the owners from Columbia, Sussex earlier in the year. I've met with and had discussions with planning board members. I attended the community meetings. I met with the lobbyists, reviewed social media. I've been to the property. I've been to the Seamark property adjacent to the property, looked at the traffic studies, and received many other emails, some as recent as a few hours ago. Those I did not have the opportunity to go through in as much detail as I would have liked, as they came in quite late.
I also attended community meetings. I did meet with the applicant. I've received many emails also, and that's about it.
Mayor, if I may, one other thing before we get started. You'll recall at the last meeting, I had, we talked about quasi-judicial in general, and I had put out there an invitation for anybody who wanted to contact our office. I'd be happy to talk to individuals or groups and so forth. I did get contacted by the advocacy groups, St. Pete Beach. It was Jolene, some very nice people anyway. We set up a Zoom meeting. We did about an hour meeting. There was 4 or 5 people on the meeting. We talked just about the process in general, quasi-judicial, the difference, but who are the parties, substantial competent evidence, the criteria, things of that nature. So I wanted to let you know that that did happen. And even after this, I'll make myself available to anybody who wants to understand this process more. It's not always easy to understand because it's very different than legislative type of things that you're normally doing. So our office will always be available to talk to anybody who wants to know more about quasi-judicial process. And during that meeting, we do know that that group has an expert that I know of, and they now have a lawyer that we were notified of yesterday. So at some point during this process, you're going to have to decide how much time you want to allocate to that group. The city does not have a specific, some cities do, some counties do, some cities don't, some counties don't have procedures for identifying who is a substantially affected party, an interested party. This city, the codes are silent on it, so there's no way to really go through an evaluation and say you are substantially affected party and you get more time or emphasis than another party. So at some point after the city and the applicant presents, I think you're gonna have to make a decision about how you want to handle that. I think in general we've always relied on fundamental fairness and said that if someone is going to the point where they are hiring some professionals to represent them, that you afford extra time. And I did mention, I think in an email to you all, about their expert, because I sent it to you all, and it said that at some point you're going to have to, at the meeting here, you'll decide how to handle that, and we can go through that later if you want.
Just for my understanding, from the standpoint, when you say their expert, has he been qualified as an expert? Has the city considered him an expert in the field with which he's going to offer opinions?
The commission would have to qualify him as an expert. It's not my job to qualify him as an expert, but
you called him an expert, and that's why.
I apologize, because I do know him as a planner. I'm also a planner in the trade, and I know him as a planner, and he's well qualified. But I can't deem him as an expert. But all I'm mentioning to you is that there's no way for us to advise you who is an interested party or an affected party or a substantially affected party, because there's no code language. Like, for example, some cities will say if you're within 500 feet, you have the ability, you have standing, essentially, is what it goes to. So, so I would just suggest that after the city presents and you know, the attorney for the applicant gets up, and I'm sure you'll ask her how much time they need for their presentation. At some point, just for the record's sake, you know, if you're going to take up the advocacy groups, attorneys' arguments and their experts, if you are going to entertain that, I think it's cleaner to do it before you may get into the public comment part, because, you know, it'll be hacked up, and I always think about the record and down the road, but something for you to consider.
Are we comfortable with?
Sure.
If you don't mind,
Yes.
you direct those to me.
Sorry.
Yeah.
Mr. Mayor, point of order. I do have one question. Typically in ex parte communication, there's two prongs. It's to disclose it so that there's enough information that we can then rebut that in our testimony. So it's not just about it disclosing it, but it's about doing it so that we have our due process rights protected. I did notice in the meeting notes that some meeting notes from some associations that you mentioned that you met with, that you gave a presentation. Could you just let us know in the details of the presentation that you gave, just so that we're prepared to be able to rebut that during our testimony?
I've given no presentations, and that is the last question you get from me.
Okay.
I've attended meetings. I've not given presentations.
Okay, thank you.
Mhm.
Maybe I would just clarify that as I read emails, so it'd be very difficult for me to tell you about the thousands of emails that I got. But generally, I was listening to people. And I'm sure we all had a lot of questions about, are you going to vote yes or no on this? And I said, I reserve the right to listen to all the information, gather all the information, including the information at the meeting tonight, because I could hear things from my own colleagues that could change my mind. And so I want to make it really clear, there are a lot of people that were frustrated with me when I wouldn't answer yes or no. But to me, it's like asking a judge before the case how they're going to rule. So that's kind of my standard answer. And I think that's good policy, that all of us should come into this room open-minded, because you never know what you're going to hear. And this is a hearing. There's a reason why they call it a hearing, for us to be listening. So I think it's just important to let the public know that this is a process, and I think we all take that process seriously. And they may be frustrated not understanding that process, but it's intended to be fair. And so I just felt it was important to say that.
Yeah, and the point of your disclosure is really for me to protect you all, because but the state has adopted a law that says you can cure any ex-parte communications by disclosing it. Before that law was enacted, there was a case that came up, and essentially during the hearing, it was expressed that one decision maker had done their own research and talked to some other people, and it was deemed to be prejudicial because they didn't disclose that. And so the state legislature has made it very simple and just allowed you to disclose whatever you've done. If you've gone out and looked at the property, or if you've had staff meetings, and all of you seem to have done that, and you know, and if the council wanted to ask you more details, they can do that, and that protects you. So the whole process of disclosing is to protect you from any allegation of biasness because of an ex-party communication.
And I would just echo Commissioner Frislowski's comments on discussions and/or emails received. How are you going to vote? And I've had, my retort is the same. This is a quasi-judicial hearing. It's, you know, we use the same example as being the judge. If I had to ever go to court and stand in front of a judge, I don't want an answer in advance, which frustrates people. And as we know, this is not an opinion poll. This is a quasi-judicial hearing. So, thank you.
Great. Thank you. Brandon.
Get started. Thank you. Ryan, could we? Thank you. Brandon Berry, planner with the city. This is case conditional use permit number 23053, resolution 2023-21, which is associated with a conditional use permit. It's a Serrata St. Pete Beach, a request for a new large-scale lodging development and rooftop dining, drinking, and music area. The property address is 5300, 5350, 5380, and 5390 Gulf Boulevard. The agent is Elise Batzel of Stearns Weaver Miller, Esquire, for CP St. Pete LLC. This was read as part of the resolution title, but I'll reiterate that this is a two-part request. The first is to permit the construction of a 290 temporary lodging unit, 10-story, 115 6-inch tall hotel with rooftop features not to exceed 12 feet above that rooftop in total height from base flood elevation on the northern portion of the site, and a 130 temporary lodging unit, 8-story, 88-foot, 6-inch tall hotel with rooftop features not to exceed 12 feet above that rooftop from base flood elevation on the southern portion of the site, along with ancillary and accessory structures, which will increase total site density to 646 units, just under 75 units per buildable acre, and exceed 50 feet in height for new construction. This request is made pursuant to Land Development Code Section 35.3B1. The second part of the request is to permit a rooftop dining and drinking amenity that includes the playing of outdoor music. This is made pursuant to Land Development Code Section 35.4B. Here is a brief application timeline. As was already discussed, the applicant held 2 community meetings back in April. In June 20th, the applicant completed to minimum standards the application for request number 1, which is the new hotel development. The technical review committee for request number 1 was held on July 19th. The application was amended with request number 2, which is the rooftop dining, drinking, and music, on August 28th. That returned to technical review committee for only request number 2 on November 1st. The planning board hearing for this request was on November 13th. The planning board is a required board preceding the city commission hearing for these types of requests. They made a recommendation to the city commission 4-1 for this application. Notices were posted in accordance with the city's ordinance for that hearing. They have also been posted in accordance with our ordinance for this hearing. On November 20th, notices were posted to 378 property owners within 500 feet of the subject property. November 22nd, a legal ad was published in the Tampa Bay Times. November 27th, a sign was posted at the property. As of this morning, we have received a total of 508 letters. That includes 338 letters that were sent to the city clerk's office, may have also included zoning and other staff, 170 letters that were sent to planning and zoning. And of course, tonight is the city commission hearing. Here's a listing of exhibits. Just a short description of what a conditional use permit is. This is out of the city's Land Development Code Division 2, which is definitions, and Division 4, which is the conditional use permit division. Starting out with the definition, conditional use means a use that has operational, physical, and other characteristics that may be different from those of the predominant permitted uses in a zoning district, but which is a use that complements or may otherwise be compatible with the intended overall development within a district, provided that specified standards are met. In Division 4, certain uses are conditional rather than uses by right. They are subject to the conditional use regulations because they may, but do not necessarily, have significant adverse effects on the environment, public services, the desired character of an area, or they may create nuisances. A review of these uses is necessary due to the impacts they have on the surrounding area or neighborhood. The conditional use review provides an opportunity to allow the use when there are minimal impacts, to allow the use but impose mitigation measures to address identified concerns, or to deny the use if the concerns cannot be resolved. Here is an aerial map of the subject property. The property is located south of the C-Mart condominiums, north of the Bellwether Resort, which was previously known as the Grand Plaza, and to the west, traveling north to south, just south of 55th Avenue, of Sunrise Resort, Belle Grande, Boca Sands, and Beach Mart. Here is the site plan for request number 1, starting at the northern side of the site. The applicant is requesting to demolish an existing 6-story building on the northern side of the site, as well as a northern portion of the existing Serrata development, in order to construct a brand-new development. It's referred to in the application and in the staff report as Hotel Number 1. This is proposed to be a 10-story structure, 115 feet 6 inches, with rooftop facilities, as mentioned in the request. This development would contain 290 temporary lodging units, as proposed. Hotel 2 is proposed to be the existing remodeled Serrata. This is proposed to remain in its current location, minus the renovations mentioned prior. It is currently 8 stories. It would remain 8 stories, no change. It would be made 226 units. That was 382 units, but that was also inclusive of the 6-story building on the northern side of the site. It would also include some renovated facilities. That includes a pool, a new facade, specifically a porte cochere, and a new restaurant. It was mentioned earlier in this meeting, but those items were submitted separately for an administrative site plan. Those are items that can be reviewed administratively, but they were reviewed into this, they were rolled into this conditional use permit because of the simultaneous applications item that was mentioned earlier. And Hotel 3 on the southern end of the site, this is also proposed to be a brand new development, 8 stories tall and 130 lodging units. This is site plan for request number 2. This is the rooftop dining, drinking, and music area. This is not an exhibit that was provided by the applicant. This is taking the floor plan and imposing it over the site plan. I just wanted to point out where this is on the site and what's being requested. So you can see in green at the bottom left, that's the southwest corner of the proposed Hotel Number 1. There is a pool deck. The applicant is proposing to offer rooftop dining, drinking, and music on this floor 4. You can see a red T. That is floors 4 through 10 that rise up above this deck. So it is blocked for the most part from the northern side and from the eastern side. That is the only area that they are proposing for rooftop dining, drinking, and music under this application. There are other rooftop areas, but they're not requested for this use. And here's a rendering. This was included with the packet, but I just wanted to point out, look, standing on the beach behind the property to the west, looking to the east, this is where the dining deck would be located. So staff responded to the 20 criteria that comprise this conditional use permit in the staff report. Staff finds the request to be generally consistent with the adopted comprehensive plan. At the planning board hearing, staff had asked for the applicant to supplement 7 criteria for which only partial support was found. Staff had found the remaining 13 criteria to be adequately supported prior to that hearing. Staff does find that the applicant has provided adequate support for those 7 partially supported criteria. I'll cover those in just a moment. And I mentioned this earlier, but the planning board recommended this case to the city commission at a vote of 4-1 with conditions at the meeting on November 13th. So these are going through the 7 criteria that had been pointed out at the planning board meeting and have been requested for supplemented testimony, and then following up with what the applicant has provided since that hearing. Looking at criteria 4.4A2D, whether the application will have significant adverse impacts on the livability and usability of nearby land due to noise, late night operation, or safety issues. The applicant has clarified in response to a staff concern about noise, especially late at night on the northern side of Hotel 1, that valet service would be offered. It's only a drop-off exterior area. There was a letter that was provided by CMARC Incorporated. That was over the summer. I understand there was a more recent letter provided on Friday, but this is addressing specifically the items that were included in the first letter. The applicant will provide photo documentation prior to and vibration monitoring during construction. At the planning board hearing, the applicant demonstrated how the stormwater mitigation requirements for this development that are imposed by the FDOT and the Southwest Florida Water Management District substantially exceed the local requirements of a 25-year, 24-hour holding capacity. We do have our Public Works Director as an expert who will be able to speak to this after me, as well as sewer capacity. And the third item was a wind study, if required by building code, will be addressed to the permitting stage. The applicant's architect has provided a letter providing some information about the wind study, and that was included in a staff response that was included with your packet. Criteria 4.4A3, whether the transportation system is capable of adequately supporting the proposed use and existing to the existing uses in the area. Evaluation factors include street capacity and level of service. At the request of staff, the applicant has amended their traffic study to include a derived peak hour Saturday count adjusted to peak season. This was collected in August 2023. The city's transportation expert will also be speaking after Public Works and fire experts. They have expressed agreement with the procedure, analysis, and conclusion in the amended traffic analysis. Criteria 4.4A4, whether the minimum off-street parking area required will be provided and will function properly and safely. Staff had expressed some concerns due to what had been described as the phasing of this project, but there are multiple construction elements going on with this project as the work proceeds. If it is approved for development, we wanted to ensure that the property would have adequate parking throughout the different development phases to support the existing uses on the site. The staff has stated with the applicant that we will work on ensuring that there's adequate parking during the site plan review if this use is approved. Criteria 4.4A6, whether the applicant has demonstrated the financial and technical capacity to complete any improvements and mitigation necessary by the development as proposed. The applicant supplied staff a write-up on November 7th, listing a number of Columbia Sussex corporations developed and operated resorts, and staff has recommended a condition that any finding of financial and technical capacity extends solely to Columbia Sussex Corporation. Criteria 4.12A1, prevention of unreasonable and disproportionate negative impacts on utility infrastructure, including sanitary sewer. As I mentioned after my presentation, the Public Works Director is available to speak to potential sewer requirements of this project. I mentioned the city engineer. They are not present tonight, but there has been some correspondence about how the project should be assessed in terms of sewer impact, whether it should be a peak hour versus an instantaneous flow distinction. I did receive correspondence from the Assistant Public Works Director this afternoon consenting to a peak hour analysis. Staff have also added a new condition that if the development requires any kind of off-site improvements related to sewer increase or improvements, the developer is responsible for the actual and documented cost of those improvements, with the city to be the ones who provide the work. Last two, criteria 4.12A4, the aesthetic and architectural features of the development, including design and appearance of building facades. Staff would like to see the porte-cochere proposed for the Serrata be made more harmonious to the existing elements of the building, and would prefer to see interspersed planter boxes in the Hotel 3 parking garage front facade, subject to City Commission preference. The applicant has expressed a willingness to work with the staff on the minor design concerns, and of course we welcome City Commission recommendations on the building design. And finally, criteria 4.12A9, for projects of this size, projects taller than 50 feet in height, the amount of separation provided between the proposed temporary lodging use and any existing buildings on adjoining properties, and the resulting impact on sunlight and views. The applicant has prepared a shade study and can speak to its effects. At the winter equinox, December 21st, shade will be over half of the CMARC building at 10 a.m. The shade clears the building by 12 p.m. This was something that was demonstrated at the planning board hearing. They have provided those documents to staff. They were included in your packet, but they can speak more to the impacts of this Hotel 1 on the northern development. Staff finds that the applicant has supplied adequate support for the 20 conditional use permit criteria based on the supplemented criteria that were requested. Staff recommends approval with conditions, subject to the applicant resolving any concerns that arise among the City Commission related to the conditional use permit criteria. Out of respect for the City Commission's time, I am only addressing the new and amended conditions. I'd be happy to go through all of the conditions if you would like me to. These are the ones that have been modified since the planning board hearing, either added in or the content substantially changed. There was an initial condition, condition number 1. This was relayed in the planning board resolution that it requested effectively additional documents before this application was brought forward to the City Commission. We had asked for an updated traffic analysis showing a weekend peak hour, a shadow study, and improvements determined to be necessary to preserve sewer capacity. That condition has been removed due to the applicant supplying items number 1 and 2, and staff adding a condition relative to item number 3. This is a new condition that the applicant is responsible for the actual and documented cost of off-site improvements to accommodate sewer flows if off-site improvements should be required. The applicant shall pay with work to be performed by the city. Condition 10 related to operational and design requirements. The applicant shall comply with the beach ordinance as adopted and when amended. Added condition number 11. Each resort development shall have a dedicated spot for the freebie or successor circulator and ride share. Condition 12, the applicant shall dedicate an easement for a beach walk along the coastal construction control line upon being issued a notice to proceed. This walk is contingent upon future City Commission and FDEP approval. This was commented on at the planning board hearing. I just wanted to make it clear staff are not recommending any action related to any kind of beach walk, any kind of boardwalk tonight. This is just a request to obtain an easement along the coastal construction control line, so should such a development occur at any point in the future. This is an amended condition, condition number 18H, related to marine turtle lighting. All new and existing lighting on the subject property shall be compliant with the Land Development Code requirements for new beachfront lighting, Pinellas County Coastal Construction Code, and Florida Department of Environmental Protection regulations, whichever was more stringent. At the planning board hearing, staff had recommended specific requirements. This is a more holistic and overall request that all existing lighting be made compliant with the standards for new lighting in the city's code or in the state codes that may be more stringent. And a new condition that the applicant shall photographically document conditions on adjacent properties as are requested and use vibration monitoring during construction. New condition number 27, this was recommended by the planning board. The applicant shall connect to the reclaimed water system and have their connection metered. The irrigation system shall use pressure regulation and have leak monitoring systems installed. And finally, transit operation improvements and operational requirements. Condition number 30, this is an added condition. The applicant shall pay $100,000 per year for 5 years for mobility services, facilities, and/or improvements. Condition number 31, the applicant shall bear the cost of Gulf Boulevard short and midterm safety improvements in front of their property that are not otherwise provided during development. This is specifically out of the Gulf Boulevard safety study. Condition number 32, should the city proceed with an emergency services level of service master plan, which the city officials from the fire department can speak to, the applicant shall bear a proportional cost of that study. Condition number 33, the applicant shall maintain transportation management plan strategies regardless of whether the lot is subdivided in the future. 34, no deliveries from vehicles that exceed 2 axles are permitted before 7 a.m. or after 10 p.m. And condition number 35, the applicant shall provide information to guests regarding safe crossing of Gulf Boulevard. Staff recommends a motion to approve Resolution 2023-21. As I mentioned, there are other experts with the city, Public Works, Fire, and our city transportation consultant. I'd be happy to answer questions now. If you'd prefer to hear from them and then have me come back up, I'd be happy to do so as well.
I'm good with questions. While he's still here, we refresh.
2 quick questions. The height of the C mark and the bellwether, the buildings to the north and the south, are they taller or shorter than the proposed structure?
Sure.
This is an estimate based on the plat detail for the C mark. I was estimating that Hotel 1 appears to be about 12 feet taller than the C mark when looking at the roof height. That is an estimate. For Hotel 3, it's 8 stories, 88 feet 6 inches in height, and I have the the bellwether as, sorry, let me find my notes. The bellwether would be taller.
Okay. And then the second question, so there would be 6 stories on the north and the east side of the, 6 stories above the pool deck, correct? On the north side and the east side?
Correct. It's 10 total stories. That 6 stories above is inclusive of the 4th story, so above the 4th story.
To the south, which is the applicant's property still, and the west is the Gulf of Mexico.
Correct. That would be for hotel number 1 specifically. That is 10 stories. Mm-hmm.
You want to go down the line here? Or?
We'll go down the line, let's do that.
So I have, Brandon, I'm not sure, and you tell me as we go through these questions if it's appropriate for you to answer these questions or for the applicant to answer the question, because I'm not sure who's got the best level of information. But the first question I have is, who are we doing business with? Because the documents and the discussion items have mentioned Columbia Sussex. However, the CUP application named CP St. Pete LLC and Mr. Derek J. Hout. Presumably, they'll sign the contract with us. They're listed as the property owner. The analysis, the financial discussions in the agenda pack mention Columbia Sussex, page 41 of 861 in the packet that I printed. I know some people have 862. And everything seems to be with Columbia Sussex. In fact, I don't believe Mr. Hout is here tonight. I know Mr. Young and Mr. Young are both in attendance. So I need some clarification. And then also when we look at the, it's not clear on the lobbyist registration and who Ms. Batzel is actually representing, because the lobbyist registration, and I have to put my glasses on, I apologize, but the lobbyist registration for Ms. Batzel, let me give you a moment here, which was duly filled out before we had our meetings earlier this year. There it is. I'm sorry, there it is. Says that we're representing Joe Young at 740 Centerview Boulevard in Crestview Hills, Kentucky. It is no mention of the LLC or Mr. Hout. As I mentioned, the CUP application, same thing for appointment of agent. The agency agreement here, the appointment of agent, give me a moment. I apologize. Well, the appointment of agent is also, there we are, with, from CP St. Pete LLC to Ms. Batzel. The, I assume the contract will be signed by the LLC. The special warranty deed is also, that was included in the packet, is also to the LLC, the CP St. Pete, by Mr. Hout, as well as the conditional use application.
Mm-hmm.
So who are we doing business with, and what analysis did we do from a company standpoint? Who's going to be the operator? Because, and the reason I'm asking these questions is not to be difficult, but we'll sign a contract, and we need to protect our rights as a city, and it's just not clear. So,
Mr. Vice Mayor, would you like the applicant to actually answer that, or the planner from?
well, I'm not, as I said before I started, I'm not sure who's the appropriate person to answer that question, but I think it needs some clarity. Maybe it's both, because our analysis in the packet and what we heard is that we analyzed the financial capability of Columbia Sussex, who's not mentioned in any of the documents. It's the LLC. And I haven't seen any analysis of the financial capacity of the LLC. And just for discussion's sake, they could be a $2 company, or they could be a $20 billion company. I don't know.
We actually haven't seen financial documents for anyone.
Yeah,
So,
and Yeah, I'm sorry.
No, I'm just saying that it says, we've looked at their financial capacity. We haven't seen anything about financial capacity other than to say,
The only thing I want to mention is, so Brandon's here as the senior planner for the city, and I don't want him guessing at things that he doesn't know about.
Yes.
And so if somebody else is a better person to provide that information, they can do so to the commission under oath. So I'm just asking Brandon, like, don't try not, don't guess. If you
Right.
can't answer it, ask, say it.
but if the staff says that they reviewed the financial,
I understand that, yeah.
then I'd like to know what they reviewed.
Okay.
Is that a fair question?
Right, it was specifically the document that was referenced. It had been a write-up that was provided to staff. I believe it was right before the planning board hearing regarding the capacity of the Columbia Sussex Corporation. But beyond that, I would recommend asking the applicant.
Peace. I had some questions on the water and the reclaimed. So on page 14 of the book, it says the project may increase reclaimed water use. So it's not clear to me, and you mentioned as one of the conditions that will now hook up to reclaimed water. Was that not the plan before, or was there a different plan, or was it to use potable water?
I think there was some question about whether or not reclaim was already offered at the property. I understand that it is. We wanted to make sure that it was metered, and there are other corresponding conditions related to grouping of landscaping material to reduce
I saw
demand
that.
of potable. Mhm.
Because on the metering, it's not clear to me why we're putting a meter in, because today in St. Pete Beach, and as far as we've been updated from our Public Works Director, the county is not going to meter any of the units in charge individually for reclaimed water use. So is the plan, and this is a large site, and we've had these discussions now, actually as a city for several years, not with the planning department, on how do we meter the large users and ensure that the large users are paying their fair share of our ever-increasing charges that come from the county for reclaimed water. So from a resident's view versus a large view. So do you have any, can you clarify that a little bit, how that's going to work and why we're...
That had been a recommendation of the planning board. We do have a optional provision in our amended reclaimed water ordinance that we can require metering if we would look for a proportional user fee or something like that. That wasn't directly addressed through that condition, at least as I drafted it based on the planning board's feedback. That might be something up for consideration if it's something you'd like to discuss, but...
Yes, I would.
Okay.
And then on the stormwater, while we're on the subject of water, and again, maybe it's for the applicant to answer, how do we, have we reviewed to ensure that the mitigation factors for stormwater will prevent water from leaching out and potentially to surrounding properties?
Not yet, and the reason for that is because that's an aspect of concurrency review. Stormwater is one of the 5 facilities that the city reviews for concurrency, which if this use were to be approved, it would be handled at the site plan. The others are potable water, solid waste, sewer, and transportation. So those elements are addressed at the site plan stage. The city's Assistant Public Works Director is the one who reviews the drainage plans for the city. So he would be checking off on the minimum standards based on the city's criteria. I understand based on testimony at the planning board meeting that Southwest Florida Water Management District and FDOT also have their own standards that are above and beyond what the city has that would need to be demonstrated.
Okay. So you mentioned another item I have, and unfortunately, well, I have several pages here on concurrency, and I'm questioning and looking at why we're doing it down the road and not now. And I understand what we were read chapter and verse a few minutes ago, but what I don't want us to do is be in a situation a few years down the road where we get surprised. And we haven't, and because we haven't evaluated it properly. And I know some of these things are difficult to do, but there's new development, increase in density brings impact and stress on our infrastructure, our ability to provide services, whether it's fire, water, and we've heard the number of it. And I'm wondering if it wouldn't be better to do that now as opposed to later and just kicking the can down the road. And I know some is based on a plan. We don't have a lot of data right now, and some are estimates, but that's what planning is all about, or based on estimates. And in my mind, I'm looking at how we planned the sewer system. And I know Mr. Clark, our Public Works Director, will talk more about sewer system capacity. But when we did the sewer project, when the city did the sewer project, we built it out to, and I'm sorry, Mr. Clark, for stealing your thunder, but it was built out to the maximum potential build-out based on the comprehensive plan that was in place, and maybe there was a factor, we bumped it up a little bit just for safety, because sewer system capacity is not one you can easily increase, so you take the most prudent method. But we use some assumptions there. And we can, there are lots of debates, will we ever build to that plan, will we not build to that plan? But that aside, we use that as our base. So now I'm looking at other things so that we don't get surprised in 2025, 26, and go, we didn't put in enough capacity, and now we're stuck. Now what do we do? I look at that for the same, with the same view as we've been asked to review this CUP application to go forward on all the other infrastructure, so and we'll hear from all, fire services and water, even city staff. What services, because it's important for us. We, as the city changes and grows, if it grows, I should say, we need to make sure this building that we've got the appropriate level of support to provide services to the community, because, that's what we're here for, right? To make this and continue to make this a great place to live. So a very long intro to say maybe this is something that we should take a stab at now and not after and waiting down the road, because the longer you kick the can down the road, the more you might be surprised. We may not have a problem. I'm not saying we have a problem, but if you don't do the analysis, you never know. And I'm a firm believer, no sooner than later.
Understood. I can say for traffic, the applicant has provided a traffic study. This is a preliminary document. Concurrency is issued at the site plan stage. That's how it's laid out in the capital improvement element of the comprehensive plan. It's the final development approval. They have provided some data related to stormwater, and as I mentioned, the Director of Public Works will be speaking to sewer capacity and other improvements. That leaves two elements, solid waste and potable water. Those are both handled through the county. Typically, and I don't have a letter with me, but I could show you the process in the past. The applicant reaches out to them at that stage, and they supply us a letter. So in terms of the items that the city reviews internally, the applicant has provided data. No determination of concurrency is being made tonight, but we have received information that we felt comfortable moving forward with.
Okay. On the item you mentioned on the height, and to Commissioner Grouse's question, has there been any, on the top of the CMARC building, there are microwave towers for cell phone reception for the city. Has there been any analysis done on potential interruption of that service? Because I think you did tell us that the building will be higher than the CMARC on the south side, and would there be an impact to cell service for the residents and for anyone in St. Pete Beach?
Not by myself at this stage. I'm not sure if the applicant's provided any, but no.
Okay, because I think that's important. Again, this would turn out to be an unintended consequence. You build the building, and then all of a sudden, phones don't work, and I'm not sure which networks these are, which I don't think is important at this point. And I think we'll hear on the wind study. CMARC did. There were concerns. The response, I will tell you, and I think we'll probably hear more from the applicant, but I think the response was pretty thin. They said, well, we don't think we need to do it. And yes, it was written by an engineer, but we don't think we need to do it isn't really a study. So I have a bit of a concern there. I want to hear more, and you didn't speak about the beach and beach access. I assume we'll be hearing that from the applicant, as well as the easement that's owned by the Brightwater Beach Estates that I didn't see addressed.
That was addressed in the prior presentation. If the applicant doesn't address it, I'd be happy to.
Okay, so we can wait on that one. The other thing I have, I saw in the packet in staff analysis is, I call the economic analysis, and again, I'm going to read from what's in the book here. Quote, "The project is likely to increase the commercial tax base, removing from the redevelopment pool property that could otherwise be redeveloped as residential and providing potential shift to the tax burden away from existing residents, which is directly promoted in the comprehensive plan. The project will also increase bed taxes that can be used for projects such as beach renourishment that may have an impressionable impact of the standing." So what I'm trying to look at is how the project, and it didn't see this, contributes to the city's economy directly. Yes, we know there's increased bed tax. We know that the bed tax is, I call for the greater good, and used by for different tourism projects. Some of that money we are getting back now with the beach renourishment. But how does that tie into directly our businesses? How is this going to improve our businesses here? Because you've heard me in a previous commission meeting talk about our empty lots. We have a lot of empty lots, and my concern is that we're not, if the best use of a property in our business districts is a parking lot, we have a problem. So I'm interested to know that, and maybe that's something we'll hear from the applicant. But I tied that into the transportation plan, and I know we'll hear that from the applicant. But the stated assumption, I found it interesting, the stated assumption in the transportation management plan, page 306 of 861, states, quote, "Patrons at the Serrata Beach Resort are anticipated to be fully serviced within the resort's site due to the amenities provided on site, which include but are not limited to full-service restaurants, pools, fitness and sporting facilities, gift shops, and recreation activities. This is intended to reduce the number of external trips generated by the proposed redevelopment, since patrons are anticipated to use the on-site rather amenities than off-site amenities." So when I tie those two together, I find them conflicting. If the project is going to benefit the economic growth and help the city, then how do we make an assumption? And transportation plans, we know, are based on a lot of assumptions and extrapolations of data that says, my base assumption, it's in the beginning of the report, by the way, says that my base assumption is people are going to stay on site and not be leaving, so don't worry, you won't have a traffic problem. So also on transportation, well, I'll hold off on transportation until we further, we hear from the applicant, because I believe they'll be talking on that. I just as a little aside, the deliveries starting at 7 a.m., I was just wondering why that doesn't start at 7:30 a.m., which is the time in the morning that we have around the city for construction. It starts at 7:30 a.m. Don't know why we push this to 7 a.m., just for consistency. And then there's discussion on off-site premise parking during build-out, so I'm interested to hear about that, and I'll hold off on that, and then I assume afterwards we'll hear from our external transportation consultant. I guess we'll talk more on the rooftop music later, so I'll hold for now. So those are some of the questions, so thank you.
Okay.
Commissioner Kozlowski?
Thank you, Mayor. First of all, good presentation, Brandon. I'm very impressed with staff report, and always have been with you, but I know this is a big project, and I just want to compliment you to start out. I'll hold off on my transportation questions until we hear from somebody else, but I have a few others. The issue of the amplified music on the roof and pool deck, The regulations limiting the decibels, is that per regular land development code? I know we did something special for the Hotel Zamora, and I just wanted you to kind of go over that issue briefly.
So this one, it's still held to the decibel limits in the land development code. Nothing's changed with that, but there's actually a special standard for new development in the community redevelopment district that music cannot be audible from an abutting property. So it's even stricter than that. If it's 30 decibels at 11 o'clock at night, that the ambient noise, it shouldn't be audible to somebody at the neighboring property. So it's not a 65-55 issue. It's what is audible from the property line.
Okay, thank you. That clarifies that. The easement along the beach, parallel to the beach, that's tied to the mean high water line, and there's some language in there about it being dedicated or recorded or something like that. The concern I have, it's good. I think that's a big public amenity. But because they have riparian rights, and as we all know, the issues of ownership of the beach and the right to go to the beach has been a big, big issue. But my concern is that line can move over time. So when I see the words, it was recorded or something dedicated, recorded, I think there needs to be some language that allows that to shift with shifting sands so that it's always a 10-foot line. It doesn't matter where the mean high water line is. I don't know if, I guess it's just a comment on my part to clarify that, maybe in a condition.
And City Attorney, I believe that this is the condition related to the mean high water line, and we've discussed this in the past, related to the mean high water line, high water mark, or the wet sand, whichever fulfills the intent of the condition.
Okay, that's good.
We want to make sure it's...
So the intent of that is, because obviously the mean high water, the mean high water line versus the high water mark is different, but the intent would be the most beneficial to the public, basically.
Right, exactly.
Like wherever, it's essentially wherever there's wet sand, 15 feet up. I think the applicant will speak to that, but that is the clear intent, is to make sure that the mean high water line isn't 20 feet out in the water, and then we're getting an easement.
Okay, you've got it. I just want to make sure that's loud and clear and we get it documented appropriately, so sometime in the future is never an issue that. There's language in there and some diagrams about a continuous dune line and it mentions dune walkovers, but when you see the diagram, there are gaps in the diagram as if they can walk through the dunes. And obviously, it's not as good as having a continuous dune with dune walkovers. So I'd like to have that clarified to require a true continuous dune with dune walkovers. Gaps are not good. A gap is a gap, and it's as good as not necessarily having a dune. This question is maybe not as much for Brandon, but I did talk with the city manager about this one, so maybe I'll leave it up to you guys who's more appropriate to answer this one. But I want to make sure that there's been discussion about does the resort or will the resort, we're not going to know what the taxable value is, so we're not going to know exactly what the taxes are or what the net taxes are to the city. But I'd like to have an assurance that the taxes being paid through this resort will adequately cover the city services that are going to be provided without burdening residents, taxpayers. So I don't know how else to say it other than, can we get some kind of comment? I'd like an assurance. I know you probably can't give an assurance, but
I can try to answer that. Obviously, you can't give an assurance. We don't know what the assessment will be in the future, so we can't say what the new taxes will be coming in. I can only speak from my experience in dealing with very large developments in the past as far as what impact they had. And my experience has shown that developments such as this has paid their way and actually contributed more than what their demand has been. And the other thing to consider is our cost of services are going to go up every year, even without any development. Our cost will go up every year. So if you have more people contributing toward that automatic, or not automatic, but that increase every year, then that helps out too in keeping your tax rate down. But like I said, in my experience, and I've dealt with some very large ones, many of them over the years, and it's, you know, the question has always been, you know, does development pay? Does development pay for its impact? And my experience is it does and actually contributes.
Okay, thank you. I appreciate that, because I know you've had a lot, many decades of service. That's really all of my questions of Brandon. I will have some as we have the other experts come up, and of course the applicant. Thank you.
I just have a few questions, Brandon. With regards to off-site sewer requirements, you're saying that the applicant will pay for what the city says we need, and the city will do the work, and the applicant will pay. What if the applicant says, "Oh, down the road, well, I don't think you guys need that. Well, I think this is sufficient. We're only going to pay for that." In other words, I think it may be better that we have the study and recommendations completed that say, this is how much more in sewer capacity or the effects that it's going to be on the sewer infrastructure. And a lot of us I'm considering about lateral lines, because it seems like lateral lines are going all the time. If we know what lateral lines, what sewer lines they're going to be impacting, and we can accommodate it with the analysis accommodates for it plus 5, 10, 15% built in, then we have a number and we say, we have a range number and say you're gonna pay X amount of dollars for this work to be done. Because what I'm worried about is we get to the other side of this and then suddenly all these things that were general agreements start falling apart because we didn't have the level of specificity to tie it down now. And then it gets loose on us down the road. It doesn't ever happen, or doesn't ever happen like we intended it to happen, and we have no way to fix it. So that's just my thought on that. I want to go to mobility services. You said $100,000 a year for 5 years. Who made that deal or that agreement, and why isn't it in perpetuity? Do you expect something to happen after 5 years that's going to change the mobility services issue?
City Manager, we discussed this one. Would you like me to?
I can comment on that.
Yeah.
You know, there's nothing in the traffic study that demands that they contribute something like that. But we had discussions that traffic has been a huge issue as far as the comments that all of us have received. So we thought that there should be some kind of contribution made to help us. The original, I think at P&Z, and correct me if I'm wrong, it was a contribution to the freebie for 3 years, I think, or something like that. But there's nothing to say that that's their impact and that's what it's going to cost for what they will impact it. So this was just something that we thought would be helpful to the city overall for a time period.
$100,000 for 5 years?
Yes, sir.
Okay. And then you said that they'd be willing to bear the cost for traffic safety in front of their property. And I think we've got some issues that go to the north of their property and to the south of their property. Boca Sands, Bella Grande, Sunrise, those were built, I want to say, in the last 20 to 25 years. There's a lot of units over there. It's very impactful from a traffic standpoint that those buildings are there. And they are the most directly impacted by the large hotel district. So they do extend past the front of the Surratt property to the south. And we're going to have probably some issues to the north because we have another project that is brewing. So what is the scope of what they're willing to bear with regards to the cost of traffic safety, north and south?
The staff recommendation was particularly for what are identified as short and midterm improvements in front of the property, and this is through a Gulf Boulevard safety study that the city is currently working through. These are not massive improvements, but things like signal timing and other improvements that are related to that frontage in particular.
Commissioner, let me add to that if I could. We have the study that was done for the whole corridor, and correct me if I say something incorrect here, but and we discussed, well, should it be something that they take care of in front of their property, which DOT is going to make them do something, once they get to that. But we wanted anything additional that was identified in that study, that safety study plan, to also be something that they would have to fund. The other way we looked at it, though, and I think it goes to what you're saying, is we looked at the possibility of having, rather than that condition, a condition that they would pay a proportionate share of the entire corridor study. I believe that's where we were. Is that what we were talking about at one time, Brandy?
At one time.
In other words, we would look at everything that would include in front of the other properties. Then we would have to come up with some kind of a proportionate share that they would pay toward all of them, not just the ones in front of theirs. We just thought it was a cleaner way to have them do all of the stuff in front of theirs.
Just for my clarification on stormwater, they're having on-site stormwater, I'll call it a cistern, that type of storage facility for on-site stormwater, unless, I think you said at the planning board meeting, there was a 16-inch rain, and then their stormwater would go into our system?
That might have been the applicant's engineer who presented that. They did have a slide on that.
There's criteria that they have to meet in our code, as well as the Southwest Florida Water Management District for the stormwater. And they'll have to meet all that criteria, which makes them retain a certain amount on site.
Okay. In all the staging for construction is going to be on-site staging?
Yes.
And I'm sure people would want to know, is Gulf Boulevard going to have to be closed on one lane in perpetuity while this project is underway?
I haven't heard that. I would ask the applicant, though.
Okay. And you might not know. It's probably a better question for the applicant. That's all I have right now, but thank you.
It's been a lot of work, hasn't it?
Yeah.
Yes.
So, just going to go through your presentation and have a couple questions. So you have a section on there that says recommending all existing outdoor lighting be made compliant. And that's for the turtle issues, environmental issues?
Yes.
Okay. What about windows?
That is included in that, and our code is less strict in certain ways than the Pinellas County Code, but there was a request at the planning board hearing that the VLT be reduced to 45% or less, and that is a specific requirement of the Pinellas County Coastal Construction Code. So that would be a higher standard. They would be limited to that.
For all three buildings?
Yeah, correct. And that automatically applies to any new building, but it would apply as well if this condition were approved to the existing Serrata that remains.
Okay.
Mm-hmm.
You had a statement here that says reason for choosing a luxury brand at the Northern Development. You said it was not addressed. Do we have an answer since then?
No, not particularly why it was the brand that was chosen, or a luxury brand in general. The applicant might be able to answer that.
We've heard different franchise names: JW, Hilton.
Mm-hmm.
I forget what the other one was. Have we seen any franchise agreements? Have we seen anything that says yes, you can build this, or you will receive this franchise agreement?
Not that I have seen. I believe through the renderings, it does show the JW, but anything, substantial, legally binding, not that I'm aware of.
Okay. Have we seen any agreements from the franchises that says if you have a McDonald's, you can also have a Burger King right next door on the same property?
No.
No. Okay. You have in 24, resort benefits for residents. So my question with this one is, and I think Commissioner Grill and Marone have also touched on this, we have a lot of answers with a lot of questions with vague answers, right? Well, how much are we paying for this? We'll see. We'll look at this. If it happens in the future, we'll deal with it. And so we have another one here where we've talked to the applicant about it, and we'll see what the future may hold. So what are the discounts? Is there going to be free parking? Is there not going to be free parking? How long are the discounts good for?
Right, I understand. That's not something staff really negotiated. If there's recommendation from the city commission, absolutely. But it's not something we really negotiated. We're looking generally that there be a program. But if there's guidance you would like to provide, by all means, we'll address it at the appropriate stage.
If we would ask the applicant to address that.
Sure. If you go back to your diagram for the site request,
Yes.
trying to understand what the green highlighted lines are.
This one here?
Yep.
It's just generally showing the location of the properties. This is not a proposed subdivision or anything like that. I just wanted to show the different developments on the site. It's not related to any request for subdivision. I'm just pointing out the different projects.
So what conversations about subdivisions have you had with the applicant?
I think it was brought up at technical review committee, not necessarily it wasn't for this project. I believe it was for the amenities there was a subdivision line shown on one of the site plan documents, and we just discussed it generally. If that's not covered under this scope, if there is a subdivision, it's required to come back before the city commission, but that's not being proposed under this development at this time.
If this were to be subdivided today, for example, would they be able to ask what they're asking for today?
There were a few elements that were brought up, and these are things, if a subdivision were to ever move forward, for example, there are requirements that certain amenities be provided on large resort district projects, depending on how the subdivision's handled. And as was mentioned in the presentation, the site is, if it were to be approved for the development shown here, it would effectively be at its maximum capacity. So there's only certain ways that the site could be divided to retain that. But it would need to be, elements like that would need to be evaluated at the site plan stage, setbacks, other items like that, we would look at that stage. But it would depend on how it's subdivided.
Can I ask a follow-up questions? Some of these questions I was going to ask the applicant. I think it's maybe unclear as to who we should be asking to who. So I had ones that were kind of clearly for the city, but since it's been brought up, is this currently one unified site? It's one plat?
It's not all one platted lot. No, it's one parcel through the property appraiser's office. But what typically happens with developments like this, it's what the city's required in the past. If they're portions of platted lots, they can be combined through a unity of title, some other kind of covenant that binds the lots together for development purposes. You see it frequently with subdivisions and other types of not subdivision, shopping centers and other types of development where they function as one development, but they might either have separate ownership or they might have different divisions for that purpose.
But to kind of go along with the mayor's question, I had the same concern that, for example, Hotel 3 doesn't have amenities so wouldn't qualify theoretically on its own, maybe definitely on its own. And so I noticed there isn't a condition that requires a replat. I'm used to requiring a replat. I don't know if it requires a replat if it's already one plat, which then wouldn't allow subdivision later on. So that's kind of, it's related to what I was going to ask later on.
That's typically something we handle at the site plan stage, by all means, if it makes sense to do so. It could be added as a condition, but
We could do-
that's where we,
Okay, we can do that as a condition, have it as one unified, under one ownership.
Would that be an unreasonable restraint on the
Well,
application of property?
Yeah, I mean, the applicant's going to probably address this as well, but what we would, there might be reasons to do something like a restricted covenant in lieu of unity of title that ties all the properties together. Sometimes that's a request because of different lenders that are involved in different parcels. I don't know. But I know that we've used documents like that as opposed to replatting it into one
Okay.
whole parcel. But
Okay,
we
well-
can, there are legal documents that we could tie it together with.
Okay, well, I would rely on your legal expertise.
Yeah.
I'm just trying to use some common sense and understanding that this is coming before us as one.
Yep.
And we'd like to make sure it's one, and that there isn't a separation in the future, which then changes things, which would have led us to not have approved this had we known that.
Yes.
And I'm
And
trying to, that's my kind of layman's way of saying that.
so I made a note of that, I know the intent of what you want. Also understand that the CUP applies to all the properties, so if they were going to make amendments to it, that's an amendment to the CUP that's going to have to come before you.
Okay,
So-
okay, all right, thank you.
Mayor, one more follow-up on that one. So then, how then, if it's three separate plats, then are we meeting the intent of the Land Development Code for a large resort district, which talks about a fully integrated resort? So is it a fully integrated resort at the building level, at the plat level, or at the parcel level?
through the, whatever document is appropriate, whether it were to be a replat, a covenant in lieu of unity of title, or possibly a unity of title, it's typically not it wasn't something I looked into for this hearing, but we've addressed it with other developments. It would be for the resulting, what zoning calls a zoning lot, basically a functional piece of property. And as I mentioned before, you have shopping centers in the city where there's out parcels, but they function as one unit. And they, a modern development of one of those would be unified in some way that is, it legally combines all the property to function as one.
So what if you, if you do that, and then the applicants decide 5 years, 10 years down the line that they sell the property to somebody else, they've got restrictions where they cannot subdivide the property, but they no longer have any kind of franchise agreements in place to let them operate 3 competing properties on one parcel. And now, not because of anything we did as a city, but it will no longer be able to function as intended.
I believe the applicant needs to address that rather than our staff.
We'll save that for them. What amenities will Hotel 2 and 3 actually have, since they won't have full service?
They will have the restaurant. I'm just getting to the list.
Because on page 26, for example, they don't even have, they have housekeeping as a questionable.
And that's because that's part of the operational standards. I mean, that would be something that we could address through and probably site plan would be most appropriate for checking off those boxes. But at least, you would think there'd be housekeeping, but it's, I guess it's not clear. So it's just things that we need to look at the appropriate stage. But I understand they would be retaining some conference space. They would be constructing the new restaurant at the rear. of the existing Serrata, and it appears they'd also be retaining some office space.
And then at the South Hotel?
I understand that's fairly limited. It's described as, I believe, a select service hotel by the applicant. It's a very small restaurant area, and then I believe there's some office space in there as well. But it would be reviewed by staff to function as one development site. It's required to be combined and function as one development site because of the request that's being made. The entire site's needed to support the 75 units an acre that's being requested, so it would need to be combined to function as one development.
Mayor, if I could add there, I think what you're getting to on that is that there needs to be some assurance that down the road it's still going to function as one site. And that's what we need to have, that assurance. So I believe that, is that what you were asking?
I'm just asking how that was addressed with the applicant, since I didn't see it as being addressed anywhere in the conditions, other than to say that. Right. There was a condition for 50% Florida trees.
Yes.
Is there a reason we didn't go higher? I know we only need 25, but
it was the balance between, more ornamental landscaping and Florida friendly. That was just the recommendation I came up with based on that. And specifically, I was along the frontages and the other required buffers where the city actually has height and diameter standards for trees. I asked for those to be Florida native specifically for ecological purposes. If the city commission has justification or a request for a higher number, I'd be happy to discuss it.
Page 43. This goes to the aesthetic architecture features, development, site layout. We don't have any renderings of most of the project. I don't know if you all noticed, but we have a couple of building on the north side. We have none of this middle building, what that's going to look like. And there's, I think, two sort of very vague renderings of building 3. So what have we done to, it says renderings attached to this report, but the renderings don't have much.
That had been what we were supplied with. There were elevations as well, but that they were the same ones that we reviewed. So.
What is going on top of the roof of the JW Marriott? It said not to exceed 12 feet, but what are the plans?
My understanding is that's a mechanical area. The applicant can speak more to that. We've discussed it's not a customer space. I understand it to be mechanical.
I think I'm good.
Brandon, are there height restrictions on rooftop, what do you call them? Rooftop features?
It's a maximum of 12 feet above the maximum height of the roof, which is 116 feet. I have spoken with the applicant about this, and they would comply with both resorts.
So what we have down on 8th Avenue is a very nice-looking building, but it has a rooftop feature that I think was, I don't know if it's for the hood system, I don't know if it's for the elevators, but it protrudes up very obtusely, and it visually really affects actually the beauty of that building and the street. And I'm wondering, I don't want to get down the road on this, and they say, well, because of the elevator shaft, because of exhaust systems, we need this, it's required by, and we allowed a certain height, and then we put this on top of it, and say, well, it's a little bit higher than it's supposed to be, but it's required by the fire marshal, the whatever. So I just don't know specifically what those rooftop features are going to end up looking like, or whether they have them built into a schematic, and the applicant may be able to answer this too, built into a schematic where we can see exactly, not what they expect, but exactly what we can expect this rooftop to look like from the street when it's done.
They may possibly have that. I do want to say that typically in most zoning districts, the permission is for a 10-foot height increase for mechanical features and items like that, elevator shaft overruns. In the large resort district, it's specifically 12 feet, but it's not 12 plus 10, it's just 12, it's an extra 2 feet. But they may have renderings, I just haven't.
Thank you.
Okay.
Any other questions for Brandon for now?
No, sir.
Thank you.
We could have Mike Clark, Director of Public Works, up to speak.
Mayor, I think as we may, are we going to swear in everyone, or?
Yeah, everybody else who intends to speak, applicant, experts, and city experts, if you could stand now.
Thank you. And just get it all done at once.
Do you swear or affirm that the information or factual representation that you're about to give or present to the city commission tonight is truthful? Yes. Thank you.
Thank you, Amber.
Good evening, Your Honor, Commissioners. Mike Clark, Public Works Director. I've been asked to speak on to the sanitary sewer system. I do have an overhead graphic. At this point, we have general numbers given to us by the applicants that are reasonable in terms of the normal types of flows that we expect to see based on rooms and the number of rooms and the kitchens and the usage of the building itself. And so we did an extrapolation of how that impacts our sanitary sewer system, and we did that on 3 levels. First, we have, the wastewater plant consideration. Then we have the force main conveyance system consideration. And then we have the gravity pipe collection system that services the buildings themselves. So I'll address those from the top down. The first is the wastewater plant itself. And we have a wholesale agreement with the St. Petersburg Northwest plant that they will service us. Our level of service is 2.9 million gallons per day. Last year, our average was 2.64 million gallons per day. So you can see we have quite a lot of space there. We're not anywhere near our capacity. This site planned increase is 59 million gallons per day. And so you can see we're nowhere close to closing the gap between 2.64 and 2.9. In fact, it's about a 3.22% increase at the plant itself. So the plant has no concerns. The next concern is how do we get the flow from our lift stations into the force main conveyance. In this case, all 3 buildings will go into one of 2 lift stations, which goes into our force main, which goes to our pump station 2, directly to pump station 1, and then off the island. It's all force main. And so from our force main, the new ones that we just built, we have no concerns about the additional flow. The force main is designed to hold the capacity of the entire city as if it was built out. Every single parcel of the city completely built to its maximum density and occupied and running. This force main was designed to handle that, plus a safety factor. So we do not have any considerations or concerns about our force main conveyance system. The third level is the gravity collection pipe considerations. There are 3 buildings that are being proposed. You can see them here, 1, 2, and 3. And the blue arrow shows where we might perhaps see the lateral coming from the building, servicing the entire building regardless of what's in it, coming into a manhole on a gravity collection pipe. Okay? And so I'll address these one at a time. So building 1, which is the JW on the north, that's expected flow of 162 gallons per minute, added with building 2's northern expected flow of 25 gallons per minute, is expected to flow into the same manhole number 338. And from that manhole, it will flow 1 section of pipe to a pump station, or lift station 19, which has 650 gallons per minute of capacity capability. So you can see that 162 going into a 650 capacity, we really do not have a concern here, there at all.
Where is lift station 19?
The station 19 is here.
Okay.
And station 20 is here on the south.
And Mike, while you're pointing, who owns the blue line? And then can you talk about that, I assume you'll talk about the green line in number 2.
So the lines connecting the buildings, the blue and the green arrow, they will all be the property owners. That's the property. That's their private service. That's their private lateral. Very similar to all of our homes. Where you flush your toilet to bring it out to the city main in the street, that's your private lateral.
Okay, thank you.
So moving through building 3, their expected flow of 73 gallons per minute is expected to flow into manhole 322, and then through 4 successive pipe sections with a maximum flow of 1 section being 110 gallons per minute, which is the last section right here. So the sections of pipe are between the manholes themselves. So it enters at 332. This section is a section of pipe that has 282 gallons capacity. This section of pipe has 250 gallons capacity. This section here has 200, and this last section has 100. And so you can see that if Building 3's flow is the only flow that goes to that particular lift station, then it does fit in capacity. But we would want to take a closer look at that when the numbers actually come in. This is just still very high level, very general. It is possible that the developer would consider the flow from building number 2. It could go in either direction. If the flow from number 2 at 126 gallons per minute here goes this way, then we do have a constriction problem. And that's where the conditional comment was made. If that is the way that the developer would like to flow that conveyance, then there will have to be some considerations about the pipe sizing to get that flow into the lift station. The lift station can handle it, but the pipe is too small. Alternatively, they could go to the north, and through that manhole section, those sections have plenty of capacity, and the lift station can handle the flow. So at this point, however the developer wishes to bring forward their design, we will work with them and come to the engineering conclusions that will provide us with the solution that we will require. But in no case do I see a situation where we have any concerns as to whether or not we are capable as a city of handling the flows from this development.
And well, thank you for that. And the evaluation that you mentioned, which way it will go, north or south, at what point is that done? Is that at site plan, after site plan?
I would expect to see it at 30% design site plans, first site plan design review meeting. I would expect to see a decision from the developer as to which way they want to go. But I would leave that up to the applicant as a more specific answer.
Thank you.
Mike, where's the slide in the presentation?
It is not. This slide was created based on information that I've been receiving over the last week, and updates along the way.
Because the slide that we have in the presentation shows vastly different numbers.
Yes, go ahead and throw that one away. This is your new slide. I can only deal with the numbers that I'm given.
Okay. So,
But the more recent numbers are the more accurate numbers.
The recent numbers are more accurate. They show a very simplified version of the very complicated situation. But I do not believe that the conclusion that has been reached has changed. It has always been that we can handle the flow. They may have to do a modification of the pipe in order to make it work. That's always been the case. This is just better numbers.
well, the difference is the flow added on your slide is half the flow that's added in the slides that we have in the package. So is their flow somehow decreased by 50% in their metric somewhere?
No, I think it's the other way. So these numbers here do not take into consideration the flows that exist right now coming from the structures. We don't know what those flows really are. These numbers are flows based on what the structure's capacity, the number of units, the number of rooms, what does a kitchen produce. They're very general in nature based on the number of units and fixtures and kitchens and things that are expected in a building of this size. But again,
I'm just looking at building 3 slide. We have 160 gallons per minute. Your slide has 73. That's less than 50%. Building 2, 340 versus 126. That's almost a third. Same with building 1. Half of what is on your slide versus what's on our slide.
So just for clarification, Mr. Clark, who came up with the two sets of numbers?
The assistant public works director and myself. But we attempted tonight to simplify this conversation because the other slides, they can be complicated. The flows that we're showing, the 162, 126, and 73 GPM, are what's expected from the building based on its proposed. Doesn't take into account anything that's there now, because that really doesn't matter. What are they going to push into that pipe, and can that pipe take that flow? Very simple question. And so that was our attempt, Brett and I's attempt this afternoon through the last couple of days, was to break this down into that very simple question. What is that building going to produce, and can that pipe take it? And the answer is what you see here. And I will say that as we go through the planning, I fully expect these numbers to change again.
We got to make a decision based on these numbers today.
Based on these numbers today, I'm very comfortable in recommending approval.
Yeah.
Ultimately, this is a process, and probably people don't understand it's a process, because I'm an architect, so I'm kind of used to going through this process. And there are industry numbers that you use and plug in the beginning, and they have to be verified over time. I would expect, though, that the applicant's plumbing engineer and combined with their civil engineer are going to be ultimately responsible for the numbers that you have per building right now that will flow into our pipes.
Absolutely.
Our pipes are our responsibility, their pipes are their responsibility.
Oh.
And ultimately, the most important thing is that there's a condition that says if something needs to be done that's going to cost money, they're going to be the ones that do it and not us. And so I know it's kind of hard to, grasp these numbers and it's engineering, but this is not unusual in this flow. I'm going right through the same thing in a project right now, and there's kind of debate about the numbers. But in the end, we just need to make sure it works. And if it doesn't work, it's not our issue. It's the applicant's issue.
That's absolutely correct, and that's why that condition is in there. I could address stormwater, but it's a little bit simpler than this based on the applicants at the presentation at the TRC. It looks very obvious to us that they are able to hold the 24-hour, 25-year storm on their property without flowing onto adjacent properties, which is illegal. And above that, of course, the DOT conveyance system has to take it. But they are, at this point, we see that they're in full compliance with our code. And I don't see any issues with Swift Mud or the Florida Department of anybody else.
Mike, can you clarify, is Swift Mud's requirements more stringent than the city's requirements, and they will have to go through Swift Mud?
They will have to go through Swift Mud. I think part of that has to do with their property being adjacent to the beach also. We have to show that they're not going to discharge onto our sands. But I cannot at this time right now answer your question with precision, so I prefer not to.
Okay.
Those were my two items. If there's no other questions, I think I'll be followed by somebody from the fire department.
Thank you, Mike.
Thanks, Mike.
Do you swear or affirm that the information and factual representation that you're about to give represent the city commission tonight is truthful? Yes. Thank you.
Good evening.
Good evening, Chief.
Jim Kilpatrick, Fire Chief. I was asked to speak on the master plan that we proposed for this project. Just to give you a brief kind of definition of it. Master plan is an organizational planning document that draws from public engagement as well as through assessment of the operational environment to frame resource allocation decisions. Organizations of all types utilize these documents to proactively guide decision makers and develop effective strategies to address challenges related to sustainability, funding, and resource allocation. This document will include specific areas such as service demand trends, that will analyze items such as unit hour utilization and concurrency. Population projections will also be utilized to analyze potential service demand increases. The proposed master plan will be comprehensive and community-centric. During the process, public outreach is completed to refine and prioritize the community's expectations. Priorities are then set along with associated strategies to achieve them based on available funding and other criteria. The overall term of a traditional master plan is 10 years. With annual work plans being developed based on collaboration with community development, community and department partners. So that's a brief description of the master plan that we're proposing, and we feel like that is a good vehicle to assess where we're at and where we need to be in the future. I'm available for questions.
Questions for the chief?
Actually, I have one that's actually from a resident that asked me to ask this, and I didn't know the answer, but I knew I was going to get to talk to you tonight. Emergency management and hurricane evacuation provisions. The question generally presented was, what tools will the city have to enforce an emergency evacuation of these hotels when these folks are told it's time to evacuate? I see in here on page 45, subsection 8, talks about 5.22 requires that, and I'll say this, Pinellas County countywide rules, section 5.2.2. Requires that all new uses in evacuation zone A prepare a legally enforceable covenant stating that the lodging use will be closed as soon as practicable after a hurricane watch is issued. The applicant said they'll comply with that policy, and the resident asked, what enforcement provision does the city have to ensure compliance and/or penalty? And I said, I don't know. I see that there's a covenant. Covenant is an agreement. The covenant is a promise. So I don't know if there's any penalties, and maybe the penalties are included in the Pinellas County countywide rules.
That might be a question for Andrew, but I do know that the county is the one that dictates the evacuation. We've enforced it through the Pinellas County Sheriff's Office. We also go out in our vehicles and announce it. So I don't know what penalties there would be if you didn't evacuate. You know, as with citizens, they choose sometimes not to evacuate at their own risk. So we go, you know, location to location and try to verify that it's evacuated.
Chief, is it correct, I've been told, and based on your experience, that the transient lodging facilities, hotels, will, during evacuations, typically evacuate their guests earlier because they then also want to make sure that they take care of their staff?
Exactly, and as Commissioner Marone just stated, it's at a hurricane warning. So, you know, they're out earlier than most. So typically, we have some people that linger longer than they should, and usually the hotels are compliant and out earlier than most.
And is it, and maybe this is for the city manager, also from there have been discussions about evacuation and numbers, and are we bringing too many people onto the island? My understanding is that, and city manager and city attorney, you both were here, and as was Commissioner Frizlowski, when the comprehensive plan was put together with the numbers, the max numbers, one of the considerations was evacuation and how many people should be on the island, assuming it's built out to max. How many can you evacuate if Zone A is evacuated, or is that urban legend? Does anyone?
I can't answer that.
Yeah, I don't have the information on that.
Okay. I mean, that's what I had been told, that the county looks at numbers, because you don't, for example, you'll put 1 million people here, you'd never get 1 million people off in an evacuation. And I'm making up the number. We'd never do that, of course.
I would just say our most effective way of encouraging people of getting off the island was when we told them we were going to be shutting down the sewer system. That got everybody's attention really quickly, including our residents, who tend to stay at times.
Chief, how will emergency services be accessing the beach in case of an incident?
How will emergency services be accessing the beach?
Like if there's a incident in front of this property, how are they getting there?
Through the site review process, we're developing access points. Currently, I think we're in preliminary kind of site review. Fire marshals assuring that all those access points are there and appropriately designed for us.
And then I'm seeing some really narrow driveways here on this property.
Mm-hmm.
And you've got some really big trucks.
Mm-hmm.
How are you, if you had to get to the front of one of the buildings, the front being the beach side, the west side,
Mm-hmm.
how are you getting there and how are you getting out?
On the sand, on the sugary sand, we cannot get to that side with an apparatus. There is no way to get to that side. I wish there was, but there is not. We've had some review of the site plan, as I mentioned. I know the fire marshal has corrected some measurements and is addressing those as we move through that process.
So you're getting in on, let's say, between the C-Mark and the
Mm-hmm.
Hotel 1.
Mm-hmm.
How are you getting out? I'm just looking at the scale that I have here, right? It looks like your truck is bigger than the turnaround.
Yeah, there is a three-point turn designed into the any of those accesses that exceed 150 feet. I'm sure there's some renderings in the site review that the fire marshal might have or could provide or discuss.
Fire marshal's here.
Yeah, anytime that there's a road and it dead ends and it's greater than 150 feet, by code they have to provide a turnaround. So right now, since it's in the CUP process, we have reviewed the majority, but all the details and the turning radiuses and all that and the width of the road, we are going to look into it more thoroughly during site plan review. But they are aware of the requirements.
And what happens if you can't turn around?
It won't. It's going to be addressed during site plan review, or else the site plan cannot be approved.
Kelly, I'm sorry, for the record, could you just introduce yourself?
Kelly Inces, Fire Marshal for the city.
Thank you, Kelly. Chief, can you give us an idea of what your call volume generally has been the last 5 to 7 years?
I can give you some data from fiscal year 19 forward. Within the city of St. Pete Beach, there have been fiscal year 19 were 2,422 calls. Fiscal year 20, 2,562. Fiscal year 21, 2,655. Fiscal year 22, 2,844. To go along with that data, I can tell you that we've listed resorts along the beach, included all the resorts along the beach, and generally the call volume that goes to the resort areas is between 23 and 27% of those calls, which are strictly within St. Pete Beach. With mutual aid, automatic aid, we can respond outside of the city. The call volume is higher than that, but this is within St. Pete Beach.
And then you have numbers on this year, cumulative?
This year, I do not have this year's numbers with me. I can get those.
So that's roughly a 20% increase, 25%
Yes, sir.
in the last 4 years?
But keep in mind that is within St. Pete Beach.
Yeah.
And the 23% of the calls you said were to resorts within the beach, primarily fire or EMS?
That's all calls. So it'd be fire and EMS.
And do you know the split?
I don't have that with me, but I can say generally that it's about 80-20.
Right. 80-20 for?
80% for EMS, 20% for fire.
Thank you.
And then in 19, how many personnel did you have?
In 19, we had 33 personnel.
And then 20, 21, 22?
33 personnel.
For all those years?
We just added these one position, 3 personnel this year. They're in their administrative week. They have not even begun to staff units yet.
But we don't know what the numbers for 2023 are.
No, sir.
Okay. So in 22, we had 33 fire.
I'm sorry, Mayor.
In 22, we had 33 total personnel. I'll say that 5 times really fast.
Yeah.
So 2020, 2022, we had 33 personnel.
Correct.
How would you characterize your current level of service?
Adequate.
Adequate. Do you have room for capacity?
It's hard to tell at this point. I believe so, but, it's based on, there's a lot of drivers for call volume, geography, events, natural events, So, for instance, we had 26 calls at Station 22 for stingrays. That's just something that occurs out of the blue sometimes. I can tell you that the next data-driven focus group meeting at the county, one of the agenda items is, the drivers at call volume. The drivers of call volume, what drives call volume up? They had a day where they had 650 transports in Pinellas County out of the blue. It just, something occurs, and they don't know if it's because it's a Friday or because of, what is doing it. So we as a staff try to iron out those data points, but I can't tell you definitively that it's because of X or Y or Z.
So your level of service, you would characterize as adequate, and that's with the 3 additional individuals that were hired?
I'm sorry, you said the 3 additional personnel, that, I feel like with that, we are adequate at this point.
Okay.
But adequate, but meeting, I mean, we had these, I mean, just to clarify, because I think people are pulling out their dictionary now and looking up the definition of the word adequate. We had these discussions during the budget review, and you are meeting the requirements of the county and the guidelines set by the county for response time through mutual aid, through what the shared service work that's done between the surrounding cities to meet those parameters.
We're exceeding parameters set by the county for response time. There's a 7.5-minute response time, coming in at just over 4.5 minutes on average, so.
Okay.
Chief, if this project is completed, will you have enough staff to service it?
It's a hard question to answer, because,
Because I think that's kind of the $64,000 question,
Right.
is what impact will it have on the fire, with the services?
I think this master plan is going to help establish what those potential stressors are going to be on our department and on the system, and they're going to be projections. So I would say, as we stand here today, I feel like we do have the adequate staffing now, but I can't tell you what call volume increases may occur in the future. I don't think anybody predicted COVID. I don't think anybody predicted some of those other things that occurred to us and the spikes after COVID that drove a lot of overtime and a lot of staffing issues that occurred. So,
Thank you.
And Chief, I'm sorry, but I will put you on the spot. That your statement that you can't analyze that now, you don't know now because there's too many unknowns. Is that unique to this project, or would you say that for any project that we'd be talking about for the future?
I think it's for any project, because you cannot establish what call volume will occur based on a number of rooms. It's very difficult. And I spoke to a gentleman at the county today about it. I was trying to get more perspective on it, and there weren't any hard answers there. So.
Thank you.
And if you had to hire more personnel, where would you put them?
I would put them at Station 22, I believe, on Squad 22.
Okay. Is there adequate space there now?
Space?
Well, yeah.
No, we'd have to put them in
3
bunk
people. We
beds.
got to put them somewhere, right?
Yeah, Station 22, built 1974, built for a different time, a different call demand and call for service demand. But I think at this point, I think we're okay. But it all depends on how, our staff responds to stressors of overtime and such that, PTO, sick, so we have a little bit more bench depth now with these extra 3 people. So I feel like it's, I want to see how that plays out. And as soon as they get on board, then I'll have more information for you to tell you that, we're good or we need more. So.
Any other questions for the chief?
None for me, thank you.
Thank you, sir.
Thank you.
Thank you.
Do we have any other staff reports?
We also have our transportation consultant who, if the commission would like them to speak, I'd be happy to introduce them.
Mayor, I'd request a 5-minute or 10-minute.
But
We wanted to see if we had any more staff.
But before we do that,
If we don't have any, we can.
should we not,
I'd rather have a break
Yeah.
before we have any more, if that's.
No, that's where I was getting.
Okay.
just if I may, should we not hear the transportation presentation from the applicant, then hear from our
Yes.
experts on transportation?
Yes.
Okay, and yes, let's take a break.
All right, 15-minute recess.
Nobody on the road. Go back to that. It'll look better.
Things are much calmer.
All right, will the applicant come forward?
Good evening.
Evening.
Good evening, Your Honor, Commissioners. Elise Batzel with Stearns Weaver Miller. Could you, oh, you already have it pulled up. That's great. So before we start, I wanted to bring Joe Young up. There were some questions about legal entities and financial capability. So I thought having Joe Young, who he and his father are here from Columbia, Sussex, he can talk through the different legal entities, Columbia, Sussex, the parent company, and the company that owns the property, and also talk about financial capability as well as technical capability, and then we'll move more into the project. And I do just want to briefly say that most of you watched the planning board meeting, and so you're going to hear a lot less from me tonight, and you're going to hear a lot more from our experts to answer those questions that you posed tonight, and to get more technical data on the record. So hopefully, if you allow us to get through, we will be able to provide you with most of the answers to your questions.
How much time do you anticipate needing?
I don't know. We spoke for an hour and a half at the planning board meeting. Hopefully, it won't take that long. Wasn't it like an hour and a half? 2 hours?
Excuse me, if you'll please allow the person at the podium to speak, and when it's your time, you'll be accorded the same courtesy. Thank you.
We'll try to be efficient and go through stuff quickly and not repeat some of the things that Brandon has spoken about. But the level of detail of your questions, we do have a lot of technical expertise that can go ahead and answer those for you, and hopefully also preempt a lot of the questions that you might also have.
Thank you.
Thank you.
Hi, Joe Young, 648 Canterbury Drive, Edgewood, Kentucky. I am Director of Development for Columbia Sussex Corporation, a title that I've held ever since I was in college. The Columbia Sussex was started by my dad 51 years ago, and he's here today. He's 83 years old and still runs the company. So he started by building a 60-room Days Inn down in Richwood, Kentucky. I still remember as a kid, I was about 10 years old, going down there when he was pouring the footers for that hotel. So this is 100% a family business. While we're on that subject, Vice Mayor Grill, to answer your question regarding ownership. The ownership of our company is very simple. Although it does get complicated, the ownership is very simple. It is my father, my mother, my 6 brothers and sisters, and I. There are no outside investors, no partnerships, nothing of that sort. As it relates to the entity that owns Serrata, typically you will do a single purpose entity for the purpose of financing. So, and then that entity is owned by Columbia Sussex or one of its affiliates. So there's no games being played. We're happy to be completely transparent with how the ownership of that works. So after my dad started with Days Inns, he developed about 20 Days Inns, moved on to Holiday Inns after that. From that point, moved on to Marriott's and Hilton's in the 1980s. Today, we have 14,000 rooms that we own and operate in the U.S. and in St. Martin, which places us in the top 5 full-service hotel owner-operators in the United States. We successfully developed hotels in the Caribbean, in St. Martin, and the Cayman Islands. In the U.S., we've developed hotels in 18 states, including New York, Alaska, California, and Florida. We're actually Alaska's largest hotelier. In round numbers, we currently own and operate approximately 11,000 Marriott family rooms, 1,000 Hilton branded rooms, 500 Hyatt Regency rooms, and the Serrata, or one independent hotel. The North Hotel will be a JW Marriott. I think that question came up. It will be a JW Marriott. I have the license agreement sitting on my desk, ready to be signed. So we have an agreement with them, and it's ready to go. And we were Marriott's.
Excuse me, do you want us to ask questions now? Do you want us to wait through the presentation?
Shoot.
Okay. So you wouldn't mind having that as a condition?
A JW Marriott?
Yeah.
No, that's fine.
Okay.
Yep. In addition to this property, we're developing a hotel, a JW Marriott in Naples, and developing ready to open a JW Marriott in St. Martin, which will open in a couple of months. As I sat here and heard some of the questions as it related to the procedural issues, I got the impression that you guys thought we were trying to pull a fast one with this CUP for the pool. It couldn't be further from the truth. First of all, we don't really consider that pool to be a rooftop amenity, a rooftop pool. It sits on top of the parking garage, certainly not on the roof of the building. It came up in TRC that, hey, it is on the roof of something. Maybe it does need a separate CUP. And just as an abundance of caution, we decided, okay, fine, we'll amend the CUP to include this. But as to the people that it affects, which would, I think we could all agree it would be C-Mark at the most. I mean, I met with Mike Gordon and Tim Yarnell on January 5th, showed them plans that included the pool and generally the way it is. Our architect and myself, we were at a C-Mark board meeting virtually February 21st, and they all saw that. And then certainly at the community meeting, I can't tell you that I said it at that meeting, but certainly we weren't trying to hide the fact that there was a pool there. And I think you have to assume if there's a pool, you're going to be eating and drinking by the pool. But maybe you don't have to assume that, and shame on us if we didn't say that. But I'm pretty sure I was clear on that at that meeting. So it's nothing we've tried to hide from anybody.
Mr. Young,
Yes.
this is in your package. This is what was provided at that meeting, and it doesn't even have a pool. I'm not saying you're trying to hide anything. I'm simply saying at the second meeting, this is what's in the package for today, and it doesn't have a pool on.
At the second meeting.
Yeah. So
What's the second meeting?
well, you had two community meetings.
Yeah. I wasn't at that meeting.
No one's saying you're trying to hide anything. I'm simply saying
We
it's.
had renderings at that meeting, and I think you were there and you would have seen them.
I was at the first one, yes.
Yeah. Did you see the renderings at that meeting?
I don't remember the full detail. It was a 2.5-hour long meeting.
Yeah, but, I mean, we weren't trying to hide it from anybody.
No one's saying it is. I'm
And that's a
simply-
site plan.
Yeah.
That's not a rendering. So, okay. Yeah, so the reason we're going to make this a JW Marriott is there's clearly a demand for a luxury property here. Being not so well provided for at the Don Cesar now. It's an aging property. It's hard for that to compete with new properties. So, yeah, we think it's ideal for this. And I also like to point out, this is the addition of 264 rooms on this site. And certainly a significant upgrading of all the other rooms on the site. So I think we've gotten past that this is the addition of a kind of a medium-sized hotel, not a 650-room behemoth. I mean, most of the rooms are already there right now. Oh.
What is the other brand?
Say again?
What is the other brand hotel?
More than likely, it will be a Hampton.
And when will that decision be made?
I mean, I can tell you in our mind it's a Hampton, But it will be a Hampton or a brand like that, similar to that.
When you have a franchise agreement with a JW Marriott, did they have certain technical requirements for building size, rooms, size of rooms, amenities?
I mean, a book of them. Yeah, our architect can speak to that, but yeah, it's enormous.
Commissioner Grill, you had some questions?
I'd like to hear this, go through the presentation first.
Okay.
Thank you.
Thank you. And Commissioner Frisowski, as his lawyer, I would suggest that he has, say, a Marriott, or, since he hasn't signed the documents, or other similar luxury brand, because you never know what happens tomorrow, and I just don't want to box you into a corner.
I don't know. We'll talk about that when we get to the conditions.
Fine. So we all know where the property is located, between Seamark and Bellwether, within the city's Gulf Boulevard redevelopment district. It is 15.45 total acres, and that's 8.6 acres landward of the coastal construction control line. You'll hear a lot more about this in the presentation, but the current zoning and future land use are large resort. And the city's comprehensive plan, for those of you that have read all of it recently, specifically encourages exactly this type of development within the large resort district. The adjacent properties are large resort activity center, as you can see across Gulf Boulevard. So within the community redevelopment district, your comprehensive plan outlines 4 distinct character districts. We're going to provide some expert testimony on that, but it is also within that large resort character district. So we are reducing 156 units that are currently on the north side of the property. That's total. That results in the Serrata being 226 units. We're redeveloping the existing pools and restaurants, demolishing and redeveloping portions of the existing resorts. As you've heard, there will be a new JW Marriott or luxury hotel with 290 units. And the new Hampton Inn or similar select service hotel will be 130 units. Now, the total units will be 646, but I think it's really important for everyone to note that that's only an addition of 264 units. We're talking about massive development. That's less than the size of the JW or similar hotel itself. So just to show you the existing conditions.
Ms. Betzel, I apologize.
Yes.
Are you providing testimony or?
I'm providing factual testimony. Yes.
Okay.
Well, wait a minute. I mean, it's just facts. It's just facts that are
Yeah.
part of the application.
I'm not.
You can't, this is not an expert testifying to you all.
We have experts that will present. This is facts about the application.
Sure.
Was that it?
That's it?
Okay. So all of the red represents the buildings the transient lodging units that we're demolishing. So as you can see, there's going to be substantial redevelopment on this site. It really does help to see all of the areas that are going to be demolished. That includes the 156 existing temporary lodging units that exist, as well as the restaurant and the pool located on the southern portion of the site now. Those will go away. The 98 units that are currently on the northern property boundary, that comes down completely. And there will be 58 units that come off of the Serrata as part of the redevelopment. So the colored site plan, I think, is really helpful when you're looking at all of the individual pieces of the site plan. And I'm going to go through these individually just so that everybody sees where everything is on the site. So the new restaurant and pool will be directly towards the water from the existing Serrata or the renovated Serrata Hotel. This is obviously the Serrata Resort that will be renovated, a new porte-cochere, and some other architectural details. To the north is the JW. And this is where the rooftop amenity pool is. It's easy to see here, but Obviously, you can see that it's been located more internal to the site rather than on the exterior perimeter. The Hampton Inn or Select Service Hotel is the smaller hotel on the southern boundary of the property. And here's something we're going to talk a lot about when our civil engineers come up, but they really did try to design a project that took all the queuing that's happening right now on Gulf Boulevard and bringing it all on site so that any kind of stacking completely goes away on Gulf Boulevard. We do comply with parking per the code, so I think we exceed it by just a few spots when this is completely redeveloped. And as you've already mentioned, we're providing a number of beach access points. So right through the middle is an oversized beach access. As you know, there's the 4 feet on the northern boundary that is actually not on our client's property. It's owned by the property across the street. And staff has added to a condition, I don't know that Brandon spoke about it, but added to the condition of development that we would incorporate additional beach access to the north if the city is able to get a public beach access prior to us building all of that. We go ahead and expand that onto our property. So there is a condition that deals with that on the northern boundary. So if the city, if it aligns, obviously that would be a 3rd public beach access. Now, we talked a little bit, and we'll talk more about it when we talk. Yes,
Just to clarify, that's along the northern edge?
Yeah, so it's not shown here because
Right.
that 4 feet is along the north.
Yeah.
But if you look at, Kevin, you can see which condition it is. But there's specific language.
No, I read the condition.
Oh, okay.
I just want to clarify my own mind. It's the northern edge of the property.
The northern boundary, yes. It's a little hard to see here, but we've sort of conceptually put in here, right next to the coastal construction control line, the boardwalk easement that you have asked for as a city for the public boardwalk project. That's the general location. And just to clarify for the record, the 15-foot public beach access that is landward of the mean high water line is intended to be, in addition, outside of the wet sand. So it's not going to be in the water. No matter where that wet sand is, we've got 15 feet to traverse. And we'll make sure with the city attorney that whatever the language is in the easement, it is extremely clear that it is landward of the wet sand so that people can traverse it no matter what happens with the tide and everything else. So you ask a lot about heights. I'm sorry these are all blue, but we're fairly limited on our PowerPoint. We'll figure that out as we become a little more technical. But you can see that on the northern hotel, the very skinny area along Gulf Boulevard, that is only 34.5 feet. So it's a very low area of the hotel that's fronting on Gulf Boulevard. The parking garages, which are in the second blue color, the medium blue color, those are at 64.5 feet. And then the T-tower, kind of acting as that buffer to the internal amenities, that's at 115.5 feet. The southern boundary is, the Select Service Hotel is 84 feet, the same as the parking structure that will be there to service the facility. And just to put one point onto the record, we talked a lot about these different hotels. This is one CUP. It will be one zoning lot. We're happy to put a unified site plan covenant on as a condition. That was always our intent, and we assumed that would be requested at site plan approval, just like we've done with many other developments that are all developed as one big piece. So if, for example, they want to take a piece of that and have a different entity hold it for lending purposes, it's one zoning lot for development purpose. So these properties become married to each other forever. I kind of like to say it's a marriage because you're tied together and you have to redevelop together, and your densities and intensities all go together as far as the zoning code goes. This is just a visual of those heights in relation to the C mark and the bellwether. It also lists the number of stories. So there's 3 conditional use requests. One relates to permitting development landward of the coastal construction control line above the 30 temporary lodging units in accordance with 35.3B1, to permit the development at a maximum building height of 115.8 feet above the base flood elevation in accordance with 35.3B1, with allowances for decorative features in accordance with section 35.8A3, that's the 12 additional feet that we talked about earlier. And finally, permitting a rooftop pool amenity above the parking garage over the southwest portion of Hotel 1 that includes dining, drinking, and/or outdoor music in accordance with 35.3D3. If you notice, we limited that condition specifically for the areas on the site plan that are above the garage and notated. If in the future anyone wanted to do another rooftop amenity on this property, we would have to come back before you for an additional conditional use permit, and that's specifically specified in the conditions that are proposed by staff. So we've talked a lot about what the criteria are, but it's really important to talk about that the commission tonight, particularly after you hear a lot of the testimony from the community about where they want to see things go in the city, to be reminded that your job tonight is to follow your current comprehensive plan, your current land development code, and to determine if we have met our burden to show that we are meeting the criteria set forth in 4.4 and 4.12. In fact, this hotel redevelopment is specifically encouraged by increasing density and height for temporary lodging uses only. Your comp plan says they're not encouraging those densities for residential because of all the things that you've heard about with EMS and everything else, and we're going to talk more about that with our experts. Exclusive residential use development is strongly discouraged by decreasing permitted densities and prohibiting any additions, is what I think I'm missing a word there. Sorry about that. So the CU process essentially creates this roadmap for us, right? When we as developers look to buy a piece of property, and I talked about this at the planning board, the development community comes in and they look at your regulations, your land development regulations, and they say, where is the city directing me to put this development? And they come in with an investment in the community, and they look at your codes, they look at your comp plans to determine where to locate their projects. And they purchase property based on that, because those are the guidelines and the roadmaps as to where you as the city have told the development community that you want to see this type of development. So there are some general standards and there's some specific standards, and I'm quickly just going to overview them and turn it over to our experts. The general standards apply to any conditional use permit within the entire city. Those are the standards under 4.4. Consistency with a comp plan, compatibility, transportation, parking and loading, public health, safety and welfare, financial technical capability. They apply to any conditional use. In 4.47 specifically, it says you also have to comply with other criteria in the code for more specific districts, which basically means the criteria set forth in 4.12, which applies to the community redevelopment district. And we have to comply with all of the large resort district criteria and policy. So that's our world tonight, right? Do we qualify with the criteria of 4.4, 4.12, and the large resort district policies? So 4.12, because it is more specific, it talks specifically with respect to the impact to the adjacent properties and the surrounding area. And it's a little different than 4.4 because it says that the development, and I'm paraphrasing, cannot have unreasonable or disproportionately negative impacts imposed upon adjacent or nearby properties. So that doesn't mean that this development is not going to have any impact. That's, of course it is. I mean, new development is new development. But the standard set forth in 4.12 is that unreasonable or disproportionately negative to the surrounding owners? And that's really the question for the evening. Have we proved our burden that that's not the case? So we're going to provide this roadmap after every expert, because I know sitting here listening to all the questions that it's really difficult to determine, are we meeting everything? And so what you're going to see is, we've talked about 4.4A6, financial and technical capability. So after you have each speaker, we're going to check off the criteria to make sure that we've provided you with sufficient evidence that we're meeting all the criteria. So with that, I would like to introduce our first expert witness, Ms. Cynthia Spidell. And I would ask her first to state her name on the record, her qualifications. A copy of her resume is already entered into the record for your review as well. But she's obviously here to answer any questions while she's up here, as well as give her presentation. Here is your
Good evening. My name is Cynthia Spidell. I'm with Stearns Weaver Miller, located at 401 East Jackson Street in Tampa, and I have been sworn. I am an AICP certified planner with over 18 years experience in both the public and private sectors. My public experience was at Pasco County and includes just under a decade in the planning department as the county's senior planner and DRI, that's Development of Regional Impact Coordinator, and followed by a stint in the Office of Management and Budget, where I budgeted a capital improvement plan. Tonight, I'll be going through an overview of my planning report and findings. And this was relatively easy report to write, thanks to your well-written comprehensive plan. My next few slides will demonstrate the essence of this project's consistency with your comprehensive plan in terms of compatibility, scale and massing, character, and redevelopment versus the perception of overdevelopment, and satisfaction of the conditional use criteria in the Land Development Code. So the first factor I considered is what is surrounding the resort. The proposed redevelopment is large resort, and the C Mark to the north, which is a residential condominium multifamily, and to the south we have the Bellwether, which is also a large resort. So in planning terms, we would call that a like-to-like use. There is a pattern of height and scale that demonstrates compatibility. This is an aerial view of the immediate surrounding area, and as you can see, at 75 temporary lodging units an acre, what we are proposing is an amount consistent with what is around us. The Bellwether, which is a large resort, and like I said before, deemed to like use, has a temporary lodging unit density of 78 units an acre. And then we have the C Mark residential condominium to the north, which is at 63 dwelling units an acre. And note that residential condominium is discouraged by your comp plan on the west side of Gulf Boulevard. So I'll go into more detail about that later in the presentation, but bottom line, it summers down to directing population away from the coast and economics. So my report goes into a great depth analysis of all the regulatory documents that apply to this redevelopment. But this slide shows how you go from the general to the specific. So you start with the countywide plan, and then you go all the way down through all the applicable regulations to the large resort character district. The proposed redevelopment is in an area specifically designated for redevelopment. That is the Community Redevelopment District. And within the Community Redevelopment District, we are located in the Gulf Boulevard Character District, which encourages, Gulf Boulevard Redevelopment District, which encourages resort and discourages condominium residential on the west side of Gulf Boulevard. Then digging into the Gulf Boulevard Redevelopment District, there are character districts, and our character district that governs this redevelopment is large resort. So I'd like to take a moment to really dig into why large resort is large resort as a defined character for this district. And the comprehensive plan describes that in great detail, how the city had suffered detrimental economic loss in terms of hotel rooms, tourism jobs, vacancy rate stagnation, and that St. Pete Beach is at risk of decline of commercial investment. In particular, the comp plan addresses the economic disparity between residential condominiums and temporary lodging by seeking and incentivizing the supply of hotel rooms relative to residential condominiums. So the comprehensive plan is your official statement of land development policy. The comprehensive plan defines the character district as large resort. More simply put, it's large resort and a large resort character district. It is a primary use, and the desired outcome is to redevelop and revitalize. During the planning board meeting, we did hear a lot of public testimony from residents who feel disproportionately tax burdened, and your comprehensive plan agrees with that stance, but sought to change it. However, Despite the comp plan's best efforts, redevelopment has not occurred until now. And since this is really the first major redevelopment to occur, I'd like to take a few moments to demonstrate why. So it may seem like the intent to redevelop has been a directive in your comp plan for some time, but it never really had the chance to launch. And this is why your residents are still feeling a sense of frustration. And I could go back to the beginning of time, but I'm going to start in 1999, where the state intervened and required the city of St. Pete Beach to direct permanent residents away from the coast and to develop strategies for post-disaster recovery and redevelopment to protect the economy. So then in 2008, that's when the Community Redevelopment District and related character districts, as outlined previously, were created. But due to challenges and a series of amendments, the remedial plan was not adopted until 2015. So as part of the remedial plan, the city was directed to do infrastructure studies, assuming ultimate maximum build-out growth rate assumptions in the comp plan. And as a result, sewer came up deficient. Oh, wait, I gotta go back, I'm not done. So then in 2016, we have the sewer moratorium. So this issue wasn't really resolved until last year. So as you can see, your comp plan, your residents, and the business community never had a chance to effectuate the comp plan. This is the first real opportunity to effectuate what you have been trying to redevelop, revitalize, and ultimately shift the tax burden as originally contemplated back in 2008. So as I said before, there really hasn't been an opportunity for the comp plan to achieve its goals and objectives. But now let's look at the definition of redevelopment in the comp plan, and it could not be clearer. It is specifically defined in the dedicated section of the definition section of the Community Redevelopment District, and it is the conversion, relocation, reconstruction, structural alteration, or enlargement of any existing building and/or use. And from a planning perspective, this is very important because it specifically addresses and covers both size and use. So what does that mean? It means that redevelopment is the means to improve the economics and coastal resiliency, and the two are essentially intertwined. And this proposed redevelopment will replace obsolete and aging buildings, which in turn will attract and revitalize business. As our engineer will go into, the replacement of structures will improve infrastructure for stormwater and utilities, and that also will help resiliency. So by allowing temporary lodging, this reduces permanent residential population away from the coast. And so what is the purpose and intent of the large resort district? Again, your comp plan quotes $2,007 because it was from 2008, but the local tax revenue quoted is 88% residential and 12% commercial. Your comp plan specifically states that this trend must be reversed or the residents will continue to shoulder a disproportionate tax burden of the city's operating and capital costs with no alternative sources except property taxes, special assessments, and user fees. And to quote your comp plan, to achieve this tax allocation correction and shift a greater tax burden back to commercial properties and away from residents, commercial reinvestment and redevelopment must be encouraged through regulatory means. By increasing density only for temporary lodging uses, this will stimulate reinvestment and revitalization of tourist lodging uses and discourage or limit redevelopment of residential uses. This regulatory correction should rebalance the current disproportionate tax burden on residents by increasing commercial property values, and as a result, increase the percentage share of local tax revenue collected from commercial properties. And remember, this hasn't really happened yet, as this is the first bona fide redevelopment of a large resort seeking to expand.
So if I may ask a question then, so the 8812, yes, we're familiar, so assuming this project goes ahead as proposed tonight, as being proposed, I should say, what's the impact of the 8812 split?
Well, hopefully it starts to reverse that trend.
No, real numbers.
Oh, yeah, I mean, we'd have to do serious projections on that.
Okay, thanks.
You stated that your goal achieves the
I'm
comp plan
stating what your
goals.
comp plan says.
No, I understand.
Comp plan
Yeah,
came
no,
up with
but yes.
8812. And all I'm saying is that your comp plan says that this is the mechanism to reverse that trend.
Understand, I've read the comp plan.
Yes.
And I'm a numbers guy, so
Okay.
I also went to.
I'm just repeating what your comp plan said, and that's what we look to for support. for whether or not this is a permitted use.
Okay, thank you.
So, however, this next slide might answer your question partially, because this slide shows a study from the Farmland Info Center with respect to cost of services for each dollar of revenue raised. You need commercial land uses to offset the cost of residential in your operating budget. So what this slide shows you is that for every dollar of tax revenue you receive, residential costs $1.16. Commercial business is 30 cents on the dollar. So for every dollar you receive, 30 cents goes out. So without having a mix of land uses, that's a really critical component of your operating budget.
What's farmland got to do with beach?
Sorry?
What's farmland got to do with?
This is just a study that the agricultural department did to evaluate the impacts of various land uses on your operating budget.
Okay, and where does agriculture fit into our city?
It doesn't, but the business one does. That's 30
Okay,
cents.
so what is it, what are you trying to say here?
I'm trying to say here that you need a mix of land uses to have a sustainable operating budget in the long term. You can't just have residential. You have to have a mix. And I can say that as someone who used to do the budget.
Okay. So you've never been in a city that's primarily residential?
Sorry?
You've never been in a city that's primarily residential?
I'm not sure I follow the question.
You
How is
said you
that
have
relevant?
to have something, so I'm trying
If
to.
you want to have a successful operating budget, well, you can have a city that's just residential, but they're going to have significant operating budget deficiencies to accommodate that. So it's basically just, as a city, any jurisdiction has to look at all the land uses to come up with a budget. And all this study is saying is the more residential you have, the more you're going to have to rely on other sources to compensate for the services that you have to provide.
Let's look at St. Pete Beach specifically, right? So where do our tax dollars come from?
A variety of sources. And the next one, let me see if I have another slide on that.
What's the variety of sources?
Well, you have your bed tax, you have your sales tax, you have your penny for Pinellas.
How much do
you
we
have
get from the
ad
bed
valorem.
tax?
Sorry?
How much does the city of St. Pete Beach get from the bed tax?
From the bed tax?
Mhm.
I have, it's in my backup. But at any rate, regardless, I have some more.
Let's stick with the questions.
Well, I
And
will,
so
but I would
let's-
like,
let's
but if
answer
you let
this
me
question
finish, I'm
specifically.
still in the middle of my presentation, I haven't finished yet.
And I
So
have a
your comp
question.
plan specifically talks about the 6 advantages to having large resort, temporary lodging uses. And those 6 advantages in your comp plan are listed as reducing daily vehicular travel demand, improved evacuation procedures, decreased number of residents needing to evacuate in a storm event, reduced demands on public facilities provided by the city, and then 5, 6, and 7 are the 3 revenue sources: property tax, sales tax, and bed tax. That's what's listed on your.
Mayor, I'm having a hard time hearing. There's a lot of chatter in the audience. Could you address decorum again, please?
All right, one more time, everyone. If you are not at the podium or on this dais, please do not speak. Thank you.
Sorry, these were,
You said you were going to be quick, but come on. No, I'm teasing. I'm teasing.
So, so I'll go back. Yeah, let's start with. Oh, I'll have to go back? This way.
You had it.
Okay, so this is your bed tax by city. So as you can see, St. Pete Beach has half the amount that Clearwater does, but if you have more beds, you'll get more bed tax.
That's not my question.
So then.
My question was, how much of the bed tax is St. Pete Beach getting? You're saying that our tax base is.
3%, according to the bed tax by city.
No, that's how much we're contributing. St. Pete Beach contributes 15.3% of the total.
And you're saying to me you don't get that back?
Yeah, we
I'm
don't-
asking you, no, I'm asking you
correct.
as the expert, how much we get back.
she's a planning expert. No, she's a planning.
So then why is she talking on taxes?
Because these are the advantages that were listed in your
And
comp
so I'm
plan.
asking you to explain the advantages.
The advantages is you get more, that there's more bed tax.
And how much, and we don't
Collection.
get any of it.
According to your information for Pinellas County, it's 15.3%.
That's how much we contribute.
Okay.
This states how much that's how much is collected from St. Pete Beach.
It says here, the proceeds from the bed tax not only fund tours and marketing programs, but also several important community functions, including beach nourishment, construction stadiums and museums, and reserves to be used in the event of an emergency. The funds are delegated to a 60-40 split, with 60% of the funding allocated to marketing and 40% to capital projects. That's the best information that we have at this moment.
I think the mayor is just clarifying that technically the bed tax does not come to the city of St. Pete Beach, it comes to tourist development. And so the TDC then chooses to distribute it. It does not come back to us.
But it does go to beach nourishment programs, which...
Yes, it does go to programs that helps out St. Pete Beach. One of them directly is beach
So I
renourishment.
think all your comp plan is saying is that with more bed tax, you get more,
Right.
you get more opportunities to put that into capital projects such as beach nourishment. That's all I'm trying to say.
Right.
So back to the previous slide. I think we,
So yeah, so again, these were the 6 objectives listed, or 6 advantages listed in your comprehensive plan as to why temporary lodging is a better use here than residential. And that was increased property tax and sales and increased bed tax revenue. So next we move on to the conditional use criteria. So the conditional use criteria definition, as Brandon stated before, it means a use that has operational, physical, and other characteristics that may be different from those of the predominant permitted uses in a zoning district, but which is a use that complements or may otherwise be compatible with the intended overall development within a district, provided that specified standards are met. So this definition is critical because we all know temporary lodging is a primary use within the large resort district. However, as a mechanism the city has chosen for heights in the community redevelopment district that are over 50 feet in density, 50 feet in height and density above 30 units an acre. And as stated in the definition, it is a use that complements or may otherwise be compatible provided that specified standards are met. In summary, you meet the standards and you get the height and you get more temporary lodging
I'm
units.
sorry, can you go back what you just said?
I said in summary, if you meet the standards, then you get the height and more temporary lodging units.
Okay.
So the conditional use criteria are the specified standards that are required to be met to exceed 50 feet in height and 30 temporary lodging units an acre. And again, compatibility is repeated here, and the specific standards to ensure compatibility are listed out. What are those standards? Buffering and setbacks. The higher you go, the bigger your front yard setback has to be from Gulf Boulevard. And why? That helps ensure that impacts to surrounding area are compensated. And that is how you ensure compatibility. Compatibility is not the same as, because you can't have the same thing everywhere, but rather compatibility is what you do when you have differing land uses. Compatibility standards are those buffering and setbacks that have been adopted with a specific formula in mind. And again, so that you, as a land use decision makers, are deciding that in accordance with a consistent standard. Your LDC lists out those standards, and the conditional process gives you the ability to make sure the standards are met consistently. And this is important so that there's no room for anyone to claim that the decisions are arbitrary and capricious. And Elise will provide all the legal arguments. However, from a planning perspective, this means and ensures that planners treat development and redevelopment consistently. So, subsection 2A under 4.4 requires whether the overall appearance and function of the area will be significantly affected, and consideration shall be given to the existence of other uses in the area based on the number, size, and location of the uses, and intensity and scale of the proposed and existing uses in the area. So as you can see, this basically re-summarizes the slide that I had before in terms of dwelling units per acre, stories. We're very consistent. The CMARC has a floor area ratio of 2.5. We are at 1.5. The floor area ratio is important because it talks about, it's basically a mathematical formula, how intensely you're utilizing the land. We're at 1.5, which is consistent with the Bellwether to the south, which is at 1.6. And they have 13 stories. So this has to do, subsection C has to do with whether the applications will be compatible with adjacent development based on characteristics, size, and scale. So the project is similar in size and scale with other projects already approved in the large resort district. However, Serrata, in this conditional use as conditioned, is providing more screening, more landscaping, and larger setbacks than similar properties and than the projects that are adjacent to the development. D has to do with significant adverse impacts on livability and walkability of nearby land. And as Elise stated, it doesn't mean no impacts, it just says significant adverse impacts. So there has been a lot of thought that went into the design. And the design is to place the pool, the restaurants, internal to the project, away from neighboring properties to help mitigate any concerns.
I'm sorry, I don't mean.
Sorry.
Are you providing testimony on the design and the planning of,
I'm saying,
are we talking about the comp plan here?
I'm saying that.
Because I have questions about the design and stuff.
So we have architect and a civil engineer for technical questions, but from a planning perspective, buffering, setbacks, and how you internalize activity is definitely a factor that we consider into determining whether or not a proposed development is compatible with the surrounding area. So I'm just speaking to the fact that it's not immediately adjacent to the property, it's internal to the resort itself.
So I would ask then whoever the appropriate person is later on in the applicant's presentation for me to address these 4 bullets with specifics. Because I can read the charts, but it's interesting, but it doesn't tell me.
Okay.
Sorry, thank you.
I'm just, if we have questions, if you're not the right person to ask the question, then we need to know who.
I guess it depends on the
Ms.
question.
Vidal, can you please give your opinion with respect to how the site is laid out from a planning perspective as to how it addresses specifically the 4 things that are here? Let's talk about that. And then our architect will say why it was designed that way. But if you could opine on the compatibility issues and how the site design creates a compatible environment, that would be helpful.
Thank you, that would be.
Great. So, the project proposes design that isolates noise, fumes, smoke, lights, night operations, and odors. It cues the traffic on site and screens the headlights. And it contains deliveries within screened area on the property, and it screens the amenity areas all internal to the site. So as a planner, when I'm looking at these things, I look at where are the uses located. And in this specific instance, it is internal to the site, and it's not immediately adjacent to a residential area. It's
Where's
internal.
the queuing for building 1?
For building 1?
Mm-hmm.
It was on that other slide that Elise showed before. We'll go back to that.
Well, no, she said that queuing is internal.
To the site, correct. And
It's-
as Elise stated before, yes.
She said it's internal. This is
Internal
on,
to the,
This
to
is
the,
this is on the north side of the building, facing the building next door.
correct, and that's what one of the questions that came up and was a condition was that it would just be valet only, and the deliveries are not going to occur there. It's just drop-off only.
Okay.
And we'll go into more detail on that, too.
Thank you.
So again, thoughtful design. As I stated before, the amenities are located internal. We have increased setbacks to the CCCL, and we have increased setbacks to the residential property, and we have protection of views and vistas. And the code requirements for rooftop amenity within the large resort district are extremely limiting. And those are conditions 1, 2, and 3 as well in the conditional use permit. So, oh wait, no. So I want to turn your attention to the northern boundary, which is adjacent to the sea mark. And the Youngs did spend a lot of time redesigning this northern border in order to serve a number of purposes. The typical code tree placement within the landscape buffer would place the trees closer to the property boundary. The problem with that is that placing the trees on the property boundary doesn't really do anything to soften the view of the JW Marriott because many of these residents would be looking over the buffer. So we prepared this line of sight exhibit. And the red lines show the line of sight for these floors with standard tree placement in the buffer. As you can see, these floors will look right over landscaping. So a better site design is to place the trees closer to the building so that the floors can see the trees rather than the building. And the blue lines represent the applicant's proposed tree placement closer to the JW Marriott building. And the blue lines show that the views from the lower and mid floors will be screened by the tree placement closer to the building. And as proposed, low and mid floors have better buffer effect with landscaping closer to the building. In addition, this placement allows for more on-site queuing and allows larger setbacks to the north and to the CCL. Without the alternative tree buffer placement, the applicant would have to push the building closer to the CCCL and closer to the north property line and place the additional queuing along the Gulf Boulevard side of the JW Marriott. Condition number 28 is the easement. I think somebody was asking about that. That's the one that requires the easement necessary to expand the existing beach access adjacent to the northern property to at least 7 feet in width. And there's conditions that talk about how that happens logistically.
So if I understand, I'm sorry, that the chart, basic,
Yeah.
so 5396 is the JW? 5396 Gulf Boulevard.
No, that's the C mark. C mark's on the left, the Marriott's on the right.
C mark.
Your back is towards the Gulf of Mexico, and you're looking
Thank you.
east.
Towards
Yes.
Gulf Boulevard.
Yes. Thank you. I didn't understand. the
So,
question.
so,
You're standing on
Okay.
the beach, basically.
I wish. So, does that not say at the higher floors, both of the buildings are going to be looking and smiling at each other through the windows? Is it?
So we're in agreement that that's what's happening?
Because right now, there's nothing there. The C mark has open views.
Oh, yeah, I don't know that.
Well, let's stay on this slide for a second. To Commissioner Gurl's, maybe your point, maybe not. One of the stipulations is privacy, and now you're going to have a building with people looking in on.
Did you want the architect to answer that specifically?
Okay, we can wait till the architect. If that's an architect question, then
Yeah.
just say, wait. I'll wait.
So are we done with the slide, or can I move on?
Sure.
Sure, thank you.
We have a building that's there right now with 6 floors, right?
Right.
Yeah. Right. Okay, moving on to section 4.12, the criteria for review in the community redevelopment district. So this is a section of the code that is specific to development in the community redevelopment district. And so your LDC has criteria within that criteria, and that is why your staff report is 72 pages and my supplemental report is 42 pages. And note this section is clear, and it requires that no unreasonable or disproportionately negative impacts are imposed upon adjacent or nearby properties. It doesn't say you can't have any impact. It just says it can't be unreasonable or disproportionate. So once again, these are the standards of review to make sure all the technical criteria are covered and that the review is done consistently across all development in the community redevelopment
I
district.
have a quick question for you.
Sure.
When you say disproportionate, what do you mean?
Disproportionate? Well, it's highlighted in your staff report. I mean, that's disproportionately, I mean, it's all relative, right? So that's the reason why you have a staff report, that's the reason why you have a comp plan, and that's the reason why you have buffering and setbacks. So I would say to you, if we weren't proposing setbacks that were in excess of your minimum code requirements, maybe you might have an argument, but we're proposing things in excess of your minimum code requirements. So that ensures that it's not disproportionate.
I mean, I didn't mention anything about setbacks. I was just asking what,
But that's how you meet the criteria, to make sure compatibility amongst unlike uses is through setbacks and buffering. That's what your code says.
Can the code itself lend itself to disproportionality?
Well, that's why you have the review. That's why you have the review criteria. That's why for all the height that you have, you're required to have more setbacks from Gulf Boulevard. And that's a formula, and our site plan exceeds the minimum standards that you have in your code
For setbacks.
for setbacks as well as buffering.
Okay.
Correct. I just want to emphasize that we have listened to you, we listened to the planning board, we listened to the community, and we do understand the complexity of what is before you. And this team of experts have really collaborated together to create a redevelopment that is thoughtful and meaningful to ensure that those concerns have all been incorporated. And that is the beauty of this conditional use process. You condition the use. There's 35 conditions listed, and that's what is the beauty of the conditional use process, and that's how you ensure that any potential adverse impacts are mitigated. You get to see what you're getting up front, and you get to, so it's a site layout, it's the physical dimensions of the structures. Well, as I stated before, it meets or exceeds the code for dimensional requirements. The main JW Marriott building is going to be 54 feet from the northern property line, and the site layout designed to locate amenities internal will help to minimize impacts to adjacent properties. The buildings are set back from the CCCL. We have fewer stories and similar height to the property to the north. We have less stories with the neighbor to the south. And with that, we're going to talk a little bit about views specific, and then how the specific controls over the more general criteria in your code. So section 412A9A, views. This is the portion of the code that addresses the amount of separation provided between the proposed temporary lodging use and any existing buildings on adjoining properties. So there are these shade studies that were provided. So the question for you is there appropriate separation to the existing buildings on the adjoining properties or not? So as you can see here, we've almost doubled the setbacks for the actual building on the north side from the steam arc to help protect the residents' views to the water.
Cynthia, I have a question while you're on that, if you don't mind. Go back a slide. Isn't it true that section A9A is telling you how you make sure that the views are protected, and you do that specifically through this provision of the amount of separation? And you're saying that we have approximately double the required setback separation to what is required already in the large resort district. Is that right?
Yes, thank you for that.
Yeah.
So it's also important how our buildings are set back from the CCCL line. And our neighbors are either built across the CCCL line or right on the CCCL. So this setback also helps to improve views and vistas and to protect them. So this graphic shows the setbacks compared to the C mark. So the red shows the limited view shed if we were to build to the CCCL, and then the blue shows the additional view shed that we will be providing through site design. So it's basically by shifting the structures away from the CCCL, it doubles the view shed spread.
Before you, where is the current,
Building right now.
yeah, what's the current views like?
It's about the same.
I mean, it's taller. This is taller, so it'll be different.
I'll have him answer that question when.
So do you have a slide that shows what the current views are?
No.
So what are we comparing then?
You're comparing it how we compare to surrounding neighbors with respect to proximity to the CCCL line.
Yeah.
And by pushing, we're requesting through this redevelopment to push those buildings farther inland and not go to the CCCL line, as some of our neighbors have done and have been approved to do so. And by doing that, this helps to improve and protect the vistas.
Exactly. It says you need to protect them, so I would like to see what the views are currently so that we can determine whether, in fact, you are protecting them or not.
Well, that kind of shows it along the CCCL. So in my opinion, this does show what it currently is, right? Because you've got that building structure right there. And the red is the current view.
You're supposed to maintain the views,
I'm sorry?
protect them.
Well, we're improving them
You-
because we're moving it away. Yeah, because we're moving it away, so we're improving it.
I mean, the best I got is here, I mean, Google Earth. I
Buildings are
mean,
disparaging heights, right?
no, they're right, but at least we
So-
can
so
see.
the people that are on the 7th floor and up are going to have different views than they
As
currently.
they do now, yeah.
Exactly. So I think it'd be perfectly appropriate for you to have another slide that says, this is what it is, this is what you're supposed to protect, this is what it's going to be like. Are you protecting the current views or are you not?
But what used to be there is nothing. And there was a Cornet motel that was a two-story that ran from the street back to almost the C mark. That got knocked down in the late 80s, and the new Serrata got built up next to the C mark at 6 stories. So the C mark did enjoy next to nothing next to it for probably the better part of 30 of its 50 or 60 years that it existed. Then in the late 80s, when the Serrata got redeveloped, they had 6 floors of obstruction to some degree, and now that's going to increase to 10 and a half,
Well,
I think.
as Ms. Betzel reminds us, frequently, we have to work within the current comprehensive plan scope. And this one says we protect the views that are there today. If the comprehensive plan in the 80s did not have that stipulation and that protection, shame on them, but this one does.
I'll address that more.
I guess what I'm saying is that we now have, really the analysis, I think, would be from 6 up.
Yeah.
What is our, from the street, from the east side of to the west side of the C mark on the south?
Yeah.
What are the effects on those?
We actually don't know for any of it because they don't have anything here that shows what the current views are for the lower floors and the upper floors. We're just supposed to.
Yeah, well, I mean, your comp plan does discourage permanent residential, and you were directed by the state to move people away from the coast, so.
I'm sorry, what's that got to do with it?
I'll address views and vistas more later as well, so I think we can answer all of your
Is she
questions.
the expert on views and vistas, or?
No, I'm just talking about the planning criteria for views and vistas.
So, yeah, she's talking about the planning criteria for views and vistas, how separation and buffer relate to compatibility and planning. We're also going to address views and vistas with other experts, and we're going to provide legal arguments. So if you'll bear with us on that point, I think you're going to get a lot more information. And
Okay, peace.
Okay.
I'm sorry, you skipped over that slide?
No. So the bellwether is a bit of a different situation because it is a like-to-like use, and it is taller, and it is closer to the CCCL than what we're proposing. But the blue hours here on this graphic demonstrate that the guests at the bellwether can essentially see up the beach even from the furthest rooms. The site design, including the building setback from the property line and the CCCL, have broadly maintained the view, and these efforts satisfy the criteria. So with that, in my professional expert opinion, number one, as conditioned, the proposal is consistent with the applicable provisions of the comprehensive plan and land development code. And number two, the proposal is compatible with the surrounding area, and the proposal satisfies the applicable sections of the LDC as highlighted on the screen. And with that, I'm happy to answer any planning questions. Sure.
sorry, Cynthia, when you looked at the comprehensive plan and the land development code, did you look at those in totality?
Yes. So thank you.
I think we have questions. If you go, I have questions.
Okay.
If you go back to maybe slide 3 or 4 in your presentation.
Everything I dropped. Which slide?
Early in the beginning. All right, keep. Let's see. Yep. Next slide. Forward. There we go. No. Back forward. One more.
The character district?
No, you keep going back.
Oh, you want me to keep going back or forward? I'm
Going-
sorry.
Please go forward. You're going
Forward,
backwards.
okay. Sorry.
Okay. Right here.
Oh,
Yeah.
okay. It was hard to get a picture from the other side, but
So
I
as
wanted to show
you
where the bellwether is.
stated, the comprehensive plan, one of the things that it wanted to do was to attract and revitalize business, specifically by replacing obsolete business,
obsolete buildings.
buildings, right? So you're only doing that 2 out of 3.
Well, I think they're renovating the main Serrata one as well. They're just not, it's not a redevelopment in terms of adding, expanding the use, but I do think it's a renovation.
You have replace here twice.
Sorry?
You say replace. Your slide says replace obsolete buildings.
Yeah, because one is with, in perspective to
Comprehensive
economic
plan
risk, and
seeks
the other
to
one is for
address-
coastal resiliency.
Yeah, by replacing obsolete buildings.
Correct.
You're not replacing an obsolete building.
We are.
Renovating it, you're not
No,
replacing
we're
it.
renovating two buildings are being replaced,
Yeah,
and one is being renovated. Either way, it's improving the structure.
2 out of 3.
Well,
That's what it is, right? You're not replacing 3, you're replacing.
that's your opinion. Mhm.
Am I not doing the math correctly?
I think the key is.
I mean,
Just-
I think.
The key is this redevelopment. It's
Yeah, I think, I mean, assuming that they're not replacing because they don't consider it obsolete. I mean,
Well,
That's-
and maybe they will come back with a conditional use for that in the future. I don't know. Right now, all we're doing is looking at what's proposed before us.
Okay, so if you go forward, please. One more. Okay, I'm trying to understand what you're trying to say with this.
Right. What I'm saying is that your land use policy and your land use decisions matter in terms of how you're going to budget and take care of your citizens, your residents, your tourists, and the people who come visit here. That's all this slide says.
Okay.
And I think if, and it was to my question on the 88 versus 12, this chart is to tell us you need more of,
Residential.
well, you need more business to get the 12 up and shift the 88 to the 12. I think that's what the message that I'm taking, I mean.
I think what the message here says is that you don't get as much from businesses as from residential.
So this
I mean, that's,
cost slide. It is not
Okay.
a revenue slide. For every dollar in revenue you collect, your operating budget will pay out $1.16. That's what this slide says.
okay.
So
Yeah,
by
that's okay.
increasing the non-residential component in your jurisdiction, you're going to facilitate that because they generally use less services. And all this slide is saying is that the temporary lodging uses is the equalizer, and that's what your comp plan also says. And the equalizing is not going to occur if you don't have redevelopment. So there's a correlation between your land use decision and your financial implications associated with that. That's all this is saying.
Mhm. Okay. Thanks.
Thank you.
Any other questions?
No, thank you. Thank you much.
Jim, you are up. Jim, could you introduce yourself and qualify yourself for the record, please? A copy of Jim's resume, please.
Okay.
My name's Jim Stapleton. I'm an architect with Pivot Studio. We're an architecture and design firm in Cincinnati, Ohio area, about 30 employees, focused primarily on the hospitality industry. I attended the Illinois Institute of Technology in Chicago, Illinois, graduated in 1983. I'm a licensed architect in 38 states. I've been licensed in the state of Florida for approximately 20 years. I've done numerous projects down here, but again, our work is primarily in the hospitality sector. I'm going to address kind of parts of the design based upon your land development code, specifically section 4.12A4 architecture. And it asks that the design and appearance of buildings, facades, exterior building materials, and advertising, and directional signage. I mean, basically, you know, it's a new building. Specifically, I talk about the JW Marriott first, a 290-room hotel. You know, it's a large, full-service hotel. It's based upon a basic 300-room hotel program, even though ours is only 290. The building's been designed to kind of be what I call Florida international style, modern. It's simple, clean, white on color with gray accents, and that's partially in deference to the upcoming reviews and things that we'll have with Marriott International, with, you know, based on their design standards. But it's also what I see around Florida a lot. This building is very constrained on the site. It's kind of filling it out, all the different setbacks and things, and kind of working with things, so there isn't a lot of room to kind of add a lot of embellishments or kind of different, really a different layout than really what has occurred with what we have. The building exterior insulation finishing system was pretty standard. It's on many buildings in the Florida area here, and it's used in a lot of hotels around the country. But in general, the design challenges were to fit, we'll speak about the JW Marriott first, to fit it on the site, keep it away as far as possible. I mean, from the very first sketches, which were actually over a year ago, 15 months ago, I think in September of last year is when I started. It's substantially the same as the very first sketches that I did. And the idea was, fundamentally, I always think about what's going to happen to the neighbors and what's happening around it, who's going to be concerned about what, and to kind of do what you can to make all of that work with the overall design and the client's needs, but also the neighbors. So the very first thing was to keep the building as far away from the C mark as possible, and thus, that's why we have the queuing on the north side, because that needs kind of a 60-foot turnaround. It allows us to push the building southward away from the C mark. Initially, the building was even farther away from the coastal control line, but it was pushed back somewhat, as little as we could. But what we had to do, because of what was happening out on the street, meeting the needs of the Florida Department of Transportation and their needs for the trucks and radiuses, we've worked very closely with Brandon and the team here to kind of go through different elements of the design. We've kind of met, we listened to the C mark about closing off their kind of the parking garage view. Initially, we had an all-open garage. We closed that off. We worked on the different bump outs and things with Brandon and the team. A lot of design standards are usually the legalese of a design standard often doesn't translate well into an understanding of what you need to do, and so you have to go back and forth with the city. And so we went back and forth with Brandon and the team of a number of items, and one specific item were kind of the colored fins on the south side of the building, which when you're trying to do bump outs on a garage don't really get you much from a design and architecture point of view. But the idea was, we know that that's essentially a backside of our building, facing kind of what I'll call the backside of the Serrata, and to kind of create a colorful banding all the way out to the beachfront, to kind of allow the people to make people want to use kind of the new walkway that we're going to provide there, to kind of take the negative thing, make it a little bit more positive. We've bumped out the different stairwells and things to enhance the architectural look. We've added bike storage. We've worked so far with the team on the Serrata and the porte cochere, which is just a minor addition to the front of the Serrata that's based upon what's the relocation of the lobby. The Hampton Inn, in our very first meeting, I think it was with Alex Ray, we actually moved the tower away from the bellwether farther than what the code stipulated. We only needed a 30-foot setback for the tower, and we probably had a little bit more, but he asked that we push it farther in, and we did, because they're within 5 feet of their property line, which I don't know how that got accepted in any jurisdiction, but it did. And we've worked, in the parking garages and things. I mean, if you drive around Florida in different areas, you can kind of see a lot of parking garages and things completely covered in solid walls to hide the parking. And it never strikes me as something that's desirable or looks good. We've done our best to kind of add flowers and landscaping and other things to kind of soften the edge of the building. The JW Marriott it's a full-service hotel, and it's got a lot of parking garage, and it needs to meet a lot of different needs, and I think that we've done that. We've also kind of added mosaic murals and other things, kind of enhance the quality and character of the building to the extent that we can.
Can we see any of it?
We're required to kind of seek out and either choose different energy standards. So the JW Marriott Hotel is going to seek LEED certification, and then the Hampton Inn is going to seek LEED Silver certification. We had to, because of the way your standards are written, we had to use 2 different standards. So they're very close, but we had to use 2 different standards. There will be a 35% reduction in baseline in the water usage, which is kind of something that's just basically part of the LEED standards, and we do that in a fair amount of projects around the country these days.
Excuse me, Mayor, could I ask a question?
Yeah, of course.
Are you going to go back to the architecture? Are there future slides with the architecture? I'm interested in that.
No.
In 4.12A4, is now the time to ask you questions on that?
Yeah, go ahead. I think it asks now.
Well, what we would like to see is go back to that slide that you had that was all words.
The next one.
Yeah, the next, yeah. That's a way of describing it. I'm more interested in seeing it. So if you could walk us around the buildings, I've got some comments on the architecture.
I don't know if we have more renderings in here.
Oh, there are renderings in our packet.
You have renderings in your packet?
Yeah.
Okay.
I think there were, I don't have it up on my screen, but if I remember right, pages 235 through maybe 240, 241. I think it was on the PDF, if you go to PDF, 235.
Okay. 236.
Yeah, 235 or 6, depends.
Yeah.
There's a page difference.
Can you not pull this up on the screen?
These,
Okay, I'm going to put them up and I get.
Okay, good.
yeah, there you go.
Okay, so this is an angle from Gulf Boulevard looking west, slightly southwest.
Correct.
Can we see the northern edge of the building more? I mean, this is a good view from the public side, but can you get it more, is it more of an angle?
What, you're trying to see more of the north side of the building?
Yes, sir. I kind of like to just walk around the buildings. I mean, they weren't complete in the, okay, that shows it from the beach side, but I'm more interested from the I mean, this is the public side too, but from the Gulf Boulevard side, more on that north.
I do not have one from that view.
Okay.
Not this one?
Okay, then how about the other building?
The Hampton Inn?
Yes, sir, and the garage. I think that was page 240. Yeah.
Page numbers and what.
Okay, this is a view.
Hampton Inn currently, I
Right.
think when we met with you, we had more planters on it, and then in work, I think we did, and then with staff.
Well, all I can tell you, I'm going to try and be politically correct here. To me, this is not acceptable. I mean, this isn't even close to being acceptable. This is on Gulf Boulevard.
Right.
I don't know how to say it, but I would call this an economy garage. You can make parking garages not look like parking garages. And the whole reason for this stipulation in 4.12A4 is that if we're going to be allowing a maximum density in height, we expect great architecture. And I don't know how to say it, but this falls short. This isn't a tweak to this. I mean, this is a relook at this parking garage. And then if we go to the building, the Hampton Inn building is not a whole lot better. Can we go to one of those images?
I think it's the next page.
This is one from the beach side. There's another one that you had earlier, or that one of the other presenters had earlier, that was looking more at the north edge. Some of this is being disguised by the palm trees and things like that. And I do have some questions on landscaping.
There's this one that we.
Yeah, I mean,
Commissioner Kozlowski, I have a question for you, since you're kind of an expert at this. But one of the things that the code stipulates is that parking garages cannot be easily identified as a parking garage.
Get closer.
I need you guys to lean into the microphone. I'm having a hard time hearing you. Thank you.
Thank you.
I mean, I think the mayor is making exactly my point. The parking garage doesn't have to look like a parking garage.
Well, I think
And
the requirement is that you cannot tell that it's a parking garage.
Right. Whether it says it or not, it needs a lot of help. It needs a lot. I just think from the perspective of selling this to clients, we want it to look good. It's not just I'm more interested in the general public, but, it also, I think, helps in terms of selling the product.
Sure,
too.
I understand. Well, we can certainly work with the planning department.
We need to. I'm trying to figure out how we resolve this. I've talked with our attorney a little bit about, options. I tell you, I'm so concerned about this issue that I don't know that we could put a condition. To me, you're going to almost have to come back and show us something, because I don't want to put a condition that says, make it not look like a parking garage. I mean,
right.
And we're not going to redesign it here tonight.
No.
So to me, this is a huge issue.
Commissioner, typically, what you've done in the past on these types of projects is when they bring in the renderings, they're at a state that, I think the language is something like that, what they will take to site plan approval is substantially equivalent to what they showed to you. I think that's the kind of language that you have asked for and the commission has asked for.
Well, I asked for that if I think it looks good.
Yeah, well, that's what I'm getting at, yeah.
That's the problem, is it doesn't look good right now, but if it was, you're right,
That's what I'm getting at.
When we looked at the others, because, I know this process, it's my business, even though I don't do hotels, I know through a process, and Jim knows through the process, you can go through value engineering and things cost more, so you got to make it less expensive, and that can detract from the way it looks. And so that's my point. If this was looking good, I would say I want all this in the record, and I want to make sure that it comes not just through site plan approval process, but when it goes through permitting, it retains the qualities of which we're approving.
Correct. If it's substantially unacceptable, then you can't pass through that gate.
That's my point right now. So I just have a big issue with this.
Yeah, and just to add to that, I mean, I received feedback from, I believe it was a resident who provided us pictures of other JW Marriotts around Florida, and the feeling in, as far as the, I don't have which subparagraph, but the compatibility, overall appearance, and the compatibility is a bit, I mean, for lack of a better term, this is a bit blah compared to other JW Marriotts that were shown from around the state of Florida. It's not very, it's compatible, nothing in C-Mark, but it's an older 40-some-odd-year-old building that wasn't built to, it's kind of like a block, a rectangular block. So while we're working on the garage, we might work
Your
on
Honor, the provision you were talking about is when a parking garage abuts a public road or other public place, it will be designed such that the function of the building is not readily apparent except at points of ingress and egress. I think what I'm hearing and what you're communicating to Jim is Jim may have been under the impression, I think you can tell from his comments, that he assumed that this was a process to go through as part of site plan approval to continue to work with staff. And what we're hearing and what is being communicated appropriately is that he has to have final renderings back in the state that you can say these are substantially similar to what we're going to approve.
Yes.
I think
And just to clarify, we met one time. We met on, I think it was May 23rd, and I made these same comments back then.
Understood.
And I said,
I'm
this
sorry,
needs a...
Commissioner, to cut you off. I'm having, again, a hard time.
Okay, I'm sorry, I had...
Not you, it's not you, it's the public. I'm having
Okay.
a hard time focusing because I'm hearing out of my right ear the public. So please, decorum.
So I guess why I'm disappointed is we only met one time. This was my biggest comment back then, and I said...
It was, and we did change, we did have a different view of the garage. We had the planters and things all around it, and the staff asked us to kind of go in a different direction, which we did. Obviously, we did not go in a direction that you thought we should have gone in.
Well, and I'm not sure planters are enough. We've all seen planters on a garage. It still looks like a garage. It looks like a garage with planters. And the biggest problem with that is typically the plants aren't growing. And then that becomes another issue. It's a maintenance issue. There are ways of designing garages that don't look like garages.
We're happy to work with the staff.
Yeah.
Don't have any issue with that at all.
Okay. I mean, it's really an important thing. Obviously, I'm an architect, so this is something I hone in on, but for the public, this is a big deal. I mean, the way, I understand the way you design this. It makes sense. You put the buildings closer to the water, where you get the views, you get the people closer to the beach. That all makes sense. That forces you to put the parking garages up front. By forcing you to put the parking garages up front means then you got to handle that appropriately aesthetically.
Understood. Okay.
So I think we have direction on architecture. Is it okay if we proceed with the rest of the experts and make sure there's no other issues that,
I would like, since I've said that, I think the Marriott side is looking okay, but the building itself, the Hampton Inn, whatever you want to call that one, Hilton, could use
It needs
some work,
it needs
too.
more, and more will happen once they're engaged.
I'm not sure that the.
Well, but we're in a position here.
Yeah.
That, to me, that's, all due respect, that's unacceptable.
Okay.
We are being judged right now. We're judges, and part of the criteria is aesthetics. So if it's going to happen later, then my answer is then our answer is going to be later. But if you want the answer now, we have to see it now.
Okay. Understood.
Okay.
Anybody else have questions or proceed? Okay, so we did the shadow study.
No.
Okay. So obviously, December 21st, that was kind of the greatest amount of shading on the C mark between the hours of 10 and noon, or it's mostly gone by noon. But in general, we didn't have a lot of issues with that.
Can you expand on that from the record, that this was the most degree of shadow? And
Yeah.
tell us what happens on the Hampton building? I mean, it's part of the record, but can you walk through that, please?
You know, well, Elise is right. This is kind of the worst condition for the C mark and the Northern JW Marriott. On the other side, I don't know if we have a picture of that one tonight.
We had that in our package.
You have it in-
These were good, by the way, these
Yeah,
diagrams.
I mean, they're very helpful. But in general, I mean, because the buildings move kind of farther for the Hampton Inn, move upwards, it helps with the shade studies. So as condition, we think the architecture proposal is consistent with the applicable provisions of the Comprehensive and Land Development Plan. The building's proposed design and architecture, we think is compatible. We'll obviously work with the staff to kind of bring it closer to what everybody's looking for.
I don't think you heard that from us.
I mean, I think technically it is, but the design issues, I understand.
Garage looks like a garage. It's not supposed to look like a garage. It
Right.
doesn't meet the condition.
Okay. Do you want to pick this up?
Do we want to, I'm sorry, do you want to talk about the wind, since you did the wind?
I could talk about the wind. I mean,
Because it only addresses movement of furniture on balconies. I think the issue is bigger than that, than just, because today, my understanding is, depending on the storm, there's been people knocked over and/or cars damaged from the wind in that, between the two buildings, Seamark and Serrata. So if we put a bigger building up, and I'm not an engineer, but it would seem like you're compressing the area more and the wind velocity would be more.
So I think you have 102 feet between the two buildings.
yes,
And if you look on my block, Fifth Avenue, there's 96 feet between two 70-foot condominium buildings that were built in 1972, 555 Gulf Way and 433 Gulf Way, called the Beach House. They're 96 feet apart. They're 70 feet high. They are surrounded by small village-type homes, and I've lived there for 30 years, and we've experienced Debbie, we've experienced all kinds of windstorms. I don't know that anybody's gotten knocked off a balcony. We've lost furniture during that Debbie, that spinner that came off of the water and destroyed the Paso Grill High and Dry. I'd love to see a wind study, but I know that you already have a 6-story building and a 10-story building with 102 feet of separation. I haven't heard of any damage over there caused by wind. Certainly there would, I'm sensing there would be a wind tunnel in that area, the lower area, and we would have had reports either through the fire department, there'd be property insurance claims, all kinds of things as a result of a wind tunneling effect.
which is very similar to kind of the letter that I wrote about the building in Chicago being 66 feet away, 40 stories tall, with a 110-story or 100-story building, just.
So what effort
So
would
wait a
it take?
minute. It was my question. So if we can go back.
Yeah.
The feedback that I'm getting from residents, that I'm sharing and asking the technical expert, is, there have been problems. So the question is, why don't we feel we need to do a wind study when the people who live in the building feel that there has been an issue? I don't know if it's in the last 12 months or in the last 24 months, but the people who live in the building say there's been an issue. I'm addressing it to the technical expert.
I mean, I frankly, I don't think that one is necessary. I mean, just through long experience, and the building code does not require one. If you go around the country, and I'm around the country a lot in bigger high-rises, it's, in the example that I cited in the letter, there aren't any issues with those things that are substantive. They have, obviously, on a very windy day, if you're getting beyond kind of the standard wind volumes, you're starting to get into very bad weather, right? Those things can't really be taken care of too much by just the wind study and knocking. Of course, people are going to get knocked over in a hurricane, and you shouldn't even be there. But in general, I mean, through common sense and experience, these things, it's really not that much of an issue. I mean, as an example, Joe's company owns a Marriott in Myrtle Beach, right on the ocean front, that we designed 20-some years ago, that's about 16 stories, and within 68 feet of it is another 16-story building right on the ocean. And I've never heard from the Young families once that there were furniture blowing off the things, and if it was, I'd hear about it. And it's a very similar situation to what's happening here. So in my expert opinion is, I think it is, can the wind move furniture a little bit? I'm sure it can at some point, but it's not doing it in a substantive way that I think is a big issue.
And I'm not concerned about the furniture.
How long does it take to do a wind study? How long does it take to do a wind study?
That I don't know. I mean, you do them all the time on 100-story high-rises. You do not do them on 10-story buildings.
So you don't know like a time frame or?
No, I don't.
Okay. Understood. Thank you.
I had some questions, and I'm not sure if he's the right one to answer them, but maybe I'll ask him now in case now's the right time.
I can address the timing on the wind study.
Oh, okay.
Because a different developer did a wind study, and it typically takes 4 to 6 weeks.
And we received a letter from the CMARC when?
I think the first letter to me was in June, if I remember.
June 16th, so we've had plenty of time to do one. What's the cost of one?
I don't know. I do not know.
They're quite expensive. I think they're between $25,000 and $35,000.
Okay.
I'm not sure if this would be for you, but maybe I'll ask and you can. Okay. There were some concerns about glare and headlights from the north parking garage into the CMARC. Right. And they were talking about changes, but I couldn't see that.
We made the wall solid. The entire north wall of the JW Marriott at the parking garage is a solid wall. Initially, it was had openings before.
Okay. And then there's a concern with the CMARC about vibration. And I know there was a comment that it'll be handled, there'll be some vibration done, but has there been a decision made in terms?
This is in terms of through the construction?
Yeah, I believe the pile I'm assuming they're going to be pile foundations?
Auger cast.
Are you,
not going to be driven piles, which is what.
Okay, they are going to be auger cast
piles. They are going
piles.
to be auger cast.
Okay, that's what I wanted to hear. Okay. Is this all part of the record?
In addition, Commissioner Frasowski, we have agreed to a condition that talks about doing a physical inspection of the CMARC at the beginning of construction, and also doing, at both buildings, and also doing vibration monitoring at the property boundary.
That's good.
For assurances to the adjacent neighbors.
That's good. So you wouldn't mind that condition also adding that they're going to be auger cast piles?
I think that's in.
No, that's fine.
I mean, you're probably going to do that.
That's
It's
the
just,
idea.
I think it's in.
It'd be nice to have that in the record because, you know, CMARC, especially after what happened in South Florida,
Yes.
you know, it's a big concern about this. Okay. That'll help protect them and be good for you. Thank you.
Are you answering questions about vistas and views, or who is?
I can answer the questions about vistas and views.
So what are the current views? What are they going to look like?
Say that once again.
What are the current views? What will they be?
There are no pictures in here of the current views. Obviously, the current views are better, but the new building is a larger mass, obviously. So I think when the planner was talking before, she was talking in reference to what we could have done when what is allowable according to your land land use regulations versus what we did. As, you know, technically, we could have had the JW Marriott sit 30 feet from the property line. That would have been more detrimental to the views. We've done everything we can to push the building to the south as far as we can. In terms of the coastal control line, we could have put the tower right up to the coastal control line and made it worse. And it was, the very first sketch was thinking about those issues. So we've taken what is the program, which is allowable by your land development code, and pushed it back and pushed it down as far as we absolutely could. And it was even farther pushed away from the coastal control line until we had to deal with the Florida Department of Transportation. So that's really how we're looking at it. I mean, I think what you're saying is you had a 6-story building. Why aren't you just going to build a 6-story building again and everybody keeps the same views? And that's really not possible with what's allowed in your land development code and what is needed for the program to make this a luxury hotel.
And what's required is for you to preserve views. So what's required is for you to preserve views. And you're
required to preserve it. We're trying to maximize the views that can be achieved in a reasonable way, and I think we've more than done that. One of the single most important things that I thought about when we were laying out this building.
But you are negatively impacting the Seamark trees.
It's obviously a bigger structure.
Okay, so you're not preserving the views.
We're preserving them to the extent that you can. It is not exactly the same. We are not building a 6-story building. Your land development code allows for taller buildings with larger programs to it, and we're following those regulations.
As long as you don't.
I do know that.
Yeah. Okay. Light pollution, is that you or somebody else?
I guess it's a little, I mean, for the architect, I mean, it's really about the glazing. I mean, so obviously we're going to meet the requirements of the turtle glazing on all the new buildings, and then we're going to put the film on the existing Serrata to meet that. Separately on the site, I mean, I know Columbia Sussex is already working with people, and I think they've had people from the city been walking around there to kind of bring the current conditions up to the current turtle lighting standards. Our intent is to meet all of those standards.
So you were advised that you're not in compliance.
The existing hotel, I don't think is in the condition that they bought it, but they've been working with the city and experts and they're doing that right now.
Is it in compliance today?
Code enforcement, Pete Dwyer met with our operational folks at the site, and all the lights have been installed. In fact, Bob, do you want to come up and address the issues of the installation of the lights?
Are we done with the architect, or?
If you don't, do you have other questions?
Sorry.
He'd be happy if you were done with it.
Thank you.
Is he not the architect?
The guy who was there, not this guy.
No, him, yeah. I said the architect. You said me?
Your question, Mayor?
Name and for the record.
I'm sorry, Brad Cochran, General Manager of the Serrata.
Okay.
And your question was?
What is the current status of your lighting scheme?
So the current status, Pete Dewar provided the property some photographs of lights that were negative impacting the beach based on turtles. We identified all those, have changed all of the light bulbs to the correct amber glowing light bulb, specifically in what we consider building number 4, which is next to the Seamark. On the south facing the south side of that property, there are 2 triangles on the building on that side that have exterior balcony lighting. So we changed all of those. There's a stairwell in the middle, which has 2 elevators. That stairwell, there was lighting in that stairwell on each landing. We shaded all of those shades on there, half black, so the lighting faced or was shown to face into the stairwell. And then building 2, which faces the ocean, the beach, we changed all of those light bulbs. And then building 3, which faces the Seamark, all of those corridors, 3 floors, we changed all of those to amber colored bulbs as well. And we do have a current proposal to do tinting on, prior to any renovations or construction, to all of the sliding glass doors to all of the units.
And when were the lights updated?
Lights were updated, started last week, and it was completed over the weekend.
And when were you advised that you were not in compliance?
I don't have that date with me.
Okay, I think it's in the package. Looks like July 20th. So you went through all of turtle season with non-compliant lights.
We, through there, we changed them to a low watt LED, which we thought was sufficient. And then I spoke with Pete, and he said that lower wattage LED wasn't appropriate, so we changed them to the amber.
Thank you.
You're welcome.
Good evening. My name is David Perry. I'm Managing Principal of Perry Becker Design. We have a firm in Orlando, Florida. We specialize in hospitality and resort design. I've completed over 60 resorts in my career. We're currently working on 3 on the west coast of Florida right now, and numerous throughout the Caribbean. We have worked with staff throughout the course of the project to actually meet the criteria as set forth in your current code. We're actually exceeding the current requirements for minimum native landscaping as well as water-wise landscaping. Our Florida-friendly landscaping actually exceeds the 50%. We're actually at 84% based on our current calculations. Part of the phase 1 portion of this project, we'll be doing a full dune restoration. We heard your comments with respect to the walkovers. We'll accommodate that as part of the design. With respect to the irrigation design on the project, we use water-wise irrigation systems. It was brought up by staff that you were interested also in looking at actually provide a design for that identify breakage in inlet flow. We use those all the time. Will be used on this project as well. So based on our review of the design, based on our review of the code, our landscaping does meet the current code requirements. Satisfies section 4.1.2A for all landscaping. Also tried to build in as much buffering on all of the property boundaries as we possibly can with respect to the use of trees, native trees, and combination of palms as well. With that, if you have any questions, I'm happy to answer.
We had multiple different renderings in our packet, some of those that were just recently shown. Did those accurately depict the landscaping?
So let me go back.
A lot of times I know renderers tend to embellish renderings.
I would say there's actually less trees in those renderings than what we have in the design. And I think for graphic purposes, a lot of times renderers will actually remove trees out of the renderings to actually open up the facade, visual facades of the buildings. I would say that the actual renderings that you saw probably have more trees in them.
How about like height, lushness, that kind of?
Sure.
I'm sorry, you have to be at the microphone.
So Jim Stapleton with Pivot Studio again. Our team created the renderings, and they were based upon the Perry Becker landscape plans that were given to us. And they gave us a very specific list with all the plants.
Okay.
And our rendering team actually used the plants piece by piece to put it together. That was probably the part that took the longest amount to kind of render it and put together.
I mean, I did look at we had detailed landscape plans and all that, and, trying to compare those. So is it fair to say when it comes time to give you a permit for a CO that they can look at those renderings and say, this is what we're expecting, and you don't get a CO? You know what I mean? It's,
Yeah,
especially, I'm especially concerned about the landscaping on Gulf Boulevard.
Well, that's, so he has to talk about that.
So something was addressed is that staff actually requested, sorry about that, staff actually requested that we actually increase the amount of Florida native landscaping. So we've actually done that after the renderings were completed. But as far as density of plant material, density and height of trees, I believe that what you're looking at is identical to what was been specified on our plans.
Okay, thank you.
But when the renderings are revised, we will update according to the new Florida, the additional Florida native vegetation, so that what you're looking at is actually the landscape plan with staff's request for additional shade trees and the additional Florida drought native landscaping, so that what you see is reflective of that condition.
Good, thank you.
Any other questions?
None here.
Okay,
Thank you. Sorry, are you traffic?
I am.
All right. Shall we take a 10-minute recess, because this may be a long one?
Do we need a motion for 10 o'clock?
And before you go, so our commission meetings are scheduled to end at 10 p.m. unless one of the commissioners would like to make a motion to extend.
I'll make a motion to extend.
Second.
Wait, no, there's has to be a time.
Extend to what,
To
yeah.
what time?
I don't know. Your guess is as good as mine.
Well, we could always end early. We push it out and then end early. Or do another motion.
Midnight.
Yeah, midnight. Let's not go to midnight, but I'll say, in the rare case that we're going to go to midnight, we'll put that as a motion.
Do we have a second?
Second.
City Clerk, if you'll please do a roll call. We got 2 hours of audience comments.
I know.
Decorum, so that I can please do the roll call. Thank you. Commissioner Marone.
Yes.
Commissioner Grouse.
Yes.
Vice Mayor Grill.
Yes.
Commissioner Frislowski.
Yes.
Mayor Petrilla.
Yes.
Motion carries.
And unlike last time, this time we have a hard start at 10:10. We are adjourned. Before we proceed, Ms. Betzel, is this your last expert?
No, we have our civil engineer as well.
Okay. Just so that everybody's aware of the order. So we have 2 more experts, and then we will have public comments.
We have
after
the
that.
city expert too, Mayor, remember?
The city expert, yes, if we have questions for them as well, we'll.
Right.
Okay. Thank you.
All right. Good evening, everyone. My name is Becca Bond. I'm a licensed professional engineer in the state of Florida and in the state of Texas. And I'm acting as a transportation engineer with Kimley Horn for this development. So today I'm going to be going over the traffic impact analysis, also known as TIA. You might hear me abbreviate it throughout the presentation, and the results of this analysis for the Serrata Beach redevelopment.
Ms. Bond, I'm sorry, can I ask a question before we get going? Have you or Mr., and I'm sorry, I think it's Elfani, have either of you done any work directly for the city of St. Pete Beach while employed by Kimley Horn?
I have not, no, and neither has Tarek.
I'm sorry?
Neither has Tarek. Tarek Alfala, yes.
Tarek, excuse me, sorry for you. Thank you.
Of course.
Okay.
All right. So I know this is everyone's favorite topic, so I'm going to try to be as clear and concise as I can be. I know we've been here for a long time. So as I present, I'm going to go through the process and build upon it through each step. So please feel free to ask questions, but I think that it'll make a lot more sense if you allow me to build and we get to the final conclusions of the analysis, and then I think it might be more clear and I might answer some of your questions along the way. So on this first slide, you'll notice on the left-hand side, you'll see the major milestone dates, specifically for our Serrata TIA, including data collection dates and submittals to the city of St. Pete Beach. And while it might vary slightly by project or jurisdiction, the overall TIA process is very standardized across the industry. On the right-hand side, you'll see a flow chart that outlines the typical steps to completing a TIA, and I'll touch on each of these steps relative to Serrata in more detail on the following slides. So the first step in this process is the methodology, and determining the methodology is an iterative process with the city where the transportation engineer summarizes the proposed analysis approach and provides that to the city for feedback. Once that feedback is given back to the transportation engineer, so myself in this case, we incorporate the city's feedback into a final version of that methodology, so taking into account their comments and what they want included. So the approach and procedures outlined in the final methodology for Serrata included the proposed trip generation, which utilized hotel land use codes 310, 311, and 330 from the Institute of Transportation Engineers, also known as ITE, Trip Generation Manual, specifically the 11th edition, which is the latest edition. Also included in the methodology were the proposed analysis scenarios, being the PM and the Saturday peak hour, the proposed distribution, study area, growth rate, and vested traffic. So one thing I want to touch on that was a question earlier was about the transportation management plan. And what was referenced was in terms of decreasing the external trips. So I want to clarify that our analysis was completed with 0 internal capture. So we did not take any reduction or any assumption of people staying on the site. We used the standard trip generation rates that are in the ITE trip generation manual. So that TMP, traffic or transportation management plan, is written with qualitative strategies, and that mention was purely stating that there's ample pedestrian avenues created on the site so that people staying at the JW Marriott could walk over to one of the other restaurants and they can all intermingle on the site. But we did not use any reduction or any % internal capture for our analysis because we wanted a conservative analysis. So jumping into the distribution. So the distribution we utilized in the analysis was based on the Florida Standard Urban Transportation Model Structure. So we often abbreviate this in the industry as FSUTMIS because it is a mouthful. This is a computerized transportation model package, and it's developed by Florida Department of Transportation, also known as FDOT. The model is developed, maintained, and distributed by FDOT district staff. It includes elements such as roadway and transit networks, population, and employment data to calculate the expected demand for transportation facilities. So this is used to predict routes that trips will take based on socioeconomic data and the origins and destinations of travel activity within a region. So this is specific to the use that you put into the model. So we put in that this is a commercial, this is a hotel use, so it's specifically thinking about that and the other uses that are programmed in this model around there to determine where traffic is coming from and to the site. So as shown on this slide, there were minor adjustments that were made to the model output based upon local knowledge of the roadway network and in response to concerns voiced by city commissioners and residents that the model did not show traffic on the local streets of Gulf Winds Drive and Blind Pass Road. So in response to that, we allocated percentages to those local roadways so that we would show some traffic, assuming there could be some cut through. All right, next step is determining the study area. So the study area for the Serrata traffic study was determined based on the Forward Pinellas MPO traffic impact study methodology. So this is the standard that is set for the city of St. Pete Beach. So the code for the city of St. Pete Beach does not set specifics for study area for traffic analysis. They refer to the Forward Pinellas MPO for this determination. So per the Forward Pinellas MPO, study area roadway segments are defined as the roadway segments where project traffic represents 1% or greater of the available roadway capacity up to a maximum of 2 miles from the project site. The roadway segments that met this criteria were included in our analysis, and those are listed on the slide in that top section. The project traffic is for the study area intersections is those where the total traffic on the leg of the intersection equals or exceeds 90% of the maximum service volume. So the study area roadway segments are not anticipated to exceed 90% following build out of the project. However, for a conservative analysis, we included the intersections that are listed on this slide in our analysis. So that includes all of our project driveways, Gulf Boulevard and Gulf Winds, Gulf Boulevard and 55th, Gulf Boulevard and 46th, and Gulf Boulevard and 44th Avenue.
I'm sorry, I know you asked us to wait, but I'm not understanding the bottom of this chart, because from the bottom up, going north, there's another major intersection, I call it Gulf Boulevard and 59th. 59th Avenue is Bahia Shores. There's approximately 125 residential units on that street. A very similar layout as with 55th. So I'm curious why Gulf Boulevard and 59th was not part of the analysis.
So this is the list that we came together with the city engineer. However, technically none of these, per the Forward Pinellas MPO methodology that you're supposed to follow for the traffic study, none of these were required to be analyzed.
Then that doesn't make me feel better. Sorry.
No, and that's fine, and I understand. And
I mean, because it's 125 residents who are potentially impacted. So you're telling me don't worry about it because we went above and beyond, understood, but...
No, I'm just saying this is the first feedback that we've received about that specific intersection. And like our team had discussed, that this technically is not required with the CUP, the traffic study isn't. There is a site plan during the site plan process that is required, so we can always take additional...
So should we just cut this off? If it's not required, then don't do it.
No,
Let's move on.
I was actually going to suggest that we can take additional feedback, and if it's decided that that's required, then we're happy to study that and add that in. It just wasn't expressed to us that that was an intersection of concern by the city.
Okay. Understood.
But we have the commission as a line of last resort.
And then has
no clapping.
Has Gulf Winds Drive, are you aware, and has it been shared with you and factored into the analysis, that we have a major project coming up very soon for Gulf Winds Drive that will reshape Gulf Winds Drive and the use of Gulf Winds Drive from basically the, I'll use the word semi-speedway that it is today, and to try to force it to be a residential street?
Yes, and I believe that's likely why the FDOT distribution model likely did not assign as many trips there, because in the future, that will be discouraging cut-through traffic, which means fewer vehicles will
Yeah,
be
no,
traveling along
absolutely.
that roadway.
Thank you.
Yeah, of course. Okay, the fun part. We're getting a little bit more into the technical stuff here, but once again, I'll try to keep it as simple as possible. So for our traffic study, we utilize two sources of existing traffic volume. So that includes turning movement counts, which are the volume that are out on the roadway today. We have someone go out there and count those volumes. Then there are directional roadway volumes, which are provided by the MPO. So there's two different reasons for these different sources, and I'm going to try to go into detail for each of you so you can understand why we utilize both of these. So the first being the turning movement counts. These are used for the intersection operational analysis. These are not used for the capacity analysis, only for the intersections. So these were collected at the study area intersections on Thursday, February 9th, 2023, and Saturday, August 5th, 2023. The reason for the delay in those Saturday counts is it's not typical in most jurisdictions to study a weekend peak. However, we did receive feedback from the city that was of a concern. So when we received that feedback, we went out and collected those Saturday counts. And I want to clarify, we discussed this at Planning and Zoning. However, there was a lot of feedback and confusion around the peak season correctional factors, which I'm about to go into now. It is standard industry practice that existing counts are always adjusted by peak season conversion factors, regardless of the date of collection. So peak season conversion factors are published by the FDOT and selected based on the data collection date and the county, in this case, Pinellas County. They use historic traffic data to come up with these peak season conversion factors. So as we know here in the city of St. Pete Beach, the peak season is at spring season, like the end of March, early April. So you'll see that those peak season conversion factors are right around 1. So very little adjustment if you were to collect in March or April. However, our February counts and our August counts were grown by 11% and 10% respectively. So that means we took those counts that we collected on those days and we increased those counts by 10 and 11%. The second source of the existing traffic volumes used in the analysis came from the Pinellas County 2023 Annual Level of Service Report. These are published directional roadway volumes. These are utilized in the roadway capacity analysis. This is for concurrency purposes. So when we're talking about roadway capacity, when you get to that site plan stage, we were talking earlier about that's when the concurrency is issued. That is used to track all developments that come in to this jurisdiction. So I've heard feedback and I've talked to people in between during breaks. The question is, what if this generates additional traffic? What's going to happen then? Aren't they also going to place demand on our roadway? Yes, and that's why this is in place. So we keep track of the existing volumes out on the roadway. Everyone utilizes those same existing volumes published by the MPO. Then you add in any vested traffic. Vested traffic are any approved developments within, in our case, the city of St. Pete Beach. You include the volumes that they produced in their traffic analysis, and you're continuously building. So that is how you are going to get to that background traffic, and I'll get a little bit more into that later. But in terms of this, the roadway capacity is based on the existing volumes in the annual level of service reports published by Pinellas County. As I hinted to, this is how we develop that future background traffic. So before you even think about adding the project, you want to look at what the conditions would be at the build-out year, in this case, 2025. You want to know what it would look like without your project. How would it be performing? What does the growth look like in that time period? So after we establish those existing volumes, the future background traffic is determined and defined as all non-project traffic on the roadway network in the build-out year of the proposed project. So to do this, we use an exponential growth rate. And then we add on vested traffic, as I explained, from any approved development that's happened in the city of St. Pete Beach that does not have an existing demand on the roadway system. So an exponential growth rate was calculated using FDOT historic annual average daily traffic, and you've probably caught on, there's a lot of acronyms in transportation engineering, AADT, information for 3 nearby roadway segments for the 5 most recent years of data along Gulf Boulevard, north of Pinellas Bayway, Gulf Boulevard, south of Blind Pass, and Gulf Winds Drive, north of Gulf Boulevard. This calculation produced a negative growth rate. However, we wanted a conservative analysis, so we utilized a 2% growth rate. And a reminder, this is an exponential growth rate, and I'll detail that in a second.
I'm sorry, can you cover again the 3 roads nearby to Gulf Boulevard that were included?
Yes, and let me tell you, taking a step back, these are determined based on where FDOT does their counts. So FDOT has specific locations where they collect counts, and you can go and use their data to develop these growth rates, and that's industry practice.
Because the only roads around there that we have on Gulf Boulevard are small residential roads. I mean, this is a uniqueness to St. Pete Beach. I mean, those of us who live here know it. We've got one road north and south. It accommodates everything from a 1-wheeler to an 18-wheeler. All the other roads are small residential roads. Gulf Winds Drive for today continues to be the feeder. What's the appropriate word?
Collector.
The collector, some sort of a collector road, but it's going away.
Mm-hmm.
So I'm curious which roads they are, because as I say, all the other adjacent roads are residential roads.
I'll repeat it for you. I'll slow down.
No, it's not the speed. I'm following you. It's which roads were they, and why would they pick a small residential road?
They weren't small residential roads. 2 of the 3 were Gulf Boulevard. There was a count station north of the project and a count station south of the project. So those were 2 of the 3 that we utilized. And then we utilized one count station on Gulf Winds Drive, just north of Gulf Boulevard. So those were the 3 count locations that we utilized to build the growth rate.
Okay, thank you.
Mm-hmm. And we also confirmed with FDOT that they had concurrence with this growth rate. They agreed with the 2% growth rate based on their models and their volumes that they've seen in the area over the past 5 years. So to reiterate, this means we adjusted the existing traffic volumes using a peak season conversion factor of 10 and 11% respectively for PM and Saturday peak. On top of that, we grew the growth using an exponential 2% growth rate. That means 2% every year, and then the growth from each year is also built upon, similar to an interest rate, from 2023 to the build-out year of 2025. So we've had 2 percentage increase adjustments. On top of that, we also included vested traffic from the approved Miramar and Corey Landings developments. So on top of the percent growth, we've also included the project trips that were included in those traffic analysis. So that gets you your future background traffic. Then finally, when you get to your future total build out is when on top of all of that, you add in your project traffic.
So the analysis at one point, I know that was in and out, trade winds was in, was out, was in, was out.
So
Now
trade
it's out.
winds is not included in this because our application was formalized and submitted before trade winds. So the trade winds analysis
Do you want to repeat that? Your application was submitted before trade winds?
I know that our application was deemed complete before trade winds. Let me clarify that.
To make sure we're correct here, right?
Yeah, absolutely. Thank you. No, I do appreciate that.
The Corey Landings project was included, though.
Yes, Corey Landings.
No longer a project.
I know, yeah, it's an approved project and they have a concurrency certificate, so it's required to be included.
Okay.
If anything, that would make it more conservative, but yes, exactly. Trying to get back to your question.
Trade winds.
Thank you. So, no, but the trade winds development will be required to include our trips, assuming that our trips are approved, or if the city requests them to include it, even though technically we don't have a vested concurrency. That's up to the city on how to handle it, but that's industry standard for how it's completed, is whoever is deemed complete, you only include approved vested developments. All right. Moving to the results of the analysis. So the Serrata study consisted of 2 different types of analysis. roadway capacity analysis, and intersection operational analysis. And these were conducted utilizing the existing, the background, and the total traffic volumes previously detailed for both the PM and the Saturday peak hour. The roadway capacity analysis was based on the service volumes published in the Pinellas County, as I've repeated before, 2023 annual level of service report. So the Pinellas County service report determines what the jurisdictions consider an acceptable level of service or the maximum capacity for these roadways. Based on our analysis, the roadway segments are anticipated to have sufficient capacity in both the PM and the Saturday peak hours at build-out of the proposed development. And on a later slide, I actually have bar graphs that I think are a great visual for that. So that is coming in a few seconds. The intersection operational analysis was conducted using Synchro version 11, which is a industry standard software, using Highway Capacity Manual HCM 6th edition methodologies. The results of the Synchro analysis indicate that all intersections are anticipated to operate with a volume to capacity ratio of less than 1 for each lane approach, meaning that each lane approach is below capacity, and an acceptable overall level of service. So we talked a little bit about the ways this TIA is conservative. And one component that we have is the fact that there is an existing Serrata resort here today. So we did collect driveway counts at each of the existing driveways and determined the current existing trip generation. We compared that to what the ITE trip generation determines would be anticipated for this site. In existing conditions on a dwelling unit basis, the volumes that we are seeing out there today are lower than what is proposed by the ITE trip generation. However, we utilize the ITE trip generation rates for a conservative analysis. So despite that we could have claimed the existing site's not generating as much traffic, we utilize the rates that are set by ITE that are industry standard in our analysis. We also discussed the growth rate and how the historical FDOT AADT data showed a negative growth rate. However, we proposed a 2% growth rate, and on top of that included the 2 vested developments that we talked about, Miramar and Quarry Landings. And finally, throughout this process, the new 2023 MPO data was published. So we did update our report to be based on the 2023 data, and that lowered the threshold for the adopted level of service and capacity along the study area roadways. And Mr. Grill, I think that this is part of what you were hinting at, is the DOT is anticipating and the MPO are anticipating future improvements for traffic calming measures to be used in this area. So they are lowering the capacity, acceptable capacity and level of service in their tables in order to plan for that. So by updating to those 2023 volumes, we were conservative in that we're anticipating those improvements to come. Okay, so this is the visual that I think really helps. I've spent the duration of my presentation so far really digging into the technical details of the traffic analysis, but I hope this pulls it all together. On the screen, you'll see a bar graph with each of the study area roadways present along the x-axis and the traffic volumes present along the y-axis. So this first graph is based on the weekday peak hour traffic volumes, and I'm going to flip to the next one in a second. That'll be the weekend or the Saturday. The blue represents the future background traffic volumes, so we discussed all the growth rates that go into that, the vested developments that go into that. The orange represents our project traffic volumes for the Serrata Beach redevelopment, and the green represents the remaining capacity along each roadway segment based on that 2023 MPO data. So the capacity that's determined by the MPO based on existing projects planned and current geometry of the roadways.
So even though the studies, the weekday study was at a particular hour of the day, does the model extrapolate so that we can say, this is 24/7? Or is this for a particular hour of the day?
So this is for a particular hour. So the MPO, and this is pretty standard for any jurisdiction that has concurrency, always compares the PM peak hour.
So what time of day was this again?
So the PM peak hour can technically range anywhere from 4 to 6. It varies based on the day.
Right, but I understand. What day was this based on? Whatever, you should label the chart so that we know, because I think the other chart said 4 to 6 p.m. Because, and then my next question is, what capacity does FDOT consider? So this excess capacity or movement, at what speed? Because Gulf Boulevard's a 35-mile-an-hour road. Does it assume 35 miles per hour? Does it assume 5 miles per hour? And I can tell you, those of us who live here coming in from Pasadena Avenue, trying to come in and out, depending on the time of day, I don't know where the excess capacity is, but many of us don't experience it.
So capacity is not necessarily defined based on speed. Capacity is defined as 1.0 capacity. So think it's a volume to capacity ratio. 1.0 is absolute gridlock, which we're not there in this study, and that's shown in the tables in the analysis, but 1.0 would be gridlock, and then 0 would be absolutely no volumes on the roadway.
Okay.
When you're talking about capacity, the MPO and the DOT determine vehicles per hour. So the maximum vehicles per hour before you get to that gridlock stage. And that's determined based on many different characteristics of the roadway. It's determined based on the drivers, the vehicles that you experience. And the MPO does a lot of research that goes into this, that puts these numbers together, that puts these capacities together. And to go back to your question about which hour is it, it is and I'm not trying to be difficult, and I'm not trying to avoid the question, any hour between 4 and 6. So for our study, it might produce the heaviest volumes between 4 and 5. If another study has the heaviest volumes between 5 and 6, we are putting those on top of each other for the most conservative analysis. So it's not necessarily, as a whole, everyone's highest hour is 4 to 5. It is most conservative, the highest of each project.
No, I understand, but the concern, and I understand the math and how the numbers work in the conservative approach, because it's all statistics. The concern from residents' view, from the residents, is we're not moving, the traffic doesn't move quick enough today, and we're going to add more cars. And the other complicating factor is last 2 years, we've done an undergrounding project on Gulf Boulevard, which has really upset the traffic. Sometimes we're one lane. We had periods of time where 1 lane north, 1 lane south. Sometimes we even stopped the traffic.
Mm-hmm.
We're going to get back to that phase because we laid the conduit, and now Duke's got to come in. There's going to be cable being laid. It doesn't move. So to say that the road, here's where we're trying to bridge. You say the road's got capacity. I understand all the math and the graphs. It's all good. But the road's got the capacity, and we can put more cars on it, but we can move 1,000 cars at 5 miles an hour. The model will say everything's okay. And people, I don't know if the gentleman's here who used the example of buying his ice cream in Publix, and the time he got home he had a milkshake, right? We've all been quoting that for years because, well, and then the complicating factor, of course, in Pasadena, the drawbridge, but that's the joy of living on a barrier island. I mean, that's not a, we all live,
absolutely.
I mean, that's my choice.
And I understand the frustration and what you experience when there's construction out on the roadway. The reality is we don't perform traffic analysis for those times where there's construction and an entire through lane is closed.
No, I understand, but I understand the numbers, and you're very clear, the charts are good, shows everything, but the reality is people look at this and say, really? You want to share my milkshake? Come on.
Yeah, absolutely, and I understand that perception, and I'll be honest, I'm local. I understand that there's been a lot of construction, and the goal of these traffic studies is it's planning for the future. It is planning for the typical condition, not the,
Where are you located?
I live in Tampa. My favorite coffee shop is Grove Surf and Coffee, which is about 2 blocks away. So
Not quite local.
No, and I'm not claiming that, but I am claiming that I do drive here, and I do see the existing conditions out there. And
no, please, look, anyway, we can go on.
If I ask the expert a question about capacity.
Sorry, I couldn't hear.
Do you mind if I ask a question of the expert about capacity? The studies, this is not the only study Kimley Horn's done. I've seen the study before this. There was this, I think y'all did the study at the West Quarry, the Quarry Landings. I'm not sure if you did Miramar or not. So I've seen consistently the analysis including a threshold of 90% of capacity and staying under 90% of capacity. Is that right?
The threshold for 90% is when you get into the intersection analysis. I will say that on all of these, we're below 90% capacity.
And then you keep saying that in every report, it's below 90%. If you look at the second line here, the Gulf Boulevard chart during peak, and you have this green up here. I assume that the green, from the orange to the green, is where we come up to meeting capacity.
Correct.
Okay. So how far on Gulf Boulevard are we from capacity? What is that numerator?
Someone has a calculator.
In other words, because you got two projects in here other than the Serrata project.
Well, I think a different way to phrase it is, right now, what is the Gulf Boulevard rating? Now,
Yeah. But I want to, yeah.
and I'm saying
Working backwards, we have 13, but what does 13% mean?
no, I'm saying what's the rating of Gulf Boulevard right now? A, B, C, D, E, F. Which one of those is it?
Is D.
No, we're below level of service D. That's the requirement that's set by the
You're
MPO.
using the Ford Pinellas, that's what was in your package.
Correct.
And that
Correct.
says D.
It's below level of service D. We're saying that level of service D is the acceptable standard. We are below level of service D, so we are not at level of service D.
We're rated at D.
I thought we were D.
B?
D,
D, yeah.
Yeah.
D as in dog. Where's
Let me open the table. I have it right here.
Yeah, okay. That's what, the conclusion said,
Of the level of service D capacity.
Yeah.
I think they're asking.
I think the conclusion said we're at D and we're staying at D.
No, the conclusion says that we are held to the standard of level of service D. We are not exceeding the level of service D.
That wasn't the question. We asked where we are today.
I would need to, they don't, in the tables, they don't set the different letter grades. They set the standard for which you are held responsible for. We can go look at, FDOT produces tables, so we would have to go actually calculate what each level of service threshold would be. I do not know that off the top of my head. I can calculate that for you, but.
So what's the threshold for exceeding D?
So it's different for each roadway and for each segment. So if we're specifically
for your
talking Gulf
project
Boulevard.
on Gulf Boulevard.
Okay. I mean, we have multiple study intersections, so I just wanted, or study roadways, so I wanted to check. 1630. So as you'll see on this table, Gulf Boulevard, 75th, Bayway, and Blind Pass are all at that 1630. So just above that 1,600 vehicles per hour.
Is what?
1,630 vehicles per hour is the
Capacity.
level of service D capacity that is the standard set by the MPO.
Which is the max out. Capacity means capacity, the most, right?
For level of service D. So level of service F, there's additional, there's E, there's F that come after that. So F would be absolute gridlock. So yes, for the standard that's set as acceptable by the MPO and therefore the city of St. Pete Beach, that is level of service D. So that is 1,630 vehicles per peak hour.
And what are you at, 1380 on Gulf Boulevard? I'm guessing. What's the number there?
1380, roughly, more, 60, 80.
Tarek says it's 1363. He's looking at the table.
There's a lot of different segments.
Yeah, there's many. What's the maximum? The highest?
1372.
1372. So obviously that would be right in front of our site where all of the project traffic, northbound and southbound, all converge on that one segment.
Are you done with your presentation? Because we have a lot of questions. And so
I know.
we also want you to get through it as well, so.
Yeah, no problem. I'll skip, this one looks
You don't have
very.
to skip anything. We
No,
don't
no,
want
no,
you
I'm
to
not
skip
skipping.
anything.
I'll go to the next one. This one looks very similar. This
So
is,
the blue is the capacity. The blue is where we are today. The orange is what the model says the project will add. And the MPO says we can go to the green.
so the blue is not where we're at today. The blue is our existing, grown with the peak season. So peak season of today, the additional 2% exponential growth rate, plus the background volume, so Miramar and Quarry Landings. So that's the blue. Then the orange is our project traffic, the green is the remaining, up until that level of service D capacity.
So when you say vested projects, how far out do you have to go?
So a vested project is anything approved that is not currently built. So those volumes, the completed project, those volumes are not on the roadway. So they wouldn't be captured in our existing counts.
Yeah, to what radius?
Within the city of St. Pete Beach. And this is determined with the city's staff in that methodology process. So
Because at the planning board meeting, you referenced Maximum Marina and some of the other developments just on the other side of the Bayway.
I did not. I believe they were used as a reference in terms of other developments, because there aren't a lot of examples of developments that have come through the city of St. Pete Beach because of the moratorium. Those were used as examples of common growth rates used in the general jurisdiction. That was not in terms of any background trips that were added to our study.
We're all ears.
Awesome. So I'm going to move into the criteria, like the other experts have done. For transportation, there are two criteria to mention. So the first one is section 4.4A3, and this states whether the transportation system is capable of adequately supporting the proposed use in addition to the existing uses in the area. Evaluation of factors include street capacity and level of service, access to arterials, transit availability, on-street parking impacts, if any, site access requirements, neighborhood impacts, and pedestrian safety. So I know we've talked a lot about capacity and level of service as we talked through questions in my previous slides. But as I've detailed, the traffic impact analysis reports acceptable capacity and no level of service deficiencies or intersection failures for either the weekday or the PM peak hour. There are no neighborhood impacts aside from general and studied impacts to the roadway capacity and level of service. The project has direct access to an arterial roadway with improved site access and the addition of abundant on-site queuing to relieve any stacking along Gulf Boulevard. And I know we've touched on queuing a few times, and our civil engineer, Scott Gilner, will get into that in his following presentation. Transit is available. No on-street parking is proposed for the development. All parking is on-site upon completion of the redevelopment. And finally, increased pedestrian safety is proposed with a 10-foot sidewalk along Gulf Boulevard, ample additional beach access, and a 15-foot public access easement landward of the wet sand, which Elise mentioned. So the second criteria and the final transportation criteria is from section 4.12A2. This states that transportation infrastructure, including ingress and egress from public rights-of-way, traffic control devices and signalization, internal vehicle circulation of the site, design and function of parking areas, loading and unloading areas, pedestrian transit infrastructure and amenities, and public sidewalks and roadways. So, like most of this has been, is a big mouthful. But the proposed development has improved the access, has abundant on-site queuing proposed, no signalization is necessary, parking meets code, and the site provides internal circulation and cross-connectivity between the buildings for vehicles and pedestrians, has dedicated loading areas, which are properly screened, and has pedestrian access throughout the site and connecting to the new 10-foot sidewalk that's proposed along Gulf Boulevard. And then before my conclusion, I just wanted to discuss that the traffic study did go through peer review. So as mentioned, the traffic study was reviewed by the city's transportation engineering consultant, which is standard. The letter that they produced stated that they agreed with the procedures, analysis, and conclusions in our report. The report followed industry accepted procedures, and the growth factors, adjustment factors, and the distribution model are in line with ITE and FDOT accepted methodologies. And finally, they consider the report, its analysis, and conclusions to be adequate for the Serrata Beach Resort redevelopment project. Additionally, as I mentioned, we discussed with FDOT the growth rate, and FDOT stated that they concur with the city's approach after reviewing the growth rate for the last 10 years, and in review of the capacity of State Road 699 and Gulf Boulevard in the city of St. Pete Beach. So, in my professional expert opinion, the transportation system is capable of adequately supporting the proposed use in addition to the existing uses. The proposed site transportation infrastructure is sufficient to support the proposed use, and the proposal satisfies the sections 4.4A3 and 4.12A2. Thank you.
Don't go
Additional
anywhere.
questions?
Oh, there'll be plenty of questions, I'm sure.
Yeah, no problem. I think they said they have questions. Yeah. No worries.
We have questions. What is FSU TMS?
The pseudomus. It is it's always a mouthful. So let me pull up my reference, because I always mix up the order of the words. But pseudomus, which I outlined in the presentation, is the Florida Standard Urban Transportation Model Structure. So this is a computerized transportation planning model packaged and developed by FDOT. So they maintain it, they add in projects, they update the volumes, they update the inputs, the socioeconomic data, and it's used to produce proposed distributions that we anticipate for upcoming developments.
So your development numbers that you're using for anticipated completion day by 2025, which is when the traffic numbers would start having significant impact. So what does FTUMIS use for a future projection date?
So pseudomus is just used for the distribution and the distribution alone, which is where the anticipated trips to and from the site are coming from in the adjacent area. So we don't necessarily input a build-out day. We input our project traffic, the use that we're proposing, and the density that we're proposing. And then based on the socioeconomic data and the other projects in the area, the existing volumes, it produces distributions along the roadway, percentages of where the project traffic is coming from on the adjacent roadway system. So it's just for the percentages of traffic.
And when you calculated your net new trips, how did you calculate those?
Absolutely. So I calculated those using the ITE Trip Generation Manual, 11th edition. It's likely the most standardized thing in all traffic and transportation engineering. There are studies that are completed and updated, it's the 11th edition, that existing hotels of all different types. So as I mentioned, we use 3 different land use codes, 310, 311, and 330. Let me really quickly. Those land use codes are for a resort hotel, and an all suites hotel. So this ITE Trip Generation Manual gets very specific about the different, all these different land use codes and all these different land use types. And they study similar uses that are existing on the roadway to determine trip generation rates and equations that standardize what trips are anticipated from the development. So what we did in this case was, there's obviously existing dwelling units, existing hotel rooms that are currently on site. There are some that are being demolished, and then there are some that are being built in excess of what was previously there. So the net new number of units of hotel rooms, we calculated based on the ITE trip generation rates and equations, the proposed trips that are anticipated from this development.
So your report states that the various restaurants, offices, meeting spaces, and ballrooms are all considered ancillary uses to the primary use.
Correct.
So did you take into account traffic for restaurants, offices, meeting space, ballrooms, retail stores, conference centers?
Those are taken into account by the ITE trip generation rates and equations that are produced in the manual. So all of the, like I said, they're studying similar existing hotels that have those uses in place, and they're studying them as one hotel land use. So the rates already have that built in. That is considered, and that's stated in the definition in the manuals for these land use codes.
Okay.
There was a comment in the conclusion about available public transportation, and I don't know if you were updated, but it says it includes the Central Avenue Trolley and Route 90. Both of those have been curtailed by PSTA. The Central Avenue Trolley's gone. It has been, the service was ended, excuse me. At Route 90, the service was curtailed. So don't know how much, if any, those were taken into account in the study, because I know there's talk about public transportation.
Yeah, so those were just qualitative statements of the existing resources available, which you're stating are no longer in use. But those were no reductions were taken in our analysis for any public transportation. So we used the standard rates. We took no reduction for rideshare. We took no reduction for public transportation. Those were qualitative assessments that were in regard to the transportation management plan.
Right, in the conclusion of that, which I guess shouldn't have been there then. Okay, got it.
On the same line, on page 293, you have Pasadena Avenue. Once you take 75 over the bridge,
Will you clarify what's your question?
you have it as 6 lanes, it's 4 lanes.
I'm sorry, which page?
293?
293 of the packet. And while you're looking at that, I mean, this was brought up, and we had the same debate on the East Corey traffic study, also done by Kimley Horn, that Pasadena Avenue is not 6 lanes, it's 4 lanes, because the Sunrunner took 2 lanes away on each side.
And you have that 3 or 4 times in this report?
As I stated, these tables are based on the MPO tables. I will go and double check, and I'm happy to update.
If the data is incorrect, it's your responsibility to make sure that we have correct data here. Is it not?
Yes, I agree with that.
Thank you. Do we have counts on the different roads and then also to the driveways for the adjacent properties?
I'm sorry, will you repeat that question?
Yeah, so the property is located across from a commercial property, across from 2 condominiums with driveway cuts. Do we have counts for those turnoffs?
For the driveways that were present across from or adjacent to our driveways along our property frontage, yes, those counts were included.
Where can we find those, please?
Why isn't Gulfport Boulevard South and Shore Drive 6 lanes? Because that's where the electronic billboard is, and it drops down to 3 lanes one way and 3 lanes the other by Palms?
No,
Is that where it is?
No, once you cross the drawbridge, they took 2 lanes away for the buses.
Yes.
So now
But there's still 6 lanes there, right?
Can't use them.
But there's still 6 lanes there.
There's 6 lanes, but there's 4 traffic
Well, I
lanes.
understand they put the bus only lane.
And I do want to clarify, Tarek did just check the MPO's tables, the 2023 updated tables. They do list it as 6 lanes with the capacity. We are required to match those tables set by the MPO.
Peace, understand, but the reality is they're not 6 lanes. And we had this discussion, Elise left the room, she will remember, we had this exact same discussion with Corey Landings, because the same assumption was there.
So back to cut counts.
So all of the counts that were collected should be in the appendix of the report. Tarek will double check.
Yeah, they're in the appendix.
Which page, please?
We'll have the page in the report, but not in the full package.
Give me the page report, that's fine. We have both.
It's right here. No, that's it.
There's a lot of pages in there.
It's 212 pages, yes. It's a lot of pages.
It starts on, it's Appendix D.
Appendix D, it's labeled as raw turning movement counts and peak season factor category report. There is no, the appendix are not numbered.
So, Mayor, I think it's...
And for clarification, for the access, we study for obviously level of service, but we're primarily looking at requirements for turn lanes when we do the access analysis. So it's not always pertinent to necessarily look at the driveways on the opposite side unless there's a need for signalization, which in this case there is not.
Well, you have your driveways on here,
Correct.
and we should know how it impacts the other driveways, right? Is that unreasonable for us to have that information? You have 3 driveways on one side, you have 3 driveways on the other side. I think it'd be good information to know what it is we're looking at and what the numbers are.
Appendix D is 323. 24 at the time, 324. I don't know why I have it. I don't know. Different wording.
I know we have some of the counts for the adjacent driveways. We studied the intersections and access analysis per code and as requested by the city engineer.
Because the difficulty just in that area, there are, as you know, there's condominium units, particularly buildings, particularly on the east side of the street, that are not at a street, but they're large units, the large number of residents, and crossing, turning, depending where you are, going northbound or southbound, and having to cross traffic. I mean, it's a 4-lane road. There's no, ideally, there'd be a turn lane or something. It just doesn't exist.
Yeah.
Is the difficulty.
Yeah.
So.
And I talked about improved access. So it always seems, it's like access vehicles. Who talks about that? Transportation engineer, civil engineer. Civil engineer is going to talk about the site plan and some relocations of our access to better align, to reduce the number of conflict points. So he will be answering some of this question.
So that's why I want the numbers from you, so that when he gets up and talks, we can talk intelligently. Right now, we don't have any numbers.
There are numbers provided. The numbers are in the counts in the
He
appendix.
wants to come up, and then you can come back and tell us where those numbers are?
I have told you where those numbers are. They're in Appendix D.
I'm looking at Appendix D.
There's turning movement counts at all of our project driveways and all of our study intersections.
This is Appendix D.
Correct.
Right.
So where's the Belgrande and Boca Sands?
I do not know if we have the counts there. We were not requested, we're not required for our analysis to have those. I think some of them may have been captured. If they're across directly adjacent from our driveways, then they should have been captured. But I can't speak to the others.
Okay. Look, I think, thank you. I mean, this is a lot of work and a lot of numbers and a lot of analysis. The concern, traffic, as you know, is a concern. It's particularly concerning for the neighbors around the area, particularly on the east side of Gulf Boulevard, let alone to the north, Seamark. And the fact that we are not, and I talked about it earlier, the concurrency that I don't see being done, and we're going to wait now till we do trade winds. And yes, you were approved before trade winds. It's going to come, and it's going to come very soon.
Well, I do
How
want
do we take a look at this as a commission holistically, and what's the condition going to be?
I would love to clarify that this analysis is per concurrency standards. So this could, if it was a possibility for a concurrency certificate to be issued now, if the city deemed this an accurate, complete study, which their traffic engineering consultant did, we could be granted concurrency, but that it does not happen at this stage. So that's the only reason why that's not happening.
So let me explain it a different way, factually. Concurrency has to be concurrent, right? You have to determine that your impacts at that specific time, that there's capacity on the roadway. We could get this conditional use permit. We could wait 7 months before we go in for building permits, and 3 other developments along the roadway could come in and say, I'm going to redevelop under the current zoning today, and I'm going to go ahead and submit my site plans. They get ahead of us in line. And so when you talk about concurrency, it means that we have to show to you that our impact on the date that we are putting building plans, getting site plan approval and building permits, that's why we're saying this is preliminary. Staff asked us to do a traffic report to show you preliminarily that there was adequate capacity today, but we have to redo this again. We have to redo this with utilities, we have to do it with water, we have to do it with all of the things that we have to show concurrency on, because we don't know what's going to happen between today or the day this gets approved or not, and the day that we come in to get those building permits, and your staff can't issue the certificate of concurrency until those things align. It is a timing issue. And so I think that's what Becca's trying to say in a different way, is that you can't know about concurrency for sure at this stage. But what your land development code says is that we should show you the transportation impacts from a conditional use permits perspective, and that's why you have those criteria. And so that's what this study does, is it says, we are looking at this today, and today, here's what the situation is. But we have to go through this again, and we have to show to your staff and your city engineers at the time that we pull those permits that this is still the case. It may not be. You could, let's say this goes through, we come back, whatever, you guys approve this conditional use permit. That doesn't mean that we get to build this project. We have a lot of additional steps to go through before we're at that position, and concurrency is one of those. Thank you.
Thank you.
How many of these have you done?
Of these hearings?
Yeah.
Or, I don't know. Too many to count?
Yeah. How many times have you found the road deficient?
Oh, plenty of times.
Like, give me a number, like 10%, 20%?
I cannot guess that for you.
Okay.
Plenty of times.
Plenty, it's kind of nebulous.
I am not venturing to guess on a number that I do not know.
More often than not, less often than not?
I'm not guessing and predicting.
Thanks. Any other questions?
No. Thank you.
Oh, I'm going to introduce Scott Gilner, civil engineer, to come up next.
We'll let you all finish and then.
Okay. For you tonight, council members. My name is Scott Gilner with Kimley Horn & Associates, 201 North Franklin Street, Tampa, Florida, 33602. I'm a civil engineer registered in the state of Florida. I've been with Kimley Horn for, this is my 23rd year. And so happy to be here tonight to kind of run you through the civil engineering aspects of our presentation and go from there. I'm going to hit on, I hope I cover a lot of the questions. I think Commissioner Maroney, you had one about 6 inches of rainfall and other things. Those are all going to come through here as I go through, so bear with me for a little bit, but feel free to stop me if you have any questions as we go. All right. Okay, so this is kind of, I think the first step we kind of talked about, stormwater design requirements. So when we design, much like you do steel or concrete, you have to design to the worst case scenario. So in this case, we have the city of St. Pete Beach, we have Swiftmud, the Water Management District, and we have FDOT, who has their own rainfall data and what we have to run from a stormwater perspective. We look at all three, and then we evaluate the worst one, and we actually model to that, and we design it. So as you see on the screen, and I'm going to get more into the city of St. Pete Beach because you guys have a very specific criteria. You have a very old infrastructure. You have a lot of old, I'll say, what's the best way? Mature properties that have probably were developed way before these codes existed. And so you have a lot of kind of little nuanced things that I'll show you some pictures of that I think come into play. But City of St. Pete Beach in particular,
What you all look at is the 25-year, 24-hour storm, but what's critical is you go back to a naturally unimproved site. So that's a critical piece where you don't get to count all the pavement and all the buildings that are out there today. You actually look at it as if it were a grass or a naturally unimproved site. So that becomes a stormwater criteria as you kind of work through there. However, SwiftMud has a more stringent criteria with what they are, and then DOT has an even more stringent criteria because we're tying in via pipe connection to the FDOT system. So we're down to the 3-year critical storm event, and as you'll see, you have 22 CFS allowable by the City of St. Pete Beach, 10.8 CFS allowable by SwiftMud, and only 2.77 CFS allowable by FDOT. Oh, cubic feet per second, I'm sorry. The discharge rate you're allowed via the pipe connection. All right, so this is kind of what I was talking about. As you drive up and down Gulf Boulevard, you'll see kind of all these little nuances. You'll see higher pavement sections, you know, they're sealed, pavement's been sealed, so it's old, it's been there 20 some odd years. Sheet flows right out the driveways. You see a lot of that all over. You also see these little nuances where they probably had a localized flooding area. They saw cut through a curb. It now goes through the island, comes out through the sidewalk, ends up in the DOT right-of-way. So these are all the little kind of nuances that code that the City of St. Pete Beach has in place is going to kind of take into consideration, and with the redevelopment comes into play. So that's just kind of an example of what we're talking about here. So we hit on this on the first slide. City of St. Pete Beach, we're not using. The critical storm event we're using is FDOT. So in every storm event that we run for this entire site, 10-year, 5-year, 50-year, 100-year, we're using that criteria of 2.77 CFS. That's the only allowable part we're discharging. And what that means is on our site, because of the beach sand that we have on the site and the percolation rates we're allowed, we're actually only discharging in the largest storm events that FDOT has. All of the SwiftMud criteria and all, both the 25-year and the 100-year storm events, everything is retained on site, percolates into our vaults, never actually discharges out into FDOT's right-of-way. The only time we do that is in the largest storm events of FDOT, and it's really kind of more of an emergency outfall that instead of staging up beyond the vault and then it actually spilling out other places, we actually have a pipe connection into Gulf Boulevard that discharges out only in those largest storm events.
I'm sorry, can you, for the layman, convert 2.77 CFS to how much rain per minute?
Let me get to some of those slides, and so 2.77 CFS is what we're allowed. That's based on a certain storm event. It doesn't. It's hard to explain, but it works in a bell curve, right? So at the beginning of a rainfall event, the water doesn't go anywhere, and then at the very top of that bell curve in the FDOT, and I'm going to show you a slide here in a second. That top piece of the bell curve is only when that discharge rate goes out at 2.77 CFS or allowed to go out at 2.77 CFS. Once the water gets down below that elevation, no water goes back out and everything else percolates into the ground. So there's only a period of time at the top of the bell curve where that water is going to go. It's hard to say because as you get to that triangle in the bell curve, it's 0, and then all of a sudden it's 0.1 CFS, and then it goes up to 2.77 allowed, and then it comes back down and drops back down to 0, then everything stays on site. Does that make sense?
It does, but how much rain? Is it a garden hose, fire hose?
It's, so the 1.99 we're talking about, 16 inches of rain. 16 inches of rain.
In what period of time?
72 hours? 72 hours.
16 inches of rain in 72 hours.
Yeah.
Okay, we should never have that.
Yes, that's kind of the point.
Okay.
So with the stormwater system, as we're working through this, we're really breaking it down into 3 sections. The blue section to the north is the JW Marriott. It actually covers the new Port Cochere in front of the Serrata, and that all drains into the vault system that you see are the kind of little Lego blocks in the center of the JW Marriott parking lot on the ground floor. And all of the blue pipes or lines, those are the pipe networks pulling all that water in, and only the purple lines that go out to the FDOT right-of-way are where that water discharges from the vault. In the center section, you've got the orange area, which is the existing serrata, and that basically stays on site and percolates into a drain field as it does today. And then on the south side, we have the green area, which is the Hampton Inn, has another vault system, pipe network around it, same system, effectively stages up, only discharges out via to the FDOT right-of-way in the largest storm events, and we move on from there.
And are the purple lines gravity flows?
Yes, everything on this is gravity flow. There is no pumping. Gravity is our friend when it comes to stormwater. So yeah, we don't want that. Let me see here. Hit there. I think we kind of hit on this, but basically I think this is an important part. So when we're out on the beach, a barrier island like this, one of the things we're looking at is what is the percolation rate? And because of the site characteristics and the beach sand that we have out here, that's one of the great benefits we have. I don't often get to design a system like this where we can perk that much water into the ground. But the rates you see here at 40 feet per day, that's feet per day draining down horizontally. So that water goes into the sand, excuse me, and then basically percolates out 40 feet per day in terms of like a column of water. And then vertically 26.6 feet per day. That's what the geotech provided to us as the hydraulic conductivity for the property. Now what we do when we design it is we actually cut it in half. So 40 becomes 20, 26.6 becomes 13.6. Just like a factor of safety you would do with designing steel or concrete, we do that when we do stormwater systems. Both of these vaults that we were showing on the screen before, the blue to the north and the green to the south, they're open bottom. So basically, they're going to have walls, probably like a stone kind of almost footing or bedding, and then beach sand on the bottom, and that'll effectively perk out into the water or into the groundwater from there.
So what prevents in the blue at the north and south from the water not perking and going north and south?
Well, it is going to perk north, south, east, and west. I mean, that's what all of the beach does.
And asked another way, then, how does it not affect the properties to the north and south, potentially? Because that's a...
In what manner? Yeah, so just
probably a water runoff issue, high to low.
Yeah, so it's not runoff. It's percolation into the groundwater. So basically, we basically put the vault bottom 2 feet above the groundwater elevation, the highest groundwater elevation, and then that water we get stacked up actually dissipates down into the ground and percolates out as if there were no development on this barrier island. It doesn't really run off. It goes down into the sand.
Into the water table.
Yeah, correct. Which is nature's filtration.
Yeah, right, yeah.
Right? So.
Thank you.
And basically, another way of looking at it in that last diagram,
Oh, I'm sorry.
I thought maybe your concern was, for example, the blue area, concern that it doesn't run into the property to the north, to the C mark. Those blue lines are pipes.
Yeah,
those little round dots are drains, I assume.
Yes, sir. That is correct. So
it's sloping the drains, being conveyed to the vault system, and then draining through the vault system. So it's not draining over the whole blue area. It's only draining where that grid is, which is a vault.
You're 100% correct, and that's the other reason why we put the pipe outfall to FDOT. If we've just perked it, right? From an engineering perspective, you always want redundancy in your system. We talked about gravity. Why do you not want pumps? Because when the electric goes out, you've got an issue. In this case, what we want to do is we want to have that pipe outfall to FDOT because it allows us to basically percolate the lion's share of what's going to be on the site. But in the event we get a major 16, 20-inch rainfall event, we get a Harvey that's here like Houston had where it stacks up 20 inches, you want to have that outfall, secondary outfall that gets out. So that's the whole reasoning behind it.
Where does that go once it gets the outfall in that case?
There's a whole pipe network along Gulf Boulevard. I want to say it's on our side of the site, but there's a series of laterals. It runs down across the street, and I believe it goes out one of the roadways where it goes out to the bay. Yeah. Difference here is what goes out there today really isn't treated.
Right.
And what we're talking about is only in those major storm events do we discharge, whereas everything else is basically filtered through the sand as we go.
This is going to be a big improvement here.
Huge.
This is
I can't hear.
This is going to be a big improvement in this area. For those of us that have driven this area, particularly right here in a storm event, you cannot drive the slow lane, and in some cases, the only lane to drive in to get by is the middle lane, which you're not really supposed to be driving in, especially if both sides, north and south, are trying to drive in that lane.
So I think I hit this one. So we talked about a lot. This is kind of another example of, this is a schematic of the vaults, but hotel and 1 and 2, 3 effectively have same groundwater elevation, same bottom of vault elevation, and you can see the lion's share of water. What's on the screen, the SwiftMud design high water at 25 only stages up to 4.74, never goes up to the outfall point. Same with SwiftMud design high water of 100, never goes up to the red line. Everything in that little red line, that little sliver, is only what we discharge to FDOT. Everything else goes down into the sand. And that's in all the storm events we're talking about. Jumping over from stormwater erosion control, I think some folks hit on this before. The cut-throughs we talked about, we have no problem with the raised cut-throughs. We were trying to do something, obviously there's a significant number out there today. This is much different.
Yeah.
We're adding a tremendous amount of dune restoration, waterward of the 3CL line. But we have no problem to add, the cut-throughs and basically plant under them, et cetera, and work through that. The one comment I would make, and I don't know if this is a condition or not, is I know the fire chief mentioned, how do we get out access to the beach? In the center drive, and I have an exhibit that I could show real quick, but we have a turnaround in that 15-foot beach access. In order to get to the new restaurant, we actually have that as a fire truck road. They can pull right out to effectively the 3CL line. I think it's fine for now. So they can pull out to the 3CL line and basically stop and then back up and go back the other way. I think someone was asking, how does the fire truck do it? We already have a turnaround set up to do that. My only comment would be is, if we wanted to do the crossover over the dunes, happy to do it, but it also might be something we want to think about. I don't want to put a condition in and then the fire chief says, I need fire access to get out there, and then all of a sudden we've got this cross-up where we have a dune, basically crossover, and
We have crossovers that are made for the fire truck to
are
get
they the
over.
ones kind of like?
Yeah.
Yep, okay.
Yep.
Yep.
Yeah, we got one at, I think it's, 52nd or we did, yeah.
Yeah, we did.
Well, maybe we can have another.
I mean, dune crossovers are good because we're doing them all over the place. We had them in Paso Grill, and it just, in a big storm event, it doesn't breach the dune and go behind the dune and then wash out the dune.
And that's a huge concern, because you're doing all this work and then you get it washed out in one storm event.
Yeah.
So, again, happy to do that. We kind of modeled our cut-throughs by kind of angling them so you can't see from the beach back, and it's like a full dune, vista or view as you see it. Couple of important aspects of this, and I kind of hit on it a little bit later, but the dune restoration is also a huge resiliency component, right? The barrier island, before we all developed it, that's a lot of what it looked like.
Yep.
So we're restoring vegetation, we're restoring species habitat, we're raising the dune height. So as I kind of jump through it, and that's actually kind of what it looks like now. You can see it's pretty barren and sparse. We bring that significantly forward. But I want to show here, we raise these dunes pretty significantly, roughly 2 to 3 feet, depending on what they are and where they are along the beach. And then that's that crossover you're referring to that would kind of mound up with it. This all goes through the FDEP 3CL permit, as it's called, the Coastal Construction Control Line permit, which is, I think, what you all hit on about FWC and sea turtles. So when we submit for the FDEP 3CL permit, it's a requirement that FWC opines on, do we have amber lighting? Do we have the proper lighting? Do we have the proper tinting of windows? both existing and proposed. So all of those will be conditions of what we need to do as we go through this. And we're about to submit for this 3CL permit just to get out in advance of it and get any of their comments as well. But another important aspect is resiliency, not only from the dunes, but there's a resiliency, I think we talked about, there's reconstruction, there's also renovation, there's redevelopment, even if we leave the 226 units of the existing Serrata. When we basically knock down those 150 some odd units of hotel keys and we raise them and put them in a new building, they're no longer below the floodplain as they are today. They're now built in a building in a structure that's built to Florida Building Code today. Some of those, if you're 1980s, whenever those structures were built, depending on which one we're talking about, there's been significant upgrades in what we're talking about from a wind loading perspective or a Florida Building Code perspective. So there's a resiliency component to that as well that I think it's an important aspect to note.
And how many units are you leaving in the flood zone?
226 are left in the existing Serrata. How many are on the first floor? No, first floor.
Was there 365?
No.
382. No, how many are?
I have to get you exact number on the first floor. I don't know the answer to that.
Mr. Mayor, just it's hard for the clerk and it's hard for the court reporters to capture everything if people are talking simultaneously. Just letting you know. I know they're frustrated with that.
So the question, I believe, I don't know if it helps you all. Okay. So this is just another example blow up of the dune restoration, as you can see. And then we talked about this, but the new construction is resiliency. It's part of it, right? You get better flood control. We talked about the stormwater vaults. You talk about what you have in Gulf Boulevard with just the little cut-throughs, better flood resistance, hardened structures, and then resilience is really more than new construction. You get FEMA rule limits repairs, direct effect on recovery. So for instance, one of the examples we've been talking about with city staff is if we build the parking garage for the JW, the idea was that city staff wanted to park city vehicles in the JW. And the owner is more than happy to basically park those vehicles up on the second and third floors to get out of floodplain issues, and it gets the city back on its feet faster. Those are all parts of this that you have to think about as you're looking at it. It's not just, is it in the floodplain or not? Each piece kind of adds to the talking about driveway alignments. So this is what you have. The southern driveway basically is what we're going to model for the northern two driveways. But effectively, you have offset driveways with offset left turns. So effectively, those folks are basically making a left out. They're also looking back to their right, to basically join into traffic. And then they've got someone potentially doing the opposite, going the other direction. And I'm going to jump to the next slide. This was a request from FDOT. This is a pretty standard request from FDOT, which is to line up your driveways across from you. And so this allows you to not have to look back to your right and also basically look at the driveways to your across from you as well.
So are people only leaving these properties?
I'm sorry?
Are people only leaving these properties?
No, they must go in to come out.
So where are those arrows?
I think it was the point of the conflict coming out when they're going in there.
But if you draw the arrows, you now have conflicts again?
Oh, yeah, there's certainly conflicts.
Okay,
There's
so
never going to avoid conflicts. The point is to reduce conflicts.
Well, isn't the point of this, the left-hand turns the most difficult turns, turning right in?
That's correct.
Is not the issue.
No, it's the turning left in.
Yeah, but the turning left in is the movement that's going to move. They already have the right of way in there. They're sitting in the center lane at that point.
Sure.
So
But it's still a left turn,
in the center lane,
and then you're still crossing.
You've got someone sitting right in front of you.
Yeah. And then if somebody else is trying to come out the other way.
But you can see them. They're sitting right in front of you, not having to look right and try to go left. So it's a conflict point by No, I understand that, but he's talking about something else. So this is just a zoom in of the driveways that we're referring to. Again, DOT recommendation regarding conflicts and just reduction of them, aligning the driveways across from one another. Just another example of just kind of the existing driveways, obviously gated up. I know that we have a stacking question and queuing. I'm going to get to that in a second, but this is what you have here. Some of the driveways are gated, they're sort of broken, gated, they're not inviting. You know, the wayfinding isn't the best, so it makes it difficult to kind of find out where you are and where you're going on the property. Jump ahead. This kind of gets into, and I think someone had mentioned it, this is regarding the private beach access that's on our northern boundary. You can see now the red dashed line. I think that's being used as a public access. We didn't count it because it is private. It's actually owned by a homeowners association across the street from us. Right. We didn't want to count it. But as you can see, and I'll jump to, there's a picture here in a second that I can show you. The sidewalk along Gulf Boulevard is 5 feet wide. The ADA ramps aren't the best. It's narrow, it's relatively uninviting, and there's a big distance between beach access and crossings across Gulf Boulevard. So as we go forward, we make that, one, you look at all the beach access we have. We had the 7-foot beach access on the southern boundary, runs all the way out to the mean high tide, or the water line that we were referring to. You have the easement, public beach access easement along north-south, along just inside the water line. You've got the main 15-foot beach access in the center of the site, and you have a 10-foot sidewalk along Gulf Boulevard as you work through it. You also have an existing 10-foot crosswalk in red, and then we're adding, which is the DOT standard, roughly 300 feet north of that, the 10-foot crosswalk across Gulf Boulevard again, which then aligns to the beach access drive. Rather than people, and I heard it in the planning board meeting, people walking across Gulf Boulevard at random locations. A lot of that has to do is because they don't have a really good spot to do it. If you do them periodically, you know, every 300 feet, they're much more inclined to use it as they do it.
So that's a proposal you have to FDOT?
That's correct. FDOT, we've had 2 meetings with FDOT. The driveway alignments were one of the main things they talked about the first time. In the second one, they said they were getting further along in their studies and would like us to do this crosswalk. We're happy to do that. We think it's a good idea.
One of the problems we have with crosswalks and with Gulf Boulevard is they're on-demand crosswalks. So it really chokes up traffic because you could be driving, someone pushes, one person crosses, you go, and it doesn't, they're not, I don't know what the right technical term, remember Becca would know, they're not synced in time so that, you know, you push the button and the light turns on. So it really also negatively impacts the flow of traffic. And we've been talking, I think, with FDOT, how do you get that better synchronized? And when things are synchronized, then people will, you know, will increase safety and people will use crosswalks. But step by step. I mean, this is just one of the problems with
I agree, and I think if you do one, and I think if you go back to the short and midterm solutions that FDOT and the MPO and the city have provided to us that we have to look at in terms of along our frontage, there's 3 segments. I think it's the north, the central, and the south corridors, I think, within that study. I think when you look at them all holistically, you're going to get a lot of that benefit you get. If you look at one crosswalk and it's not synced north or south, you're right. It becomes kind of, you stop at one, you go to the next one, you stop again. It makes no sense to kind of.
Right, and the drivers get frustrated and maybe they don't pay enough attention and then we get into a safety problem. But
Understood.
More crosswalks are better. It'll improve the safety.
Better space crosswalks is kind of where. And this is kind of what we're talking about, which is, you know, I won't even get into the ADA compliance, but the slopes aren't working well, and you know, it's just not inviting. You know, if you've got 2 people with wagons pulling in opposite directions, it's going to be awful tough to pull past that. Plus, you know, little kids in hand, that's going to be difficult. The beach access that you see on the far right picture, that's actually the northern beach access that we were just referring to. That is private. I just want to point out that, again, that's really narrow. If public is using it, it's really difficult to use. That's why a 15-foot beach access, it's wide. Wagons can go in either direction with a group of people walking side by side. And this is that center beach access we're referring to. So it's 15 feet wide. You've got trees going out, much more inviting area to walk out. And that's kind of just a rendering of illustration of that beach access. Just real quick, I think we'll hit on these. Parking and loading. We made all the parking requirements. I think one of the questions at Planning Board was, did we need more parking or did they feel like we needed less? Owner actually responded that, no, this is about what we would need and pretty consistent with what they have at this type of hotel. So I think the city code is pretty much spot on what we would think and we would need. We satisfy all loading requirements. So we load we load two different ways. We load passenger vehicles, and I'll talk about those here in a second, but we also load service vehicles. The trucks enter and exit the JW Marriott from the Gulf Boulevard side, so they have their own standalone entrance. They back in, pull out, trash compactors. They're all faced away, again, from C-Mark, so it's something from a noise perspective and other things that we're addressing. We provide connectivity with all the various sidewalks throughout this site. So now, it's much easier to walk from Hotel 3 to Hotel 2 or Hotel 3 to 2 to 1. Plus, you have a various interconnectivity both from the Gulf Boulevard side and from the beach side as we work through it. All right, so health and safety, this is just referring back to the CUP requirements. We've incorporated a number of features into our design, sure that we're enhancing public health, safety, and welfare. While we're going, we provided the beach accesses like we talked about. We've already talked about those. We're providing the additional pedestrian safety features, the 10-foot sidewalks, internal queuing, and I'm going to get here that to in a second, and elimination of access conflicts. We significantly improved the stormwater functionality. We talked about that as well. Improving the resiliency of the property, which not only benefits the property, but the community at large. And we committed to the full dune restoration, which both enhances the beach experience, as well as providing nesting habitat for birds, sea turtles, et cetera, through that process. I'm going to jump over real quick to the queuing one, because I know you all had that question, I think.
I'm sorry. Ryan, can we have the doc cam, please? Thank you.
Sorry. Yeah, so as we're doing this, what we did was we took exactly what we got from the traffic study, which we've already talked about is conservative. And so we loaded all those vehicles, but then we said, okay, what happens if the valet breaks down? What if there's only one person there and it's taken them 10 minutes to pick up each car and do that, which is unusual, right? Typically a valet is going to be 4 minutes, 5 minutes, so half that time. But we said 10, let's figure it out. What you see on this right now is the amount of trips generated in the PM peak hour to each various use with a 10-minute valet wait time, and that's the stacking that you see.
Could you say the number of cars just in case I can't? If you didn't read it. Sorry.
I might need your readers.
Here you go. There you go.
9, 10, 11, 12,
9 there.
12, 9, and 4.
It's getting late, too. Can you read it?
It's been late. It's been late.
Yeah.
Late was a while ago.
12, 8.
9 and 4.
Well, I could count them. I should have just counted the red boxes. I'm sorry. So it's 12, 9, and 5.
This is available queuing.
Oh, I'm going to flip to the
You're
next
looking-
page.
oh.
So that's what's on there. The red boxes are the 12, the 9, and the 5. And then what we were talking about, without impacting anybody else, the green is the additional queuing you have available. And that's our point of, that's with a 10-minute valet. You're not going to see that, but that's the point of PM peak hour. You're definitely going to have more than one valet. It's not going to be a 10-minute valet in the PM peak hour, right? And that's kind of what we're trying to propose. Jumping, I'm sorry, can we flip back to? Yep, good. So real quick on utilities, and Mr. Clark did a great job kind of hitting on all these things. Sanitary sewer, I totally agree with the calculations he had. Those are the same calculations I had when I ran back through the numbers. I think there was a difference in just what the request was from us on fixture counts and water meter versus sanitary sewer. They're calculated differently. That's all it was, and I think that was a misunderstanding and part of that. We do have letters from potable water from Pinellas County. I believe we also have solid waste, and then sanitary sewer, as we discussed. In the planning board, if you watched it, I was referencing that you got lift station 20 and lift station 19. We would be more than happy to route the existing Serrata to the north. That's actually what we wanted to do. I don't believe the condition in the staff report hurts us, but I don't think we'll actually need it either. I think we'll just reroute the manholes on site, come into the north lift station, go north. There's adequate capacity to the north, there's adequate capacity to the south. Shouldn't be an issue as we go. Electric, gas, and telecom are all available. We have letters and submitted those to the record for all of the various utilities. And I think just talking about concurrency, we kind of hit on it a bunch. You know, one of the things, and I was just thinking about it going the opposite direction. If you had a whole bunch of developments that came in and no one actually pulled a permit and started to build, and you made them reserve a bunch of concurrency, you'd have ghost concurrency or ghost projects where you'd be gobbling up all this concurrency, you'd start building all this infrastructure you'd be required to do, and you wouldn't need it. And so there's another side to that, is the timing is critical to when you reserve that concurrency. I certainly think it's responsible for us to preliminarily tell you that there's water available, there's sewer available, stormwater's available, but to lock it in really is a timing thing at site development when you're actually to pull a permit, and that's kind of when you lock yourself in, if that makes sense. Stormwater, I think we hit on this. Current condition precedes our modern stormwater code. New development will comply with the most stringent regulations at DOT, SWIFMA, and the city. And as you all said, I mean, it's a significant improvement over what's there today, and we truly believe that.
So that letter on the previous slide on the potable water, so Pinellas County has signed off that they have the capacity and...
Correct. I mean, it's a 16-inch water main out there. I've heard things about the water pressure and other things. I mean, I do a lot of development downtown Tampa, right? I mean, I did a lot of the projects in Water Street, 12-inch water mains around all those blocks. You got a 16-inch water main here, and it's looped, and you got a tank not too far down the road. When we did our water flow report, we had adequate pressures for fire, potable water, all of it. So, yeah, I don't see that as an issue. And yes, they do, but they don't lock in concurrency, just like we discussed, but they give us a will serve letter, and yes, they have done that for both reclaimed and for potable.
I'm sorry, on the electric. So I'm sure you're aware we've got an undergrounding project. So I don't know, your mains will hook up, do they sync up are we undergrounded, or are you going to have to go to the poles and then come off the poles?
So we're working with your undergrounding team right now, and the way it's going to sit is there's a series, and I don't have a slide for it. I apologize. Actually, might. Is that on the utility plan? No. But basically, all the infrastructure is on our side. It's on the west side of Gulf Boulevard in our area. There's a couple pole boxes on the north side of the road, and there's a large switchgear at the very southeastern corner of our property. And there'll be some crossover, but at some point, there's nothing above ground when they're done, and they've kind of created underground conduits kind of stubbed out that will pick up and run to the new transformer locations and planning purposes. So it's there, it'll all be undergrounded all the way into the site as well as along that whole side of Gulf Boulevard.
Okay, good.
Open space in ISR, site landscaping, open space provisions, impervious surface limitations. We meet all the open space requirements. We meet the ISR requirements. And I think, again, open space in ISR, I'd be remiss if I didn't say the full dune restoration. I mean, I think that's a huge impact. Probably kind of gets glossed over a little bit, but it's a big deal. I'm sure you all would appreciate if more people did it down the beach as you went. Kind of hit on this lighting and noise. I think someone mentioned it from a lighting perspective. Really, when you're dealing with coastal pieces and you got the 3CL line in play, your lighting is really driven a lot by FWC and the sea turtle process that you have to go through. That'll all be part of our FDEP 3CL permit. Will be required to meet those lighting requirements, as well as the shading and the tinting of the windows, et cetera, like we talked about. We also talk about site design, restrictive conditions regarding noise. The loading areas are screened. They're within the parking garage. The parking garage on the north is screened along the whole northern face. None of the lights look out onto Seamark. A lot of those pieces are in play. The truck loading area is facing Gulf Boulevard. We've already talked about the conditions from 7 a.m. till 10 p.m. To work through that. And let's see. Bear with me. Fire suppression, facility security, emergency management, hurricane evacuation provisions. I think you all had a discussion earlier about this. I think it's at hurricane warning, if I'm not mistaken, from an evacuation perspective. You've got fire suppression. We did the water flow report. We've been working with Kelly and her team regarding fire flow. We've designed basically a system tying into your existing system, put it to each individual hydrant, flow it at each hydrant, in a proposed scenario, and then to all 3 or 4 hydrants all at once. We're still adequate in all capacities as we do that. We've obviously built modern buildings to fire hurricane codes. I think LEED even leads into that. You've got probably more energy, not just windows being more energy efficient, they're also probably more hurricane resistant and more resilient in general, when you deal with things like that. We've got on-site security and management staff. I talked to the owner a little bit about this. It's really kind of on an as-needed basis. Some places need more, some places need less, and it's usually a time of day that kind of varies on that, but all of that is accounted for. Again, we talked about city emergency service vehicles, getting up, being able to stage within the garage, and just something that I think is an important aspect as we kind of work through that, and more than happy to provide to the city. And so, in my professional expert opinion, as conditioned, the proposal is consistent with the applicable provisions of the comprehensive plan and land development code, section 4.4A4, parking and loading, section 4.4A5, health and safety, 4.12A1, utilities, 4.12A3, stormwater, 4.12A5, open space and ISR, 4.12A6, lighting and noise, and 4.12A7 and 8, emergency management. I think you're ready.
So just very quickly, there's one last criteria that's a factual-driven criteria. You guys look really tired, so are we. That is hours of operation, provision of, I'm sorry, Elise Batzel for the record, I apologize. Hours of operation, provisions of required services or amenities, residency limitations, and facility maintenance. Really quickly, We obviously comply with the operational requirements under the code. That includes the uses that have to be available on site. We talked a little bit about that. The only thing that wasn't mentioned was the business center. We mentioned this in TRC. They will have business centers, but you're not going to see big rooms anymore of business centers. There's going to be a computer and an area, but we don't create these big business centers anymore because everybody's on, their laptops and their iPads. But there will be a business center to meet the requirement of the code. Pools will close no later than 11. We're happy to condition the approval on that. That's the way that they run their operation anyway, so we wanted to offer that because that's how the business is going to be operated. That helps with all of the impacts as well to close those earlier rather than later. We also must operate as a transient lodging facility. That's in this requirement. And just so you understand, because of the limitations with how many nights people can stay, Serata has software that actually alerts the staff when you're approaching the number of days to be sure that they don't inadvertently rent rooms longer than is required under the code. There were 3 additional things that I wanted to cover. And we've already talked about all the transportation improvements, stormwater, public access, but there are some community benefits that are in your conditions that staff and the city manager asked us to agree to and added as conditions since the planning board, and I think it's important that we at least list them. I'll go with number 8 because we've already talked about everything else, with the exception of job creation. At the completion of this project, the applicant believes that over 400 jobs will be created. The bonus beach access, we have added a condition that basically says whether or not that select service hotel ever gets built, we still have to provide that beach access with an additional time. So even if the luxury hotel to the north gets developed and a crazy recession happens and everything shuts down, we're still obligated under the CUP to go ahead and provide that beach access after a certain period of time, and that's listed in one of the conditions. We have also committed to that $500,000, $100,000 for 5 years for the freebie or other mobility services that may replace the freebie if the freebie is no longer in existence. Based on the Gulf Boulevard safety study, we have agreed to pay our proportionate share of that study so that you can go out and see what other safety measures may be needed. And we have agreed up to $30,000 for an emergency services study. So that's all over and above what staff had recommended at the planning board that we've agreed to between planning board and this hearing tonight.
Could you go back to one slide just so we can refresh 1 to 4?
Yes.
Got it.
Yes.
Thanks.
Transportation, all the queuing. I think we talked a lot about that. That's really just a reiteration of community benefits. With that, we are going to close our presentation, and we would ask for time for rebuttal after the community makes its comments, please. Your Honor.
Thank you.
Thank you.
So we have a so we have it right now, the meeting scheduled till 12. The question is, do we want to adjourn? Do we want to continue? Do we want to?
I would make a motion that we extend it till 2 a.m. I think there's a lot of... Excuse me.
Please let him speak.
This is right on the heels of the applicant's presentation, where I think a lot of the issues are fresh in people's minds. And I think this is probably the time to strike. It's probably the most effective time because they've just gotten done with the presentation, and then we can draw the comments and connect them to the issues that were raised by the commission and raised by the applicants.
I'm inclined to disagree. It's excuse me, please, wait.
Just can't.
No,
they can't.
please. we got to get this done in the next 4 minutes, so we got to have this discussion, so please. I think there was a lot of things that were brought up by Commissioner Frizlowski, additional things that we wanted to see from the applicant that we currently don't have. In the absence of those things, I don't necessarily think we want to say no. I think we would rather see those things and then make a decision based on that. I also do recognize that there are people making public comments that have come from out of town who may not be able to come at a later time. We have 2 hours worth of public comments scheduled, so even if we allow 2 a.m., we still wouldn't get through everything. So I think my proposal would be maybe we extend to 12:30, 1 o'clock, allow anyone from the public that is from out of town, give them priority, let them speak, and then we adjourn to a later date.
Well, I'm not sure we've got 2 hours of public comment. We have to go through. There are a number of people who have asked for extended time, and multiple people within one same organization that I don't think would be afforded more than 3 minutes. I mean, one organization, the intent of our resolution was not to give one organization 1 hour to speak because 12 people came from one organization. That doesn't give them an hour to speak. One organization, if they want to give their time to one person, that's fine. So I'm not sure, and the city clerk, and I know we've only got 3 minutes, but the city clerk had sent this out, and we've not actually gone through it, those who've requested 10 minutes. We've got others who have created organizations that I don't know where they, just because I haven't heard of them doesn't mean they don't exist, but I've never heard of some of these organizations before that are requesting 10 minutes. So I'm inclined, I do think we need to continue while it's fresh in everybody's mind. We did start this in the afternoon. There was a discussion, we'll remember, that to start this at 9 a.m., but the request was do it later in the day because people work and we want the public to be able to come. It has taken us a long time. There's a lot of material here. I think we've taken the right amount of time to work through and have the right proper discussions. I mean, there's no easy answer here.
My concern, both of you guys, my concern was almost from a procedural aspect, do we want to have the evidence closed regardless of, we can decide, do we want the record closed? Or do we want to leave the record open? Or do we want to finish, close the record, and then come back and then discuss what our position is after the record is complete?
We can't close a record, correct me if I'm wrong, until the public has spoken.
Well, that's what I'm saying.
Rebuttals,
right.
Whatever else, so that, I think we need to be able to make decisions with a clear mind, and I'm not sure that after 8 hours at 1 a.m.
I'd be glad to do it with a clear mind. I just know that we got a room full of people that have been waiting for a really, really, really long time. And I know there's a lot of people that have things on their mind and they'd like to get them off their mind. And I don't want to cheat anybody.
When would you reschedule?
The next commission meeting is on the 12th.
Okay, we can't have members of the public talking, so stop that, please. December 12th has a pretty full agenda, okay? So we really need to get through the business of that agenda, and I'm going to tell you right now, my professional opinion, it will go till 10, just on that business alone. Is that correct, Wayne? Would you agree with me?
Yes, if you do want to continue, I would appreciate it if we could get our staff together for 5 minutes to look at what dates might be available, because we do have a lot of things that are already scheduled for future meetings.
Make a motion to at least 12:30.
Just the one other thing I'd like to mention too is, don't forget, we do have one other, we have the city's transportation consultant here that you wanted to wait until after they'd presented their transportation consultant. At a minimum, I think we need to get him up here at this point rather than waiting.
Well, so since we're at 11:59 and we need to have at least 5 more minutes of discussion, I'll make a motion to extend the meeting till 2 a.m. and
I'm exhausted, literally.
Please, let the commissioner finish speaking.
To 2 AM so we can continue. That way, we don't have to have a motion every 10 minutes, and then we can decide what, we can take a break, and then come back and decide what to do. So that's the motion on the table. Sorry, do you second?
I second it.
I'm not inclined.
Well, let me take a roll call.
Hmm?
I'll take a roll call first.
Can we have,
We have a motion and a
we're
second
at
on
a
the
time
floor.
of discussion.
I object. I do think that a meeting that late is prejudicial.
Commissioner Frislowski,
Yes.
Commissioner Marone,
Yes.
Commissioner Grouse,
Yes.
Vice Mayor Grill,
Yes.
Mayor Petrilla.
No.
Motion carries 4-1.
Should we take 10 minutes and let staff get together? And
All right, we'll take a,
5 minutes.
Wayne, 5 minutes, 10 minutes?
10 minutes will be fine.
hard start at 12:10. We are in recess. City Manager, you have a date for us?
Well, we have a proposed date, yes, sir. There's a few things that were discussed tonight that the applicant is explaining is going to take a little bit of time for them to pull together, especially the architectural issues that were brought up. We also think that we have a lot of things already scheduled for future meetings, or regular meetings, so we believe that this should be a special meeting, as we're having tonight, and probably start it earlier in the day. We had people showing up here today at 2:30, so I don't think the issue with waiting till people get off work was really an issue today. We're proposing that there would be a special meeting scheduled for Wednesday, January the 10th, 2 p.m.
I don't have any conflicts.
So it's not clear to me what we're doing by delaying this. If we had started this meeting at 9 o'clock in the morning, we would continue to go and we would come to a vote. Now, are we giving the applicant more time to go cure items that they think they haven't met by giving them another, a month and change?
Well,
is that part of?
I think the main thing is the main thing that is going to take them some time, and you correct me if I'm wrong, are the architectural questions that came up on coming up with the design that's going to be acceptable. I don't think that can be done in a matter of 3 or 4 days. So that's why they are requesting, one of the main reasons requesting additional time, but their representatives can address that. But in any event, we need to be a special meeting, and that's the one we came up with.
So Commissioner Grouse, you're out that week, right?
What was the date?
The 10th?
January 10?
January, no, I will be here.
You will be here, okay, all right.
Here.
Okay.
I don't think I can start till 4.
I think we all, January 10th, we all have a meeting with a developer on another CUP with the Stearns Weaver, but that, I guess, can be rescheduled. But so we're looking at a continuance? I'm looking from a process standpoint.
Okay, so technically, you guys can continue on and move forward with this. You have other options. We just wanted to meet and convene so that if you were to continue it to another date, we needed to talk internally about what date would work for the city, because there's other city business, there's other applications that are coming in. If you were to continue and you wanted new information or new renderings or new studies, they need time to prepare them and staff needs time to review them. So that's all we're doing, but we're not telling you can't go forward.
So that was Wednesday, January 10th?
That's what.
And what time?
We were proposing 2 o'clock, 2 p.m., but that's up to y'all.
I just can't start till 4.
We could do it later. We were just thinking it's taking so long today, that.
It's at 9 a.m.
Earlier, at 9 a.m. is fine if that's what you want. That's the date.
Okay. I have to work.
Sorry, no one's using the mics.
I have to work that day. I can do it at 4.
4?
4 o'clock.
Okay.
We'll be back where we are now at midnight.
Yeah.
And then we'll hear people accusing.
We'll finish.
Just have a day job.
Well, look, if we can get through some of the audience comments tonight, and then we come back, maybe what we can do is have any of the longer audience comments for people out of town, give the applicant an opportunity for rebuttal. Would that be, since they may not be here again?
You can take the public comment out of order, organize it any way you want. As I said at the beginning, you just have to decide how much time do you want to allocate, because I think you're referring to the folks that had requested additional time over 3 minutes. So
well, there's a representative from one of the condominiums here.
Mm-hmm.
We have other representatives here who are we're not going to be available in the future.
Mm-hmm.
And so I would like to at least give them the opportunity.
Okay. And then I think you also have to decide about your own city transportation expert. Do you want to hear, I just making sure that you had, you know.
Will it be all right if we take him out of order back on the January 10th, or?
Well, let me ask you, if we allow public comment tonight, then those people are not allowed to speak at the
Again.
next meeting?
Correct.
Okay. Do we have any idea how long our transportation consultant needs? We only said he needs 5 minutes.
Okay.
I mean, so I think,
I'm okay, that's fine.
yeah, I'm in favor of hearing him and then prioritizing people that are out of town that can't make it. And I guess we got to make some decisions in terms of the time frame allowed. And then I think we continue it till January 10th at 4 p.m.
And then giving the applicant an opportunity for rebuttal for those people who will not be here again in the future.
Yeah, I think that's a good point. Yeah, I think that's probably necessary, that they'll have to be able to do a rebuttal tonight and then a rebuttal at the next meeting. Because I think the rebuttal probably ought to be in.
I'm sorry, Commissioner, again,
I'm sorry.
it's not you.
Oh, okay.
I cannot hear because of decorum. Please, Commissioners Merritt, remind them of decorum.
You are so reminded.
Thank you, I appreciate
Please.
it.
It's not that funny.
Anyway, Mayor, I think you make a good point that the applicant ought to be afforded a rebuttal after the public tonight, and then again after the next meeting. Kind of makes sense to do it while it's fresh.
Okay. Is everyone in agreement? Okay.
Yes.
Great. Mr. Planner, or traffic, or if you'll please state your name for the record.
My name is Jerry Traverso. For the record, I've been sworn. Can you guys see me right? Because
Yep.
this
Yes.
podium is
Yep.
all for me. Like I said, my name is Jerry Traverso. I'm Vice President of Transportation Engineer with George F. Young. It's a company here in St. Petersburg.
Any relation to the applicant?
I'm sorry?
Any relation to the applicant?
I know some of them. It's a close-knit business here in the Tampa Bay area, but I have no relationship.
Different spelling.
Oh, the applicant? No.
Different spelling.
I have over 28 years of experience. You don't have my resume, but I'm going to give you a little bit of my background. Over 28 years of experience as a civil engineer. The last 24 of those have been strictly related in the transportation traffic engineering. I was the city engineer for Northport, Florida, just south of here. Before that, I was a traffic engineer for Manatee County. And before that, I worked with Illinois DOT, Tennessee DOT, and several other engineering firms in the area here and in other states. I'm also a professional licensed engineer in Florida, as well as 14 other states. My responsibility was to review the traffic report prepared by Kimley Horn and review starting at the methodology. And as they explained, the methodology is like a recipe of what the traffic study is going to have. So my responsibility is to check that it follows current industry standards, and what they're proposing to analyze is in line with what what information they're going to use is available with DOT, the Institute of Traffic Engineer, and everything follows acceptable processes in the traffic realm of engineering. So we review that, and as they mentioned, at the request of the city, we met with them and we asked them for a Saturday traffic count and analysis, which, like they said, is not typical for most developments. They agreed to do it. Usually is the PM peak hour, and we know that the industry says it's between 4 and 6, and you analyze that portion because it's the worst traffic usually in any given road. So we analyzed that, again, to see that it met all the industry standard requirements, and that they included, it was very critical that they included the vested traffic, because that's one thing that I have reviewed other traffic studies, and that's one thing that people kind of forget. They include their traffic of their project and the current traffic counts, and they extrapolate, but they usually forget that. So we will check with all that, and our conclusion was that it follows and it meets current standards included in the ITE manual and as with DOT. So that was the base of our review of the report, that it followed industry standards and it met, what is stipulated in their methodology meeting and in the ITE manual. In a nutshell. If you have any questions about our work with that?
Thank you, sir.
Thank you.
Thank you.
All right, there was a question as to who gets how many minutes, Commissioner Groh. I think that was you who brought it up. We just spent 4 hours, 5 hours on the applicant's presentation, 5.5 hours. I'm inclined, they're asking for 20 minutes, 20 minutes, 2 20 minutes, and a couple 10 minutes.
There, at least the list I have, does not designates a name and a time, but no organization that they're.
Well, the first one is an attorney.
Right, but the attorney is a lobbyist for an organization.
Mhm.
So our resolution said that if you're a member of an organization, 4 people can give their time to one person to speak for 10 minutes on behalf of that organization. So how did we get, we've got.
Well, these are the requests.
Yes.
Right? And we can, if we want to allow 20 minutes, we can allow 20 minutes. I'm simply saying we've given the applicant 5.5 hours. I don't think it's unreasonable to give 2 people 20 minutes.
No, but please don't make an innuendo that someone's trying to cut off the public. We're trying to be consistent in how we, as we had a point brought up several hours ago, that we consistently apply the policy and our procedures.
And when we asked the applicant how much time they needed, they said, well, about the same as the planning board, which was 1.5 hours, and here we are 5 hours later.
Well, I think.
We're doing quite the opposite, right? We're actually trying to make sure we give the public all the opportunity, which is why we've had this conversation now. So I know we're seeing eye to eye on this, and I'm simply saying, in this situation, because of the scope of this project, because how important it is, because this has never come before the commission, I guess the question is it unreasonable to give 2 people 20 minutes?
On behalf of, so when are we consistent? So we have other people asking for 10 minutes apiece. We also have where we don't know who they represent, and how are we going to be consistent in what we are applying?
The only thing I'm asking is who are they representing? Because we have a list here with names.
I believe the first 2 are from Protect St. Pete Beach.
Yes, so I can confirm that Ms. Jane Graham is an attorney, and she gave us notice yesterday, I believe, that she was representing Protect St. Pete Beach Advocacy Group, and they do have a planner who's from out of town. He lives in Tallahassee. You've seen his letter before, but he's here to testify. So I know those 2 folks.
Okay, that's the second.
And that's the same organization, but it's an attorney who obviously will give legal arguments, but not.
See, what I don't understand is, I thought this was public comment.
Yes.
So why are we taking expert testimony from a non-party?
That's what I mentioned at the beginning of this hearing, is that, real quick, there are 2 parties, principal parties to this hearing. One is the applicant, the other is the city. Then this city of St. Pete Beach, does not have any criteria for designating anyone as an interested party, a substantially affected party, or anything. But what we normally have done in the past is that if someone, as a professional courtesy, if someone has notified us ahead of time and hired an attorney and a planner or somebody like that, that we afford them at least, you know, and I had sent an email to the commission that a while ago that they had a planner. I'm not saying designate or establish them as an interested party or substantially affected party. I'm just saying afford them time to make their case so that you're not
So what I'm inclined
you're not setting up the city for any kind of
what I'm inclined to do is, if the representative from Protect St. Pete is the attorney and wants to make a presentation and submit some type of report from our expert and submit it to the city as some type of, impeachment of the information that's already been provided, and then that expert wants to get up and speak for 3 minutes, then, well,
Excuse me.
we're not taking.
Please.
But I don't understand how, not being a real party in interest, we're taking expert testimony. And I'm just saying this, not that I don't want to hear it, I'm just saying that, are we going to go down that route where people are going to call themselves experts, and he may be an expert, but he may be an expert that has no standing in this forum to offer expert testimony. So from a procedural standpoint, what direction are we going to be going if we open that door?
I agree. So there's, like I said, some cities have procedures for establishing who is affected and who isn't, who's more affected than the general public. I'm not recommending at all establishing someone's interest other than the two parties, but I also understand and want to tell you that under quasi-judicial rules, you know, one of the main tenets is fundamental fairness. And if you all feel as though the organization that's presenting has an attorney here and has a planner that wants to put something on the record, and that denying them the ability to make at least some kind of a statement on the record for their client may somehow put the case in some kind of jeopardy. So I'm just suggesting fundamental fairness in this regard. I mean, if they're, yeah.
And
Your Honor, point of order.
May we finish this conversation, please? Yes, Commissioner. I thought you were going to say something.
Oh, okay, I didn't know if you were referring to him. I tend to agree. I think I'd rather err on the side of hearing people. And so I think we need to just get this thing going. I mean, we just burned through another half hour here. So, I mean, all due respect to everybody. I think we ought to just get it going. Unless somebody disagrees, I think maybe we just say the times that they've asked for and keep rolling here.
Sounds good.
Yep.
Your Honor, point of order.
Yes.
Florida law dictates that in the context of quasi-judicial hearings, a party is somebody who has a direct interest. As Andrew said, that's the city and the applicant. Those procedural due process issues apply in a different way to the applicant than they do to members of the public. Members of the public under Florida law are welcome to come and they're welcome to present information, but they don't have those extra rights as a party. So I would just be cautious, if I were you, just placing my objection on the record. We have no issue with short amounts of time or a little extended time for the expert, but granting extended period of times for one person or one group over another tends to indicate that you're providing them a separate status. And so I just wanted to note that objection on the record. Thank you.
Okay. City Clerk. Ms. Graham, you're a little premature. Sorry.
I was just going to
Can I call your name on the record, please, as the city clerk?
We need to establish order real quick.
Yeah, thank
the
you.
sequence. There was one other gentleman from the C-Mark, I believe.
Yes, that was Mr. Ken Barnes, I believe. Someone came up to me and said that
Was it Ed?
Ken Barnes is representing C-Mark.
Yes, that's correct.
I'm a resident. With all due respect, may I request that I actually speak at the next meeting? I'd really like to.
Okay, thank you. Then I think it was
Mr. Stapler.
Ken, right?
Ed.
Sorry, Ed, sorry.
I was going to say that we would like to speak at the next meeting.
You personally, or you and?
Me and Mr. Gauthier, the expert for fixing.
Okay.
We find it prejudicial at this time of the hour to
She needs to come up.
Yeah, so. Great. So if they don't want to speak now, should we take Mr. Stapler and?
Let's do it. I'm like the president.
Please state your name
how
and
many- how
address
long-
for the record,
how long-
and which,
How long are we giving him?
well, which group is they're representing?
My people are here.
Just one
Which
second.
group are you representing?
Hi.
One second before he speaks, I need you to audibly say, "I am now opening the public hearing," please.
I am now opening the public hearing.
Thank you. All right, Mr. Stapor, you may proceed.
Good evening. My name's Ed Stapor, 605 55th Avenue here in St. Pete Beach. And
Sorry, who are you speaking on behalf of?
well, I'm speaking on behalf of Brightwater Beach Estates, and as well as I have some members of our team here who live with me or live in my community who have yielded their time to me for 10
Your
minutes.
name one more time?
I'm sorry?
Your name one more time?
Ed Stapor, Stapor.
Got it.
Am I good to go?
Yes, sir. Thank you.
Awesome. Thank you. First, I think very important for everyone to understand, can you see my screen? Yeah, I just want to first and foremost say that we do think that our community does need development in our hospitality industry. There's no doubt. And we've heard today a lot of reasons, and I'm not going to go over them. You've all seen them, and I think we all agree with them. But the question then is, when I kind of look at this, and at Brightwater Beach Estates, I did a little survey, one question. Last Friday, I sent it out to our team, to the people. We have 102 homes in our neighborhood at Brightwater. I asked them a very simple question. Do you want me to represent your views, yes or no, to deny this CUP? 94% said yes. So 64 people of 132 that I sent it to said overwhelmingly, yes, deny. So I sit back and I go, why? Now, they did their homework, I did my homework. I did not share with them what my position was other than I am not for it, despite I agree that it's a good thing to do for our St. Pete Beach. Last at the planning board meeting, this was discussed, and we agree. You know what, the process, there's a legal precedent, we have to do blah, blah, blah. Yeah, we got it, we get it. But why do I bring this up? Is because this statement that was said last planning board meeting, the community does not like the way the comprehensive plan regulations are written today. They do not want up to 75 units permitted if you meet their criteria. They want a different plan in place of their community. Now, I will say that is wrong. All right, the timestamp is there from when this was done from last planning meeting, because I was in New York and I wasn't able to attend live, but I watched the video numerous times. But what we're actually talking about here is this. Oops, let me go back one. Is if you meet the criteria. Now, what we heard here today is everyone saying, we've met the criteria. Check, 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 check. Thank you very much. I don't necessarily agree with that, and that's my position as a resident, not a professional expert, apparently. And I say that because, from my perspective, this is under the LDC that I'm kind of talking about, and I'll give you an example. Why we think it's very important for all of us. So I'm going to talk about traffic study. One of the things I've learned in my business is never talk to an audience who knows more about a subject matter than you do. So I'm going to be talking about traffic that I'm not an expert in. I'm going to give you perspective, though, that has common sense. Because what I've heard today, which was the same thing what was at the planning board meeting, was a lot of jargon that's very impressive. But what we didn't hear are the details behind it. The devil's in the details. Now, I think the professionals will agree that anytime you do a study like this, basically we're predicting a future, however realistic it is. That's what we're doing, and saying, what's that future going to look like? Now, for my business, and I could go on for a long time about what my expertise is, but my 10 minutes would be up. It's a joke there, folks. Where's the humor here? Come on. It's late, I know, but this is going to, are you listening?
They're supposed to be quiet. They're actually being quiet for once.
Okay, I want that time back. That's 4 seconds. Now, listen. They talk about overly conservative methodology. Now, I'm not going to talk about methodology. That's not my stick. But what they gave us these assumptions that they're very clear upon. But I think they will also agree the strength of the output is directly correlated to the inputs, which are the assumptions, and the methodology. Now, I'm not going to talk about the methodology because, again, that's not my shtick, but I will talk about the inputs, which I have some misgivings about based on my experience doing stuff like this for a long, long time. One thing we didn't see is any of their data. It's in the report. Now, what does this data tell us? What's surprising for 212 pages of a traffic impact study, very little data other than that one chart that they showed us towards the end. What does this data tell us? That which I believe, and I'll tell you in a moment, that their data are doubling the amount of traffic from current to where they are going to go in the future with their future projections. Doubling. Did you hear those words? No. Why? Well, let's look at this. And I do think that some of their assumptions are questionable. All right? Because this is just basic logic to me. When I look at data and I'm saying data should tell me something, there's formulas, and I should be able to understand where it's taken me. So when I look at the data, I first of all look at their assumptions. And they give us 2 key assumptions in terms of, and this was discussed at the planning board meeting, in terms of for existing, you're using Panola County, why don't you adjust it to St. Pete Beach, da-da-da, got it. But more importantly, for the future background, and actually it was a good lesson today, I've learned a few things that helped me prepare better on the fly. So for the non-project growth traffic, it was calculated using Gulf South, Gulf North, and Gulf winds. Gulf winds, really? Are you kidding me? Simple average versus weighted average. What did they use? Simple average. Why? It makes the numbers better. Also, nobody here believes the traffic has decreased. Anyone who's been here, I've been here since 2017, no one believes the data that it went down 2.34%. But how did they get that number? Where did they get it from? Well, this is their data. Look in Appendix C. This is their data that they put in from FDOT from 2006 to 2021. Now, what's highlighted here, what's shaded, that's the data they said, the last 5 years. And you can see the graph kind of decline, and that's where that minus 2.34 comes from. Now I look at that from 2006 to today, and you ask anyone, and I'm coming to here as a resident who lives here, who drives here every day, there's no way the traffic has decreased. You ask anyone behind me, you ask anyone, you all live here, there's no way that is true. But that's data. Where's the common sense? So what I did, I looked at this and I say, okay, first of all, it's not declining, number one. Number two, Gulf winds, why are you even using it? Why aren't you using all 6 road segments that you have told us that you studied? That would be more accurate. We've all been on Pasadena Avenue now with the 2 lanes, or the 4 lanes, right? And we know how backed up that is. We've all been on Pinellas Bayway coming into Gulf Boulevard being backed up all the way up to the bridge. We've all been turning left to go up onto Pinellas Bayway, and what do we see how backed up we are right now? And that's current. That's current. Hello? Where's the common sense? Weighted average, simple average. They included Gulf winds in this analysis, and their numbers, I just did 21. You could do the math for all the other years. But when you look at the weighted average, which is more appropriate, in my view, my humble opinion, look at it, that change in numbers. Now redo that traffic study with those numbers. I dare you. Let's see where it comes up. That doubling that I just shared with you, that was their data, not my data, will be more than double. Now, trade winds, okay, we don't have the concurrence. But guess what? Common sense. We know it exists. We have it April 2022. It's a joke to use Miramar and Quarry Landings. Did you look at that data, the tables? It's a joke. At least trade winds, I get it. You don't have a concurrence, you get it, got it. But guess what? Using common sense, one says, we know what's happening. Let's look at this report and let's see how it combines with what we have. What do we find? This is their data, not my data. I'm just doing the numbers and adding them up. Tradewind says they're going to have 300 more people in the AM, 384 in the PM, adding it into Serrata numbers, which are understated. You're going to have increases of 120%, 104% in morning and afternoon. Come on. Now, I will tell you, we get it. Both projects are independent of each other, but their traffic impact are compounded. They need to be looked at together. And I made that statement with a video or during the audio last week or last at the planning meeting because I wasn't here physically, and I said that. It is irresponsible to accept one study and then trademarks going to come in. Well, here's our data. Look, traffic's going to be great. See all these green bars. Where's the common sense to this? I'm going to go quickly because I only have a minute, or less than a minute. By the way, we all know that the Florida statutes allows us to be heard. And one of the reasons why residents are so frustrated is because we haven't been heard. We've put in, and as you all said at the beginning, we sent you a ton of information, and you all read it, which is great, but have you acted on it? People are smart. They got opinions, they're smart. And one of the things that we heard tonight, I'm a professional, I have all this expertise, I'm right. And they're actually discounting everything we say by making those type of statements, which is insulting to us. My last point is this, if I allow me to indulge me for 30 seconds.
10 seconds, Ed.
All right, Mike Tyson, what did he say? We saw from the Serrata team, they have the best plan in the world, panacea, utopia, blah, 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 blah. But guess what? Mike Tyson said everyone has a great plan until someone punches you in the face. You guys have to be that punch to deliver a message that their work is not sufficient. And you saw it today with the 5.5 hours, you got a ton of questions.
Thank you,
So
sir.
you must deny, or we're not going to be punching bags anymore. We're tired.
Thank you, sir.
You got it. Thank you.
Would it be agreeable if we ask anyone else if they cannot be here on January 10th to hear them, and then we can adjourn? Would that be
Good. I'm good with that.
Yes.
okay? If you're not going to be here on January 10th, if you cannot be here, if you'll please just line up on that side by the city clerk, and she'll call you one at a time.
Do we give the applicant the right of rebuttal at the
Let's
end, or
let
one by
everybody
one?
finish,
Okay.
just like last time. And
Okay.
is there anybody else who would like to speak tonight who cannot be here on January 10th?
I think in the back.
Can you please make your way over here by my black stripe thing by my desk so I can see who you are, please? If I don't see anyone, then that tells me that you all are coming on January 10th. It's you, I guess.
Please hand the city clerk your card. Please hand the city clerk your card. Please hand the city clerk your card. If you'll please state your name and address for the record.
You have a very angry member.
Please state your name and address for the
My
record.
name is Linda Llewellyn, 2802 Pasadena Way.
Thank you, Dr. Linda.
I'm not an expert, but when you have chest pain and want to know where your cardiologist is, here she is, begging City Council to do the job that you've been elected to. It was an honorable job, but I don't know what's happened. We should not even have to be dealing with these people. We have been here 7 hours. 7 hours. This is just unconscionable on your part, because you have created this, totally. The first thing I'd like to know is, why are we even here? Occupancy in this city is only 70%. Hotel rooms are only filled at 70%. Normal occupancy is 70 to 95%. Why are we even allowing these people to come and waste our time and our good money? There is no reason for it. Clearwater Beach, Mr. Young, you're only too proud to tell us.
Ma'am, if you'll please address the commission.
Clearwater Beach. There's not a person in this room
Dr. Linda,
who thinks that Clearwater Beach is a reasonable thing. Everybody hates Clearwater Beach, quite frankly. It's reality. That is reality. Nobody in this room likes Clearwater Beach, and we don't want to be like Clearwater Beach, and you're forcing us to do it and listen to all of this tonight because you think you're going to create Clearwater Beach here. No, we're going to make sure that that doesn't happen. I've lived through several rounds of red tide in this town. It was horrible. We had nobody on the beaches, nobody in the restaurants, and nobody in the hotels. Guess what? But that was a reversible thing. Now you've come through and you've made this huge big plan, and you've used the comprehensive plan to lay out all of the projects that you're going to do. The comprehensive plan, as best as I can tell, because nobody seems to know, at the planning committee, somebody had the audacity to tell us that they didn't have anything in the comprehensive plan. They hadn't seen it. That was created before the entire towns were flooded, burned down, the climate change, all of the architecture, all of the engineering that they have proposed to us is worthless. Now we are in a new phase. We have climate change, and we have no idea where we're going with that. So these buildings, they're going to tear down the Sea Market. That's going to come down. They don't know it yet, but we're going to have a Surfside right here, and that's not going to be funny. My last comment and question is, the planning board has cited Brandon Berry multiple times as an expert. I would like to see all of his qualifications. I have never once been able to find them, and he is not an expert in anything. He's a level 2 planner.
thank you, ma'am.
Yeah, go ahead, Ted.
Please state your name.
Hi, Ted Teal, 2871 Alton Drive. Thanks to all of you. You are the protectors of the city on behalf of the voters who elected you. I'm very disappointed that the city has completely left out the fact that all the emails and voicemails and people here and petitions are overwhelmingly against this. To me, that's relevant. And in your capacity as protectors, I urge you to delay or not approve the CUP until the city and the hotel address 5 material omissions. 1, where is the multi-year financial analysis of the effect of this project on resident city taxes? Is that not relevant to your decision? We should see spreadsheets with all the assumptions documented so we can evaluate them. There is too much financial hand-waving by the city and by the developer. 2, where is the analysis of this project's effect on the number of city employees, including law enforcement and fire EMS personnel? Who bears the added cost to pay and support those employees? 3, the comprehensive plan emphasizes the preservation of the character of the city. It's all over there. Where is the presentation on how this project would maintain or enhance the character of the city? Obviously, the residents are concerned about that. 4, the comprehensive plan emphasizes that St. Pete Beach should be a green city. Where is the presentation showing how this massive project will be consistent with the enormous green objectives in the plan? 5, many residents are concerned about pedestrians dying on Gulf Boulevard. Where is the analysis of the potential increase in pedestrian accidents and deaths on Gulf Boulevard as a result of the increased traffic that we know there will be? All of these omissions are material, especially for a project of this size. There are too many questions, and delaying the answers until after you approve the application makes no sense. And I think you know this, but if you approve such a flawed application, this matter will not be resolved from the perspective of many residents. You are under no obligation to approve this flawed application. There were no guarantees when the developers bought the extra properties. They were taking a business risk. Thank you.
Thank you, sir. Next, please hold your, once we adjourn, you all can clap as much as you want. But until then, please let us finish.
I'm number 16. No, I'm number 16. I did ahead of time.
You did ahead of time. That's what I wanted to know. Thank you, that's what I was trying to get at.
If you'll please state your name and address for the record.
Yes, Jody Powell, 5930 Bahama Way North, St. Pete Beach. I'm just having her flip through these real quickly because we only have 3 minutes. The conditional use is section 4.42B. That addresses where they have said that no known historical, architectural, or cultural resources in our area, which is so untrue. Also, opening of Gulf Boulevard to the water has been blocked. They're looking at blocking walls. My family has been here since the 60s. My house personally since 73. I've been here since I'm 11 years old. I've walked these beaches. I know this community probably better than most. My father was head of security at the Don. My brother was security for both the Serrata and Tradewinds. We have family-owned hotels here, and you know, the residents here are able to walk the beaches. They pay taxes up to the dunes, and they don't pay taxes for the entire beach. That belongs to the public. We've walked those beaches for many years and have never had any problems. We use their restaurants. We bring patronage to them during non-seasons. Our character, there's no parking garages. There's no walls blocking the Gulf. We have a unique community and a quality of life. We want beauty, safety, serenity, tranquility of our island. You know, the Don Cesar was built in 1928. The Serrata, I know the Nicholas family in 1962. We go to Harry's Beach Bar. They say free parking. Now we have to pay $25 to park and then use the facility. The Bonaire, 1953. The Dolphin was 1965. The Alden was 1952. Corey Avenue is 6 decades. Historical Museum is 1917. Women's Club, 1922. Don Cesar, 1928. Fishbowl, 1930. Woody's, 1945. Bonaire, 1953. Gale's Restaurant, 1954. And the Polynesian Putt Golf is a historical golfing. We pay taxes. We pay 80%. We're residents. We have a right to walk these beaches, and high tide, we're not going to walk through the water. This is our beach. It's always been our beach for years, and whoever decided on this invisible line across the beach, that's insane. It doesn't belong to them. They don't pay taxes for the entire beach or anything else. And the traffic should be January, February, and March. That's our season.
Thank you.
Thank you for your time.
Thank you.
Thank you.
Do we have any other public comments for tonight? Anyone else who cannot be here on January 10th, please come forward now. Okay, Counselor, you're up for rebuttal.
Most of the testimony is repeat, so we'll do all of that in January. With respect to 4.426, the historical and archaeological, I'm sorry, I'm tired. Historic, you know what I'm talking about. Those are for, that criteria deals with the site, not the area, so just that clarification for the record. Thank you.
Thank you. All right, gentlemen, any other business for tonight?
Do we need to?
I need a motion.
We need to,
Yeah.
and before we close, I want to make sure there wasn't anything else okay, do we have a motion to continue?
I move to continue the hearing until January 10th at 4 p.m.
Do we have a second?
Second.
City Clerk, if you'll please do a roll call.
Commissioner Marone, you said until 4 PM, is that right? I couldn't hear.
Yes,
I said January 10th at 4 PM.
Thank you. Commissioner Grouse?
Yes.
Vice Mayor Grill?
Yes.
Commissioner Brzezowski?
Yes.
Commissioner Marone?
Yes.
Mayor Petrilla?
Yes.
Motion carried.
Great. We are adjourned.